Almighty God, we give thanks to you, the creator of the universe, and humbly beseech you to direct and prosper the deliberations of the members of this house here assembled for the advancement of your glory and the trust and the welfare of the people of Trinidad and Tobago. Grant that peace and happiness, truth and justice may be established among us for all generations. Amen, amen, namaste.
Oath or affirmation, announcements by the Speaker.
Honourable members, I have received communication from the following: the Honourable Penelope Beckles, MP, member for Rima, who has requested leave of absence from today's sitting. The leave which the member seeks is granted. Honourable members, I am to inform that a letter was sent to the Minister of Works and Transport relating to the unanswered question number 4, and a response was received on December 1st, 2020. The response to the question 4 shall be delivered at the next sitting of this House.
Bills brought from the Senate, petitions, papers.
The Minister of Finance.
Madam Speaker, on behalf of the Minister of Finance, I have the honor to lay the following papers. Paper number 1, the audited financial statements of the Rural Development Company of Trinidad and Tobago Limited for the financial year ended September 30th, 2019. Papers 2 and 3, the annual report and audited financial statements of National Enterprises Limited for the financial years ended March 31st, 2019 and 2020. Paper number 4, the annual report of the Regulated Industries Commission for the year ended December 31st, 2014. Madam Speaker, I beg to move that papers 1 to 3 be referred to the Public Accounts Enterprises Committee and paper 4 be referred to the Public Accounts Committee. Thank you, Madam Speaker.
Honourable members, the question is that papers 1 to 3 be referred to the Public Accounts Enterprises Committee and paper number 4 be referred to the Public Accounts Committee. All in favour say aye. Aye. Any against? The ayes have it. Leader of the House.
Thank you very kindly, Madam Speaker. Madam Speaker, I have the honour to lay the following papers. Paper number 5, the ministerial response of the Ministry of National Security to the 14th report of the Joint Select Committee on Social Services and Public Administration on an inquiry into the challenges of prisoner re-entry into society and prisoner reintegration services in Trinidad and Tobago. Paper number 6, the ministerial response of the Ministry of Education to the 17th report of the Joint Select Committee on Social Services and Public Administration on an inquiry into the Ministry of Education's strategies for ensuring continuity in the delivery of education amidst the COVID-19 pandemic. Thank you, Madam Speaker.
Leader of the House.
Thank you, Madam Speaker. Madam Speaker, I have the honor to lay the 12th report of the Elections and Boundaries Commission on the boundaries of the electoral districts in the electoral area of Tobago. Thank you, Madam Speaker.
Reports from committees, Prime Minister's questions, urgent questions.
The member for Point of Appeal.
Thank you, Madam Speaker. To the Minister of Energy and Energy Industries, based on a recent report that there is a desperate attempt, and I quote, a desperate attempt by the government and National Gas Company to save Atlantic LNG Train 1 from shutting down in January 2021. Can the Minister state what specific urgent measures are being undertaken to prevent the mothballing of this plant?
Minister of Energy and Energy Industries.
Very much, Madam Speaker. Madam Speaker, Atlantic Train 1 will not be shutting down in January 2021. Train 1 will continue to operate in 2021 and will be part of wider negotiations which have been taking place among the Atlantic LNG shareholders to form one unitized facility encompassing all 4 trains. The NGC, acting on behalf of the government, is taking the requisite action to maintain the operability of Train 1, pending the finalization of the negotiations of the structure for the unitized facility. Madam Speaker, only last night, the shareholders of Atlantic Train 1 approved the turnaround, commonly known as TAR, in January for the train. This will keep the train in an operations-ready mode for all of 2021 into 2022. I thank you.
Supplemental, member for Point of Appeal.
Thank you, Madam Speaker. Minister, could you then confirm that the shareholders have agreed to supply gas to Train 1, please?
Yes.
The issue of the operability of the plant will depend on the TAR. On the gas supply side, we are currently in negotiation to source a continued supply because this train was normally supplied 100% by BP. BP is saying that they have a shortage and they cannot supply. But BP is not the only supplier of gas in Trinidad. So we are in some sensitive negotiation. And let me make that point with upstreamers to supply gas to Train 1.
Supplemental. Member for Orpooch East.
Speaker. Question number 2 to the Minister of Foreign and CARICOM Affairs. Could the Minister indicate the concerns in the public interest which required an unscheduled and urgent return to New York by the former ambassador to the United Nations?
Minister of Foreign Affairs, Foreign and CARICOM Affairs.
Thank you very much, Madam Speaker. On behalf of the Minister of Foreign and CARICOM Affairs, I am informed that Minister Beckles is currently in New York attending to matters related to her family and wrapping up her affairs after 4 years of service as the permanent representative of Trinidad and Tobago to the United Nations. Thank you, Madam Speaker.
Thank you.
Supplemental.
Would the member, speaking on behalf of the Minister of Foreign Affairs, confirm or not whether this matter had to do with taxpayer paying bills after August 10, 2020 in violation of terms and conditions of work of Her Excellency the Ambassador?
I will allow that as a supplemental question.
Thank you.
Member for Barataria, Sanwan.
Thank you very much, Madam Speaker. To the Minister of Education, in light of the recent statement issued by the Presbyterian School Board concerning the non-payment of salaries and wages of cleaners, could the Minister indicate whether urgent steps are being taken to ensure that cleaners are being paid at the said schools for the months of November and December, respectively?
Minister of Education.
Madam Speaker, this grant to the nominational schools, which is usually paid in the months of October or November, depending on the approval of the national budget, has already been applied for and will shortly be disbursed to the denominational schools.
Supplemental. Member for Coover South.
Thank you, Madam Speaker. Minister, could you inform this House if any other denominational boards within the education system has found itself in such a circumstance also.
I will not allow that as a supplemental question. Member for, 1 minute. Member for Barataria, San Juan. Remember, these are urgent questions. You have the prior right. So when you indicated to let somebody else, I took it that you had no other questions. So for your further guidance, you have the prior right. If you forfeit it, I take it that you don't have any. Member for Barataria, San Juan.
Thank you very much. Can the Minister indicate whether or not these persons who belong to the ancillary staff of the school will be paid before Christmas?
Minister of Education.
Thank you, Madam Speaker. Madam Speaker, as I indicated earlier, the request has already been made, and therefore the Ministry of Education will work with the Ministry of Finance to disburse the funding of this grant as soon as possible.
Member for Cuba South.
Thank you, Madam Speaker. Madam Speaker, to the Minister of Health. In light of the untimely death of Cherise Williams, who collapsed at the Port of Spain General Hospital after undergoing a cesarean section, could the Minister inform this House if an independent committee has been appointed to conduct an investigation into all the circumstances leading to Ms. Williams' tragic passing?
Minister of Health.
Thank you very much, Madam Speaker. First of all, let me express my condolences on behalf of all of us here, our condolences to the family. The Ministry of Health's adverse event policy is automatically engaged in circumstances like this. One, an autopsy has to be done. I could tell this Honourable House an autopsy has in fact been done, and the results will be shared with the family. Before the autopsy, the Northwest Regional RHA provides the Directorate of Women's Health and the CMO with preliminary findings. That has also been done. Based on these findings, the adverse event policy dictates that the final autopsy results be reviewed by the Chief Medical Officer and the Director of Women's Health. Pending the results of this examination, they will determine what steps need to be taken, if any, moving forward. I thank you very much, Madam Speaker.
Member for Cuba South.
Thank you, Minister. Based on all that you have outlined and taking into consideration the ministry's policies and so on, if the family, in keeping with all due process, requests an independent committee to be established, are you willing to go to that length?
Thank you very much, Madam Speaker. Madam Speaker, the establishment of a committee will be guided by the advice given to me as Minister by the Director of Women's Health, the Chief Medical Officer, and of course the family's wishes will be taken into consideration as we do counseling for them, and all of those matters will be considered on the way forward after the report and the autopsy reports have been received. Thank you very much.
Member for Faisal.
Thank you, Minister. Minister, without compromising patient confidentiality or any further investigations that might be necessary, would you be in a position to say whether the opinion has been expressed to you as to whether this death may have been preventable or not preventable?
Minister of Health.
Thank you very much. Madam Speaker, I want to be very careful how I answer that question. This country, and this is not a boast, it is a fact, this country has reached its Sustainable Development Goals for 2030 on achieving certain targets for maternal mortality rates. And we achieved those 12 years before 2030. The issue of maternal mortality is one which was a very tragic one for many years. We have now maintained since 2016 very, very good numbers, but it is still a tragedy for those small numbers that do unfortunately die. What I can tell the member is that since 2016, when I assumed the position of Director of Women's Health, before Dr. Stuart Young came in, Those declines were seen by the middle of 2016. And part of the objective was to ensure that maternal deaths, as far as humanly possible, will only occur due to patient factors or what you consider non-preventable measures. And so far to now, I think we have stuck faithfully to that. I can tell this honorable House that the days when women were dying once a month are long gone, but every death is a tragedy, this one included. But we have maintained the fact that we are very concerned about both preventable deaths and non-preventable, but I can tell you again, all of our maternal deaths, as rare as they are now, are non-preventable due to patient factors. One of the factors is that in the public sector, 40% of our women only turn up for screening at the second and third trimester of their pregnancy, as opposed to the private sector, where it's the opposite. And all of these factors contribute to it. So thank you very much, Madam Speaker, and I thank the member for his question.
Questions on notice? Questions for oral answer?
Leader of the House.
Kindly, Madam Speaker. Madam Speaker, there are 5 questions for oral answer. We'll be answering all 5. There are no questions for written answer.
Member for Barataria, Sanwan.
Question number 11 to the Minister of Health.
Minister of Health.
Permission, I'll answer that.
Minister of Finance.
Thank you very much. The government has advised the general population that to reduce the spread of the COVID-19 virus, in addition to personal protection measures, individuals should wear cloth masks once they are out in the public. To assist in the availability and provision of masks, the National Insurance Property Development Company, NIPDEC, was mandated to procure these items from local manufacturers to distribute to the wider public through non-governmental organizations, members of parliament, and councillors. The details are as follows. The successful bidders were a combination of small, micro, medium-sized sole traders and corporations, medium-sized corporations and large corporations. There are 103 such entities. I shall now read the names of all 103 because that is the question. So, the first successful bidder, Amanda Williams of Innov Fiber. The amount paid, $1,000. Number of masks produced, 100. And I may say that everybody was paid $10, a flat fee of $10 per mask. Second, Janice John, amount paid $1,000, 100 masks. Third, Jennifer Green, $1,000, 100 masks. 4, Veronica Marslin, $1,000, 100 masks. 5, Maria Lewis, $1,200, 120 masks. 6th, Marianne A. Joseph Figuera, $1,500, 150 masks. 7, Damali Philip, $2,000, 200 masks. 8, Ian H.C. Best, $2,000, $200. 9, Edith Kwashi Maitland, $2,100, 210 masks. 10, Wendy Romano Kendall, $2,340, 234 masks. 11, Paula M. Garcia, $2,500, 250 masks. 12, Sherman Hinkson Graham, $2,500, 250 masks. 13, Danielle Agard Williams, $3,000, 300 masks. 14, Gloria Winter, $3,000, 300 masks. 15, Makeda Henry, $3,000, 300 masks. 16, Marlene Weatherhead, $3,000, 300 masks. 17, Nikosi Kendall, $3,000, 300 masks. 18, Yvonne John, $3,000, 300 masks. 19, Nabala Chi, $3,300, 330 masks. 20, Lauren Janet Stout, $3,500, 350 masks. 21, Tessa Sankar, $3,500, 350 masks. 22, J. Angelique Clothing, Janelle Ford, $4,000, $400. 23, Pecklin Abdul Rahman, $4,000, 400 masks. 24, Wendy Rampol, $4,000, 400 masks. 25, Diane Sarup, $4,400, 440 masks. 26, Fleur Gonzalez, $4,500, 450 masks. 27, Belvedere Charles, $4,800, 480 masks. 28, Ansel Billy, $5,000, 500 masks. 29, Avion Thomas, $5,000, 500 masks. 30, Corey Waldron, $5,000, 500 masks. 31, DT Custom Made Creations, Diane Noel, $5,000, 500 masks. 32, Elaine Green Lisam, $5,000, 500 masks. 33, Felicity Husband Patrick, $5,000, 500 masks. 34, Michelle Zion Chazon Ramkisoon, $5,000, 500 masks. 35, Pamela's Furnishings and Tailoring, $5,000, 500 masks. 36, Parbati Pancham Boya, $5,000, 500 masks. 37, Liz Fitzhugh-Wright, Elizabeth Holder, $5,250, 525 masks. 38, Rajkumari Arthur Soju, $5,760, 576 masks. 39, Lita Robinson, $6,000, 600 masks. 40, Richard Harvey Haynes, $6,000, 600 masks. 41, Tricia Lee, $6,300, 630 masks. 42, Crystal Kraku, $6,500, and I hear sort of voce, I'll say 36 again. Parbati Pancham Boya, $5,000, 500 masks. 43, Inskip Lewis, $7,000, 700, I can't help if you're not listening. 43, Inskip Lewis again, $7,000.
Minister of Finance?
Yes, madam.
Regrettably, your time is now spent.
I would wanted to give all the information. I wanted to give it.
Supplemental, Member for Barataria.
Thank you very much, Madam Speaker. Madam Speaker, can the Minister confirm whether or not any of the 113 successful bidders are related to any members of the government?
Minister of Finance.
Thank you very much, Madam Speaker. It is in fact 103, and I have no knowledge of that whatsoever. If the member has a name, tell us. But as far as I know, it is not so. But if you know, tell us.
Member for Orbuchis? No. Member for Barataria.
The Minister confirm to date how many masks have been provided under this tender, please.
Minister of Finance.
Thank you very much, Madam Speaker, for a total cost of $4,364,000, 436,400 masks have been distributed. And I may say, all 14 local government corporations were given masks in this exercise. All 14 corporations. Next supplement.
Member for Barataria.
The headline was right this week. Question number 12 to the Minister of Education.
Minister of Education.
Thank you, Madam Speaker. Madam Speaker, since the closure of schools in March 2020, the Ministry of Education has launched a series of initiatives aimed at ensuring continuity of teaching and learning for the nation's children. With respect to laptops and other devices, 11,295 laptops were allocated to children with special needs, primary and secondary school teachers from July 2020 to present. In addition, the Ministry has begun the procurement process for 20,000 laptops through iGovTT for distribution to students of primary and secondary government and government-assisted schools. Madam Speaker, the Ministry of Education has launched its Adopt a School project as one of the strategies to mitigate the effects of the COVID-19 pandemic on the continuity of education. Under this project, private sector organizations are encouraged to provide educational resources such as devices to schools directly. To date, pledges from over 50 donors have been received and devices are being distributed upon arrival in the country. In total, 21,557 devices have been pledged, including 10,000 from TAT, and 5,520 have been delivered. In total, therefore, the MOE has distributed approximately 17,000 devices in furtherance of online learning and will, in the near future, add 36,000 more to that figure for a grand total of approximately 53,000 devices.
Thank
you very much. Madam Speaker, can the Minister indicate to this Honourable House how many students are still without devices, because the Ministry would need to know how many more devices they would be required to procure?
Minister of Education.
Thank you, Madam Speaker. We are doing another count on that. The first indication was 65,000. However, we have to figure in what was given through the Adopt to School program and also what parents were able to purchase. So we are going to finalize that figure shortly to be published.
Supplemental member for Barrett-Harrisano.
Thank you very much. Out of the 65,000 devices that the Ministry would have identified previously, can you say how many have been supplied or provided to that 65,000 number?
Minister of Education.
Thank you, Madam Speaker. That is exactly what the survey will determine. We know that through the Adopt to School, we have given 5,520. We also would have given some to children with special needs, and we have to figure in as well what was privately donated, also what parents would have purchased for their children privately.
Supplemental member for Barrett-Harrisano.
Can the Minister indicate what criteria is being used for the distribution of the laptops in terms of which schools or which students are being given priority for the distribution of devices?
Minister of Education.
Adopt to School program, the donors are giving directly to the schools of their choice based on their determination, and the principals, they are working directly with the principals to be able to impact those that need it the most.
Member for Miaro.
Very much, Madam Speaker. Question number 26 to the Minister of Public Administration and Digital Transformation.
Minister of Public Administration and Digital Transformation.
Madam Speaker, on behalf of the Minister of Public Administration and Digital Transformation, the Universal Telecommunications Fund referred to in the question is interpreted as the Universal Service Fund, or USF, which was established in July 2004 pursuant to Section 28 of the Telecommunications Act 2001 and is managed and regulated by the Telecommunications Universal Service Regulations 2015, amended in 2019. The fund is administered by the Telecommunications Authority of Trinidad and Tobago, TAT, and it is funded by contributions from the telecommunications operators and providers as delineated in Schedule 2 of the Universal Service Regulations. The regulations and the fund are both aligned to international and regulatory best practice, and the main objective is to address affordability and accessibility gaps as it relates to the provision of information and communication technology services in Trinidad and Tobago. The value of the USF as at September 30th, 2020 is $111,283,500. The list of planned projects for the USF in fiscal 2021 are as follows. 1. TT Wi-Fi, free public mobile Wi-Fi in libraries, hospitals, health centers, transport hubs within Trinidad and Tobago. Free public mobile Wi-Fi in buses, water taxis, and inter-island ferries operating within Trinidad and Tobago. Wi-Fi in designated schools as determined by the Ministry of Education. 2. ICT devices for the Ministry of Education, the supply of 10,000 ICT-enabled tablets to the Ministry of Education for schools' online learning. 3. Universal service infrastructure projects in Trinidad and Tobago, in the areas of Brazo Venado, Lower Atajos, and St. John's Parish. 4, the establishment of community-based ICT access centers in 5 areas within Trinidad and Tobago: Moruga, Fifth Company, Toco, Roxborough, and Lopino. 5, subsidized phones for persons with disabilities. That is to say, the provision of subsidized smartphones to the hearing impaired and visually impaired. Thank you, Madam Speaker.
Supplemental member for Miaro.
Minister, any idea of the timelines for any one of those projects that you've now outlined in fiscal 2021?
Minister of Planning and Development.
Madam Speaker, all of these will be completed within fiscal 2021.
Member for Miaro.
Madam Speaker, question number 27 to the Minister of Housing and Urban Development.
Minister of Housing and Urban Development.
Thank you, Madam Speaker. Madam Speaker, as seems to be the custom with questions being asked by those on the other side, as there are not 4,000 persons from Rio Claro, Miaro, requesting housing. As at November 26, 2020, there are 133,691 clients on the entire database of the Housing Development Corporation, of which there are 731 clients and not 4,000 clients who have applied for housing from the Rio Claro Miaro constituency. So once again, this question is on an incorrect premise. Madam Speaker, the HDC continues to identify suitable and available lands to develop for the provision of housing units to the citizens of this country. When a location is identified, the requisite requests to the Commissioner of State Lands are submitted for approval. These efforts are not limited to any one specific area, but are in fact countrywide. Thank you, Madam Speaker.
Member for Miaro.
Madam Speaker, question number 28 to the Minister of Housing and Urban Development.
Minister of Housing and Urban Development.
Thank you, Madam Speaker. Madam Speaker, the Mora Heights Housing Development consists of 1 wastewater treatment plant and 3 external lift stations. One of these stations recently experienced electrical issues, but that has since been rectified. With respect to the drainage at this housing development, the topography of the land and the geology of the area has resulted in minor soil movement during heavy rainfall. This causes temporary blockage of external drains occasionally. However, the Trinidad and Tobago Housing Development Corporation conducts regular drain cleaning exercises in this community during the rainy season. In 2006, the Water and Sewerage Authority granted approval for the use of septic tanks and soakaways to treat with the domestic wastewater of the El Guanapo housing development. This housing development also experienced soil movement, which causes drain blockages during heavy rainfall. The HDC will continue to monitor and treat with this issue. The wastewater treatment plant at the Coconut Grove housing development is functional and is designed to discharge effluent that meets the pollution levels for the sensitive area classification. Works are ongoing to seal the sewer collection network and raise the sewer catch pits to a higher level to prevent the entry of flood and surface water. The topography of this housing development, as well as its proximity to both the river and the sea, resulted in flooding within the community during heavy rainfall and when the tide is high. However, in 2019, coastline development works were conducted, and as a result, there has not been any major flooding since. The Mora Heights, El Guanapo, and Coconut Grove housing developments have all received final approvals from the Town and Country Planning Division. Thank you, Madam Speaker.
Requests for leave to move the adjournment of the House on definite matters of urgent public importance. Statements by ministers. Personal explanations.
The Minister of National Security.
Thank you very much, Madam Speaker. Madam Speaker, I am making this statement under personal explanations to reiterate what I said in the House previously, as it is accurate, and to protect the public from the attempts by the UNC opposition and certain elements in the media who are attempting to mislead the population. Unfortunately, there's a deliberate attempt to ignore what I really said in this House on the 27th of November 2020 and to weave and create a false and misleading narrative. Madam Speaker, I appreciate the opportunity to provide the following personal explanation. Yesterday's Express newspaper carried a front page and ran a page 3 story which suggested that 2 Damon engineers who arrived in Trinidad in October and November 2020 somehow made what I said in Parliament on Friday, the 27th of November 2020, untrue or misleading. This story and the sensational headline on the front of the newspaper were quickly followed by a television talk show host on TV6 yesterday morning and repeated in a rebroadcast last night with the most spurious false allegations and accusations that I, inter alia, misled this House and the population. Not surprisingly, this was quickly followed by the Member of Parliament for Barataria Sawa issuing a misguided press release yesterday. Madam Speaker, I completely reject any suggestion that on the 27th of November 2020, I misled this House. The facts with respect to what I said about difficulties with Damen, its engineers, and the maintenance of the Trinidad and Tobago Coast Guard Damen vessels are as follows. 1, it must always be appreciated that in dealing with matters of national security, the government must always balance the amount of information that it provides between protecting operational matters associated with national security and providing the public with accountability and transparency. 2, as part of the maintenance of Damen vessels, Damen is required to have at least 1 engineer here present in Trinidad and Tobago. 3, just prior to the closure of Trinidad and Tobago's borders in March 2020, the Damen engineer stationed here in Trinidad and Tobago, due to personal and other concerns related to the effects of the global pandemic, that is COVID-19, departed Trinidad and Tobago. Therefore, there was no Damen engineer here in Trinidad and Tobago from March to October 2020. This is one of the reasons why I said that Damen engineers who were required to come to Trinidad and Tobago to maintain the Damen vessels were delayed in arriving here due to the global pandemic, that is COVID-19. The engineers were not here from March 2020 till late October 2020 due to their concerns associated with COVID-19. These delays in their arrival due to COVID-19 have negatively affected the serviceability of the Coast Guard's damming vessels. 5, the arrival of one engineer in October who was replaced by another in November is not and was not sufficient to carry out the necessary maintenance works to the damming vessels. 6, damming has not shipped the parts for the Coast Guard vessels that are necessary for their repair and maintenance. This too has negatively affected the serviceability of the vessels. And 7, there are other engineers who are required to perform specific works on the vessels who have not come to Trinidad and Tobago because of COVID-19. Madam Speaker, these are the irrefutable facts. Accordingly, Madam Speaker, I reject the suggestions by certain elements in the media and the UNC opposition that have misled the Parliament. That is something that I pride myself I would never intentionally do. As Minister of National Security, I'm conscious that I will come under attack from many different quarters, including those who engage in criminality, corruption, and self-serving agendas. Madam Speaker, I assure the population that I will continue. I assure the
Madam Speaker, 2310, 23-1, please, I want to raise a matter.
You wish to raise a matter before the minister is completed. So you're standing on that standing order, and I overrule. Please continue.
Thank you very much. Exactly on point, making the point, as Minister of National Security, I'm conscious that I will come under attack from many different quarters, including those who engage in criminality, corruption, and self-serving agendas. Madam Speaker, through you, I assure the population of Trinidad and Tobago that I will continue to carry out my duties as I've been doing without fear or favor, malice or ill will. These facts support what I have said, and I stand by what I say now and what I have said previously. Thank you very much, Madam Speaker.
And just for the information of the House, there's no standing orders 2310. Please come.
Introduction of bills. The Public Procurement and Disposal of Public Property Amendment Bill 2020 in the name of the Minister of Finance.
The Minister of Finance.
Madam Speaker. Yes, I am not faint of heart. Madam Speaker, in accordance with Standing Order 64.1b, I beg to move that the next stage of the Public Procurement and Disposal of Public Property Amendment Bill 2020 be taken later in the proceedings.
Honourable members, the question is that the next stage of the Public Procurement and Disposal of Public Property Amendment Bill 2020 be taken later in the proceedings. All in favour say aye. Aye. Any against? The ayes have it.
The Miscellaneous Provisions 2019 Novel Coronavirus 2019 NCOV number 2 Bill 2020 in the name of the Attorney General.
The Attorney General.
In accordance with Standing Order 64.1b, I beg to move that the next stage of the Miscellaneous Provisions 2019 Novel Coronavirus 2019 NCOV number 2 Bill 2020 be taken later in the proceedings.
Honourable members, the question is that the next stage of the Miscellaneous Provisions 2019 Novel Coronavirus 2019 NCOV number 2 Bill 2020 be taken later in the proceedings. All in favour say aye.
Aye.
Any against? The ayes have it.
The Miscellaneous Provisions FATF Compliance Bill 2020 in the name of the Attorney General.
The Attorney General.
Madam Speaker, in accordance with Standing Order 64.1b, I beg to move that the next stage of the Miscellaneous Provisions FATF Compliance Bill 2020 be taken later in the proceedings.
Honourable members, the question is that the next stage of the Miscellaneous Provisions FATF Compliance Bill 2020 be taken later in the proceedings. All in favor say aye. Any against? The ayes have it.
The miscellaneous amendments, powers of statutory authorities and matters related to certain boards, Bill 2020, in the name of the Minister of Finance.
The Minister of Finance.
Madam Speaker, in accordance with Standing Order 64(1)B, I beg to move that the next stage of the miscellaneous amendments, powers of statutory authorities, and matters related to certain boards, Bill 2020, be taken later in the proceedings.
Honourable members, the question is that the next stage of the miscellaneous amendments, powers of statutory authorities, and matters related to certain boards, Bill 2020, be taken later in the proceedings. All in favour say aye. Aye. Any against? The ayes have it.
The miscellaneous provisions, Administration of Justice Bill 2020, in the name of the Attorney General.
Attorney General.
Madam Speaker, in accordance with Standing Order 64(1)B, I beg to move that the next stage of the miscellaneous provisions, Administration of Justice Bill 2020, be taken later in the proceedings.
Honourable members, the question is that the next stage of the miscellaneous provisions, Administration of Justice Bill 2020, be taken later in the proceedings. All in favour say aye. Aye. Any against? The ayes have it.
The miscellaneous provisions, Special Reserve Police and Police Complaints Authority Bill 2020, in the name of the Attorney General. The Finance Bill 2020, in the name of the Minister of Finance. Motions relating to the business or sittings of the House and moved by a Minister.
Member for Barataria Sanwan.
Thank you very much, Madam Speaker. I hereby seek your leave in accordance with Standing Order 32(2) to raise a matter directly concerning the privileges of the House of Representatives. During the debate on the private member's motion piloted by myself on Friday, 27 November 2020, the member for Port of Spain North, St. Anne's West, boldly represented to the House and made the following statement. The Daman vessels that may be down, it is because of COVID, that the shipyards in Daman in Holland, and I'm going to call in the ambassador of the Netherlands next week and meet with him, because the Daman persons do not want to fly to this side of the world to do what needs to be done with some of the vessels. It was subsequently discovered in the Trinidad Express dated Thursday, 3rd December 2020, an article titled The Daman Truth by Anna Ramdas, and I quote from an email reference therein and sent from the Embassy of the Kingdom of the Netherlands to Trinidad and Tobago. To our knowledge, a Daman shipyard engineer arrived on October 19, 2020 in Trinidad and Tobago to perform maintenance tasks. He was replaced by another engineer from Netherlands on November 20th, 2020. The matter being brought is grounded on the fact that a member for Port of Spain North, St. Anne's West deliberately misled this honourable House and by extension, the viewing citizens of the country, as he knew or ought to have known the statement which he made was false and incorrect. According to David McGee's Parliamentary Practice in New Zealand 3rd edition, it requires 3 elements to be established: that a member is in contempt by reason of a statement that he or she has made in the House. 1, this statement must in fact have been misleading. 2, it must be established that a member making the statement knew or ought to have known at the time that the statement was made it was incorrect. And in making the statement, the member must have intended to deliberately mislead the House. It is submitted that the statement was misleading. At the time, the minister knew that the statement was incorrect, and the statement could have been made to deliberately mislead the House for the following reasons. 1. The member, as part of his portfolio, has responsibility for the Trinidad and Tobago Coast Guard. The member knew or ought to have known of the contractual arrangements and/or other arrangements between Damen Shipyard, Netherlands, and Trinidad and Tobago. 3. He ought to know or he knew or ought to have known when the engineers or persons from Netherlands responsible for repairing the TT Damen vessels would arrive in Trinidad and Tobago. 4. The member is the only person who has the responsibility to grant exemptions to persons to enter Trinidad and Tobago, as the borders are currently closed and have been closed since March 2020. The member knew or ought to have known that those engineers were in the country on October 19th and November 20th, 2020, as he is responsible for granting them an exemption and would have granted the exemptions to the engineers to enter Trinidad and Tobago. The fact that the member has personal knowledge of the facts and made a statement, there is a ready presumption of an intention to mislead the House. Based on the foregoing, the member has deliberately made a misleading statement. He has committed a contempt of the Parliament and abused his privilege as a member of this esteemed House. As such, I submit that the Honourable Member has committed a breach of privilege of the House. In this regard, Honourable Speaker, I refer this matter for your urgent attention and determination.
Honourable members, I am prepared to rule on this question of privilege raised by the member for Barataria San Juan. The member alleges that the member for Port of Spain North, St. Anne's West, and the Minister of National Security deliberately misled this House, and in support of that allegation, cited the minister's statements made on Friday, the 27th November 2020, during the debate on a private member's motion. As accurately identified by the member for Barataria San Juan, the first condition to establish a prima facie case when it is alleged that a member or minister is in contempt on the grounds of misleading the House is that the statement must in fact have been misleading. The Minister of National Security, earlier in today's proceedings, has explained his statements, which he made and which led to this matter of privilege being raised. It is also significant that the Minister sought to make this clarification at the earliest opportunity. I therefore rule that this matter referred to me by the member for Barataria San Juan does not constitute a prima facie case of breach of privilege, warranting its referral to the Committee of Privileges, and I so rule.
Public business, government business, bills, second reading.
The Attorney General.
Madam Speaker, I beg to move that a bill entitled An Act to Amend the Cinematographic Act, Chapter 2010, the Registration of Clubs Act, Chapter 2101, the Theatres and Dance Halls Act, Chapter 2103, the Family Law, Guardianship of Minors, Domicile and Maintenance Act, Chapter 4608, the Motor Vehicles and Road Traffic Act, Chapter 4850, the Moneylenders Act, Chapter 8404, the Pawnbrokers Act, Chapter 8405, the Licensing of Dealers, Precious Metals and Stones Act, Chapter 8406, and the Old Metals and Marine Stores Act, Chapter 8407, in response to the 2019 novel coronavirus, 2019 nCoV, and for related matters, be now read a second time. Madam Speaker, the matter before us is really a very simple matter. The bill proposes in 11 clauses, including the short title and commencement, an adjustment to timeframes and positions introduced firstly by previous legislation contained in Act number 4 of 2020. Act number 4 of 2020, which was assented to on the 20th of March 2020, was the first round of legislation that we brought to the Parliament to adjust timeframes and structures prevailing in the laws of Trinidad and Tobago, which could not be complied with on account of the restrictions which were put into place under the Public Health Ordinance regulations. As you are aware, Madam Speaker, the novel coronavirus was declared a dangerous infectious disease by Her Excellency the President. Pursuant to that, the provisions of the Public Health Ordinance took effect, and regulations were put into place by the Honourable Prime Minister and the Cabinet, and we saw a series of application of restrictions into our movement and working conditions, effectively causing the public service to have its doors closed in respect of regular matters such as the obtaining of permits, licenses, and permissions under several laws that are part of the long title of this particular bill. Madam Speaker, it is noteworthy that we were allowed to engage in this form of restriction without the exercise of a state of emergency and the suspension of constitutional rights, nor by the utilization of the Disaster Measures Act, which would have involved a declaration of a state of emergency under the disaster measures provisions in Trinidad and Tobago. That application of the Public Health Ordinance worked to Trinidad and Tobago's sincere benefit, and in fact we saw ourselves for a period of time recognized as #1 in the world by international rating agencies, including the Oxford University, for our management of the COVID pandemic. It is now par for the course that we stand many regulations later. In fact, Madam Speaker, the last regulation was that of Legal Notice number 365 on the 22nd of November 2020, by which we implemented the 32nd regulation issued under the Public Health Ordinance. In the course of exercise of those regulations, Madam Speaker, the public service came back slowly into operation. The operationalization of electronic admission, electronic filing, and appointment systems were applied, but regrettably, the appointment systems in the balance between lives and livelihoods have found themselves in complication. That has been exacerbated by the closure of the courts to certain matters where licenses are heard and extensions are granted. Indeed, Madam Speaker, if you look to the bill before us, you will note that Clause 3, which deals with the Cinematographic Act, Clause 4, which deals with the Registration of Clubs Act, Clause 5, which deals with the Theatres and Dancehall Act, Clause 7, which deals with the Motor Vehicle and Road Traffic Act, Clause 8, which deals with the Money Lenders Act, Clause 9, which deals with the Pawnbrokers Act, 10 with the licensing of precious metals and stones, and 11 with old metal marine stores. Those several clauses take us to two places. The first occasion, as it relates to clauses 3, 4, 5, 7, 8, 9, 10, and 11, we are squarely within the licensing committee of the Magistrates' Court. All of those laws referred to in those clauses require the licensing committee to sit and hear extensions of time for the various types of licenses granted. As it relates to Clause 6, which deals with the family law guardianship of minors, I propose to treat with that in a separate measure. And as it relates to the second limb that I referred to, which is under Clause 7, the Motor Vehicle and Road Traffic Act refers to the place where the licensing division of the Motor Vehicle and Road Traffic Authority has the responsibility to renew permits for driver's licenses, for transfers, etc., all of the provisions contained under the legislation. Madam Speaker, notwithstanding the opening of the virtual courts and also the appointment systems at the licensing division, there has been a delay in the full accessibility. And that delay, Madam Speaker, has, even though it has been worked out in the best way, it is something which causes risk and jeopardy to the citizens of Trinidad and Tobago and which requires amendment. We are effectively proposing, Madam Speaker, that the mischief that has been caused by the lack of full operation due to COVID conditions and restrictions be cured by extending the period of time originally cast in Act Number 4 of 2020 in the period 31st July to 31st August, when we thought that there would have been a validity surely cured by then with the full return to systems. We propose now to extend the validity of all of the various laws referred to in this bill to the period 31st December 2020, but we specifically allow for the use of orders under the hand of respective ministers to extend that time to a further period under the hand of the relevant authority. That is, we use subsidiary legislation to extend the time frame. I want to point out with respect to the Motor Vehicle and Road Traffic Act that even though this seems to be a very simple amendment to extend the licensing time frame and the validity, therefore, this runs to the root of lawfulness in Trinidad and Tobago. If you are driving without a valid driver's permit and you cannot extend it, then you are going to be without an active cover for insurance because you would have vitiated your insurance coverage under the laws of Trinidad and Tobago. And as simple as that sounds, it attacks, therefore, the ability of persons who are injured, particularly those who bring death claims against persons who have been involved in motor vehicle and road traffic accidents. God forbid that is a feature of regular life. But the reality is that the simple amendment of the time frame here has significant consequences to the people of Trinidad and Tobago. Therefore, Madam Speaker, it is necessary for us, in the context of legislative capacity under Section 53 of the Constitution, to cause these amendments today to the Motor Vehicle and Road Traffic Act as it relates to one aspect, and then to the several pieces of law that fall under the licensing committee, as have been referred to earlier. But equally, Madam Speaker, there is another point which I had reserved comment on and which I propose to proceed with now. Clause 6 of the bill deals with the Family Law, Guardianship of Minors, Domicile and Maintenance Act. And that, Madam Speaker, is the legislation by which the right of the child is enforced. You see, children have rights of access to their parents. Not only do parents have rights of access to their children, but the law takes a very serious approach as it relates to the maintenance of children. The Family Law, Guardianship of Minors, Domicile and Maintenance Act, Chapter 4608, which is the parent law that we seek to amend, in Section 27, we have the provision that if the payment of a maintenance order or the maintenance in respect of a child, 1 month in arrears, we provide the power for distress. That is the levying and taking of goods and selling of goods owned by someone who is made to pay maintenance by way of court order. The court has traditionally adopted a very sacred position that a child has the right to be maintained by his or her parents without regard to gender. And unfortunately, this law is so serious that there is very little room in the COVID pandemic to accept the reality that we're in right now. And that reality is that there are some people who, through no fault of their own, have the disadvantage of being put under a warrant for arrest immediately, let alone distress and exercise upon their goods. Because, Madam Speaker, even though the court has the ability to exculpate in part someone who has not paid maintenance, where there's a demonstration that it wasn't a willful position, There is right now in Trinidad and Tobago the exposure to a person under a maintenance order being exposed to the mandatory warrant, where the police are out to arrest you. You are then brought before a magistrate or justice of the peace for bail considerations. You may be put into detention in circumstances where you may have lost your job due to the COVID pandemic. Things may be hard. We propose today, Madam Speaker, to cause a softening of the law under a sunset period. Now, one is always extremely cautious to exercise the consideration of a sunset period, particularly under the leadership of the member for Siparia, because one never knows when you may get that chance to extend the law. But, Madam Speaker, it is clear, as we see in Clause 6, as we propose the amendment, we propose that instead of an automatic arrest warrant, we allow the court the discretion to exercise a summons to bring the defaulting maintenance payer before the court, and that route of the summons have an expiry specifically set out at subsection 1A in Clause 6. Subsection 1A would cease to apply on the 31st of March 2021. It should be not 2020. We propose to amend that in the bill as it's probably been circulated, or such later date as the Attorney General may by order specify. The Attorney General is simply the functionary for the issuance of matters coming under the connection between the judiciary referring its matters to the Attorney General. It is no different from the rules of the Supreme Court in terms of how they are laid, etc., by the Attorney General. Madam Speaker, permit me to ask now for members to note that we received a submission coming from the Registrar General that there is a matter exactly associated with the concept of this bill that we propose to add into the amendment stage within the context of this bill, and that is a proposal to amend the Bills of Sales Act. In Act number 4 of 2020, where we amended the exact suite of legislation now being amended, we had an amendment to the Bills of Sales Act. The Bills of Sales Act, Madam Speaker, is proposed at the committee stage to be amended by simply changing the date exactly in keeping with what we're doing with the feel of this bill as it relates to all of the clauses in this bill which come under the licensing committee. Madam Speaker, in that proposal for amendment, we'd be seeking to add the Bills of Sales Act because it falls within the parameters for the considerations of this Parliament, and in it simply to extend the validity period, again, from the July-August position which we had in Act number 4 of 2020, quite simply to the same time formula that we're using in this bill, which is to take it to December or such further date as may be included by way of extension of the order. So, Madam Speaker, in summary and in conclusion, I say the matters before us are quite simple and straightforward. They are, of course, of importance insofar as there are significant privileges that are associated with the extension of rights and licenses and permits. The inclusion at committee stage of the Bills of Sales Act fits within the parameters that we ask the Honourable Parliament to consider at committee stage. And in those circumstances, Madam Speaker, I beg to move.
Honourable members, I shall now propose the question for debate. The question is that the Miscellaneous Provisions 2019 Novel Coronavirus 2019 N-CoV number 2 Bill 2020 be now read a second time. Member for Couva South.
Thank you, Madam Speaker. As I joined this debate to the miscellaneous provisions of the 2019 novel coronavirus 2019 NCOV1 number 2 Bill 2020. And I want to make it very clear from the outset, Madam Speaker, that we on this side, we are very committed to ensure that the health, safety, and security of the people of Trinidad and Tobago is given the #1 priority in this very uncertain and unpredictable period in our country. And whilst, Madam Speaker, I cannot recall the exact statistics that prevailed at the time when this issue was dealt with earlier on this year, but the reality of where we are today in terms of Trinidad and Tobago having approximately 6,725 positive cases, and the fact that 37,155 persons have been tested, and there are approximately 743 active cases, and from a global point of view, 65,513,016 positive cases, and a global death toll of approximately 1,511,016 persons. It is of paramount importance that we continue to treat with issues that can address the problems that have occurred in our society in meeting and treating with the lives of our citizens on a daily basis. And as we implement or seek to amend or continue to implement laws to protect the citizens of our country, we also have to ensure that citizens do not run afoul of the law. And Madam Speaker, the Attorney General indicated in his piloting that the matter before us is very simple in terms of adjustment to time frames, and in his presentation, he indicated that this has become necessary because of the adjustments as it relates to the operations of the public service and in relation to the application of the public health ordinance, and this was achieved without the implementation of a state of emergency and the suppression of rights of persons and so on. But it is important too that from an opposition's point of view, that we continue to raise some pertinent issues or ask questions that we feel will be of benefit not only from inside of this House, but outside of this House for the benefit of the people of Trinidad and Tobago. And the Attorney General said that Trinidad and Tobago historically was recognized as being #1 in the world by international rating agencies and so on. But based on how we have handled this with the passage of time, I would want to ask the Attorney General what would be the rating from the international agencies we as a country would receive now based on how the events have unfolded in Trinidad and Tobago. But more importantly, Madam Speaker, he indicated that this seeks to address amendments to bills that he has presented from the point of view of 11 clauses as it relates to different pieces of legislation from the point of view of the Cinematography Act, the Registration of Clubs Act, Theatres and Dance Hall Act, the Family Law in relation to guardianship of minors, Domicile and Maintenance Act, the Children's Authority Act, the Motor Vehicles and Road Traffic Act, the Moneylenders Act, the Pawnbrokers Act, the Licensing of Dealers Act, in response, as I said, to the 2019 novel coronavirus. And Madam Speaker, as I said, we on this side will always be part of a legislative framework that will seek to bring what we would call an ease in terms of inconvenience and suffering, and try to do what is responsible on the part of the opposition to make sure that persons can continue to operate not only from an individual point of view, but from a business point of view in relation to the economy of this country. And in relation to clauses 1, 2, 3, and 4, and 5, Madam Speaker, this seems to be very straightforward. But as we go into clauses 6 and clause 7, it is important that I seize the opportunity to raise some of the issues as it relates, especially as it relates to clause 7, in relation to the intended amendment as it relates to the Motor Vehicles and Road Traffic Act, Chapter 48.5, as it relates to Section 11, the intended amendment in relation to Section 11 by repealing subsection 7 and substituting new subsection, which would provide that notwithstanding any provision to the contrary contained in the Act and subject to the subsection 8, any transfer of registration required to be completed on or before the 31st of August 2020 may be completed on or before the 31st of December 2020, and the new subsection would empower the minister to extend these dates specified in subsection 7 by order. Madam Speaker, as it relates to this particular amendment, I want to draw the Attorney General's sight of an article that was in the Trinidad Express as it relates to the 4th of August 2020, when scores were made to wait outside of the licensing authority in Caroni after failing to follow the COVID-19 guidelines. And in addition to that, the long lines and the commitment on the part of the government of Trinidad and Tobago to deal with the issues as it relates to Madam Speaker, licensing, the application for driver's permits, the application for provisional permits, regulation, examination, driving tests, loss permits, driving permit renewal, endorsements, inspection, transfers, reclassifications, and so on, the notification of change, taxi badges, and school bus services. Madam Speaker, there was a commitment on the part of the Minister of Transport, who, taking into consideration the issues that were experienced by members of the public, indicated that the Ministry of Works and Transport would respond to the issues through the launch of a mobile unit service. And up till today, if I can recollect, I cannot fathom what is the delay based on the commitment that was given by the Minister of Works and Transport to have this particular launch bear fruition as it relates to dealing with the real issues and adding to a further sense of comfort to citizens in the rural communities of Trinidad and Tobago. And, Madam Speaker, in addition to that particular issue, I would want to ask the Attorney General if he can provide to us whether this amendment is an attempt to hoodwink the population or fool the population into thinking that they are dealing with the massive backlog and complaints which have emerged out of the licensing authority due to the bungling of the appointment system that they promised from an online point of view as it relates to they told the population to go on to the portal licensing appointment.mowt.gov.tt, and I have continued to interact with persons near the Motor Vehicles Authority, the main office in Caroni, because I live within that particular area, and I drive in that particular area also, Madam Speaker. And I'm always faced with long lines of motor vehicles and persons outside of that particular government institution. And anytime people see me, they will always seek to engage and complain in a very bitter manner, in a very real manner, of the frustration that they have to encounter at that particular facility, taking into consideration also, based on the social distancing, the COVID regulation, and so on, Madam Speaker. At the end of the day, I think there's only 2/10 outside of the licensing authority, which continues to add to a further level of frustration, Madam Speaker. And Madam Speaker, we would like also to know from the Attorney General in relation to the commitment given from the Minister of Finance, not the Minister of Finance, sorry, but the Minister of Works and Transport via his media release, or the Ministry's media release of Friday the 2nd of October 2020, as it relates to the Ministry of Works and Transport, the motor vehicle extension of time for the validity of certain documents, Order 2020. And Madam Speaker, on the 14th of September 2020, the Minister extended and pointed in the direction, as I said, that any of the driver's permit, taxi badges, or taxi driver licensing certificates and so on, or other documents issued by the licensing division, which would expire on or before the 31st of August 2020, to be deemed valid until the 31st of December 2020. But we have also been told, which we have no problem with in principle, that from a ministerial point of view, the ministerial order will be used to deal with the issue of extending all the necessary documentation that is needed from a driving point of view. That is all fine in relation to what is being contemplated. But at the end of the day, I think that the issues that needs to be addressed at the licensing division is the one from an IT point of view, because people go on the portal from time to time, they cannot access it, it crashes, it is inaccessible, and this continues to add to the frustration of all and sundry in our country. As it relates to the social distancing point of view and the COVID-19 guidelines and so on, I also think it is incumbent upon the Minister of Works to address the issue of the provision of a real enabling environment, within not only the main motor vehicle licensing authority in Caroni, but also in the respective offices throughout the length and breadth of Trinidad and Tobago, if the government really wants persons to buy in to what is being contemplated today as it relates to these amendments which have been tabled by the Attorney General. And in addition to that Madam Speaker, we would like the Attorney General to clarify whether drivers will be penalized, because within recent times, as it relates to the operations of the licensing authority, I have been privy, and I'm sure that members in this House and persons outside of this House have been privy to the implementation of what has been stated, and it is in the public domain, that there will be a penalty as it relates for late fees and renewals. And in fact, it has been indicated that for less than 6 months renewal from a driver's permit point of view, persons would have to be subjected to a penalty of $500 per month. For more than 6 months and less than 3 years, $875 per month. More than 3 years, but less than 5 years, $1,750. And for more than 5 years, the applicant will be made to rescind the regulation and the driving test. So I hope that the Attorney General, because when the Attorney General dealt with Clause 6 of the bill, he indicated that the pandemic has impacted upon a person's ability to earn in Trinidad and Tobago. It has impacted upon persons' ability to deal with the whole question of maintenance and so on. And he focused on those who would have lost their jobs and so on. And I would want, in the clarification that I'm seeking on behalf of those on this side, and in addition to that, the wider citizenry of this country, and especially those persons who would have lost their jobs and are struggling from a COVID-19 pandemic point of view to make ends meet on a day-to-day basis, for us to be told in a very precise manner what is the government's position in relation to the issues that I've just referred to for the benefit of those. Because people are fearful that they will be subjected to these penalties, and I think we need to bring clarity to this particular issue. As it relates to the Clause 6 of the bill and its intention to provide for persons to be brought to court on warrant instead of arrest during this period of pandemic, and the provision relative to a person coming before the court by way of a summons to answer for the breach of order to pay would expire on the 31st of March 2020, and I think that you clarified, Attorney General, that this would go on to March of 2021. In principle, again, there is nothing wrong or nothing objectionable to this, because we have all realized, and I'm sure on both sides of the House, that sometimes persons find themselves in relation to paying maintenance costs and maintenance order, find themselves on the wrong side of the law. Or in instances where they are subjected to police abuse and so on, because for reasons unknown or known to us, because I'm sure we all have experiences as members of Parliament in connecting with the ground and our respective constituents from time to time, that sometimes a person breaches a maintenance order and he or she finds himself, well, in most instances, males, they find themselves being arrested or by police officers in their respective jurisdictions and so on. They are taken into custody on a Friday, and they find themselves going before the courts on a Monday. And we have had instances in this very country that very unfortunate, but I think that I could clearly recollect that in one particular instance, a person committed suicide in a police station based on the fact that he was taken into custody via what we would call arrest for breach of a maintenance order. And I'm sure that from that angle, in terms of providing a soft landing, providing what we would call a conscionable position, we would want to support this in relation to what is intended here this afternoon. But like all things being equal, Attorney General, through the Speaker, we would want to ensure that while we grant the extension of the guidelines or support the extension of the deadlines and so on, from a time frame point of view, we will also want the government to address the real issues that are affecting the persons in our society when they go to the courts, when they go to the licensing office, when they seek to interact with the licensing committees and so on. We have been hearing of stories where persons, especially from time to time, would have problems in meeting and treating with court officials, justice of the peace and so on, and more importantly, members of the licensing committee. So if this is the real intention of the government of Trinidad and Tobago, to ease the frustration, we on this side, in principle, have no problem in giving that support for the extension from a date point of view. But at the end of the day, as persons continue to interact with government institutions, I will urge not only the Attorney General, but I will urge all line ministers who have the responsibilities, the respective responsibilities, to drill down and meet with their permanent secretaries, to meet with their respective heads of divisions and so on, to drill down, to ensure that the pain and suffering that ordinary persons are experiencing in the society, from the over 100,000 persons who would have lost their jobs, we really provide a well-intentioned soft landing so that they could continue with their respective lives. Madam Speaker, I thank you.
Attorney General.
Madam Speaker, I thank you for the opportunity to bring conclusion to this particular debate. I thank my colleague, the member for Couva South, for putting some very material observations onto the record. Certainly, the law must always be applied, and we must always have regard for the people in this structure. Laws are therefore always in the context of living, breathing, and doing so for the benefit of the people of Trinidad and Tobago. It's important, Madam Speaker, just to make mention of a few of the concerns raised by my learned colleague, that today's exercise is squarely intended for a benefit to the people of Trinidad and Tobago. The world itself has been wrestling with the issue of when will the pandemic end? And whilst we had high hopes that we could certainly have done that in a faster space, obviously the virology that stands behind the very battle that we look at and face down every day is the determinant factor. We're in very new waters. We're watching the world deal with the rapidity of approvals for vaccination. What normally takes 10 and 15 years to be approved is being done in 10 months. But, Madam Speaker, my colleague raised the issue of the balancing of interests in Trinidad and Tobago. And in particular, he raised the concern to deal with no issues, clauses 1, 2, 3, 4, 5, but having issues with respect to clauses 6 and 7. And permit me, therefore, to address with the required detail in response, the matters that my colleague raised. First of all, with respect to the issues at the motor vehicle and road traffic arena, it is important to note that yes, there have been problems with the attendance and appointment schedule. That's a fact. That's not unique. We've had some instances of that at the Registrar General's office in respect of access to the registry for searches, etc. But, Madam Speaker, what is important is to reject the submission that this is perhaps a hoodwinking of the people, as my learned colleague put it, over this issue of appointments. No, Madam Speaker. This is really to encourage people to have some degree of hope. Because, Madam Speaker, my friend, the member for Couva South, has been in this Parliament for a very long time. And my friend, the member for Couva South, had the responsibility sitting as a minister in the Ministry of Finance. And I wonder where his passion was to the concept of digitization. And let me say why I asked that question. Madam Speaker, it is this government that introduced the property and business real estate solution at the Registrar General to allow us to have online searches and filing in electronic fashion. It is this government that took the amendments to the Motor Vehicle and Road Traffic Act, which we seek to amend today in this bill, by bringing it into the modern technological parameters of this country. It is our amendments to the law, championed by my colleague now sitting with us in this House, Mr. Marvin Gonzalez, as he was then, now Member of Parliament, sitting as the legal advisor in the Ministry of Works and Transport. He can bear testimony and tale to the hard work that we did in causing 3 simple amendments to the Motor Vehicle and Road Traffic Act. Clause 20A, Clause 20B, Clause 20C. And there fell the long, anguishing journey to birth a motor vehicle authority by making the conditionality on the roads a demerit point system in a civil law context as opposed to a criminal offense. Madam Speaker, do you know that the Office of the Attorney General and Ministry of Legal Affairs is the first government ministry in the entire Caribbean to have the ability to conduct online payments? Do you know, Madam Speaker, that that has been taken on board by the Ministry of Works and Transport and Motor Vehicle Licensing Division? And I wonder where my colleague Couva South's passion was when he sat with the opportunity at the turn of the wheel in the Ministry of Finance to drive digitization, to digitize millions of records, to allow an appointment system because you've actually done the work. You see, Madam Speaker, it's one thing to stand up and give us great advice, but when you had your turn at the wheel, what did you produce? We can stand confidently now in the context of Clause 6 and say that we have digitized all of the records at the Ministry of Works and Transport, all of the motor vehicle and licensing divisions. We have introduced road checking via spot speed camera, plate recognition, facial recognition, millions of documents registered and digitized at the Ministry of the Attorney General and Legal Affairs, now Office of the Attorney General and Legal Affairs. And Madam Speaker, that is what you call delivering reality to the people of Trinidad and Tobago. And that reality, Madam Speaker, is underscored by the amendments that we made to the judiciary by removing 104,000 motor vehicle and road traffic matters from the courts, by turning on the U-turn system on May 26, 2020, as Senator Rohan Sinanan did, Madam Speaker, by making the amendments to make sure that people had no fines and no penalties for the non-payment of their motor vehicle and road traffic tickets, legislatively giving them the relief from that, as we legislatively today, in Clauses 6 in particular, give everyone a validation. You see, when the bill gives you a validation of licensing period, there is no need to consider the concept of penalties for late payments, because you're not late, you're valid. And that, whilst it sounds quite simple, apparently is a little bit hard to grasp. I say that in no sense intending to be pejorative to my colleague, the member for Couva South. But Madam Speaker, the point made by my learned colleague that people are being arrested and the horrific story of someone committing suicide in a police station being arrested in the analysis we looked at in Clause 7 for maintenance, payment, etc. Madam Speaker, that was certainly something that took a hold of us all. But Madam Speaker, the hope and deliverance and reality came by the introduction of the amendments to the Family and Children Division Bill in 2016 and the Criminal Division Bill in 2018, where we introduced electronic appearances. Let me repeat that. This government introduced electronic appearances, Madam Speaker, and that has allowed us to have nearly 20,000 virtual appearances. Madam Speaker, I can tell you as Attorney General that we appear in court on a Sunday night during the night. Friday night, Sunday night, Saturday night. Gone are the days where you have to go and sleep in a cell on a Friday night and find yourself on a Monday morning because you now appear virtually. Madam Speaker, up to nearly 20,000 appearances. Don't take my word for it. Read the annual report of the Honourable Chief Justice delivered this year. So, Madam Speaker, whilst I appreciate the advocacy that my colleague, the member for Couva South, brought today on behalf of persons who may have asked him to raise certain matters, I'd encourage my colleague, the honourable member, to recall the work that this Parliament has been doing and the work that the last Parliament did, because my colleague was there, and therefore he is full witness to the eventualities of us being able to deliver to the people results for the benefit of Trinidad and Tobago. Madam Speaker, with respect to the amendments proposed, and in respect of which my colleague has indicated no objection, I understand, that amendment, as we dealt with in the piloting of this bill, is simply with respect to the date for the validity of the mortgage bills of sales. If it is not undertaken, we will find the difficulty with thousands of instruments and therefore thousands of security items being invalid through no fault of persons. It is a very important opportunity for us to make good use of parliamentary time within the parameters of what is permitted in law, and therefore, Madam Speaker, I look forward to the acceptance of that amendment, which is being circulated now at committee stage. Madam Speaker, I understand that my colleague, the Minister of Finance, is anxious to begin the next debate, so that I now beg to move.
Honourable members, the question is that the Miscellaneous Provisions 2019 Novel Coronavirus 2019 NCOV No. 2 Bill 2020 be now read a second time. All in favour say aye. Aye. Any against? The ayes have it.
A bill entitled, "This bill contains 11 clauses and seeks to amend the Cinematograph Act, Chapter 2010, the Registration of Clubs Act, Chapter 2101, the Theatres and Dance Halls Act, Chapter 2103, the Family Law Guardianship of Minors, Domicile and Maintenance Act, Chapter 4608, the Motor Vehicles and Road Traffic Act, Chapter 4850, the Moneylenders Act, Chapter 8404, the Pawnbrokers Act, Chapter 8405, the Licensing of Dealers, Precious Metals and Stones Act, Chapter 8406, and the Old Metal and Marine Stores Act, Chapter 8407, in response to the 2019 novel coronavirus 2019 NCOV and for related matters.
Attorney General.
Speaker, Madam Speaker, in accordance with Standing Order 68.1, I beg to move that the Miscellaneous Provisions 2019 Novel Coronas 2019 NCOV No. 2 Bill 2020 be committed to the Committee of the Whole.
Honourable members, the question is that the Miscellaneous Provisions 2019 Novel Coronavirus 2019 NCOV No. 2 Bill 2020 be committed to the Committee of the Whole. All in favour say aye. Aye. Any against? The ayes have it. This House will now go into the Committee of the Whole to consider the bill clause by clause. Has the amendment been circulated? Where have you all got the amendment? Yes, just close one.
Clause 1.
The question. The question is that clause 1 stand part of the bill. The question is that clause 1 now stand part of the bill. Those in favor say aye. Aye. Those against say no. Members,
It's been extremely disgusting. And you may not be hearing it, but he's excessively disgusting.
all right, so members, we have a lot of work to do. And I believe from something that was said a little earlier that we're all excited about other things to come. So let's focus on what we're doing with all due respect to each other and to the people of Trinidad and Tobago, and let's get our work done. The question is that clause 1 stand part of the bill. The question is that clause 1 now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clause 1 now stands part of the bill.
Clause 2.
The question is that clause 2 stand part of the bill. Attorney General.
Madam Chair, thank you. There is what some may refer to as a piddling amendment, but it is nonetheless to keep language consistent with previous acts, and therefore the piddling amendment put before us here is the refashioning of clause 2 as circulated.
Well, the question is that clause 2 be amended as circulated. Those in favor say aye. Aye. Those against say no. I think the ayes have it. The question is that clause 2 as amended now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Can we do 3 to 7 en bloc?
We could go to 11 because it's a clause, right?
All right, so we'll go to 3 to 11, and then as 7A is a new clause, then we come back to that. Okay, thank you.
Clauses 3 to 11.
The question is that clauses 3 to 11 stand part of the bill. The question is that clauses 3 to 11 now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clauses 3 to 11 now stand part of the bill.
New clause 7A.
The question is that new clause 7A be read a second time. Those in favor say aye. Aye. Those against say no. I think the ayes have it. The clause will now be read a second time.
New clause 7A.
The question is that new clause 7A be added to the bill.
Madam Chair, could I seek some clarification before the...
Yes, what?
Through you, Madam Chair. Attorney General, why are we doing this amendment to the bill when in October 2nd, using the order by the Minister of Works, had already done that in a previous time, but up to December 31st? Why is it necessary to do it now, using this format?
Sure. I thank the honourable member. Very sensible question. The mischief that this new clause seeks to address in the Bills of Sales Act is the exact mischief that all of the other clauses we just accepted do. What we did is we gave a bucket. We gave a period between April to July for all things which had expired to be valid. And we said that they would be valid up to August. We had the power to extend that August date. So what happened is that anything that fell after July wasn't in the bucket. And therefore, there are a number of things that fell outside that bucket that we now want to put a bigger bucket for. So we're moving the date from April to December. That's the new bucket. The old bucket was April to July. And we're allowing for that December date to be extended. So regrettably, because of how the COVID restrictions went into effect, we had the position where whether it was a theatre or dance hall or a bill of sale, there were those that were validated by the legislation, but unfortunately, there were those that could not meet that bucket because they came after, and because of the appointment process, they couldn't make it in time. So what we're doing, consistent with all of the other 11 clauses we just did, from clauses 3 to 11, we're just extending that time frame.
So, Madam Chair, so that when the Minister of Works had done it via order on October 2nd, was
Yes.
that wrong? Or he had
No, it
that
was
wrong?
perfectly correct. So bucket is you're catching everything in the period April to July. We said that would be, those things caught would be valid until August. That's the original law. The minister's order said they'd be valid until December. The bucket still only caught those things up to August, up to July. So what we're doing is we put in a larger bucket now, April to December, and we're allowing for both posts to be moved in the future in an easier fashion.
Can I just have a follow-up question? AG, I don't know if you could help me explain. When you were piloting the bill early on, you talked about an insurance issue
Yes.
in relationship to the Motor Vehicles Act.
Yes.
That if your driver's permit was not valid, how would that have impact on the insurance validity of individuals?
What I think
we passed
the new clause 7A.
Yeah.
And
Just seeking
this,
some
as far as I am aware, deals only with bills of sale. We have already dealt with 3 to, well, 1, 2 to 11 of the bill as it stood. Okay, so that I can't allow us to go back. Even though I appreciate what you would like to do, I can't allow us to do that. We are at the stage of the new clause 7A. Okay, so if your questions on the new clause 7A, if they are answered, I will now put the question.
Should it please you?
The question is that new clause 7A be added to the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. New clause 7A now stands part of the bill. As a result of the insertion of new clause 7A, there will be a consequential amendment to the long title as circulated. Honourable members, the question is that the bill as amended be now reported to the House. Those in favour say aye. Aye. Those against say no. I think the ayes have it. This committee meeting is now adjourned. The House will receive. Attorney General.
Thank you, Madam Speaker. Madam Speaker, I wish to report that the Miscellaneous Provisions 2019 Novel Corona 2019 NCOV No. 2 Bill 2020 was considered in Committee of the Whole and approved with amendments. Madam Speaker, I specifically report that the long title of the bill was amended to read as follows. A bill to amend the Cinematographic Act, Chapter 2010, the Registration of Clubs Act, Chapter 2101, the Theatres and Dancehall Act, Chapter 2103, the Family Law Guardianship of Minors Domicile and Maintenance Act, Chapter 4608, the Bills of Sales Act, Chapter 8232, the Motor Vehicle and Road Traffic Act, Chapter 4850, the Money Lenders Act, Chapter 8404, the Pawnbrokers Act, Chapter 8405, the Licensing of Dealers, Precious Metals and Stones Act, Chapter 8406, and the Old Metal and Marine Stores Act, Chapter 8407, in response to the 2019 novel coronavirus, 2019 NCOV, and for related matters. I now beg to move, Madam Speaker, that the House agree with this report from the committee.
Honourable members, the question is that the House agree with the committee's report on the Miscellaneous Provisions 2019 Novel Coronavirus 2019 NCOV No. 2 Bill 2020. All in favour say aye.
Aye.
Any against? The ayes have it. Attorney General.
Madam Speaker, I beg to move that the Miscellaneous Provisions 2019 Novel Coronavirus 2019 NCOV No. 2 Bill 2020 be forthwith read a third time and passed.
Honourable members, the question is that the Miscellaneous Provisions 2019 Novel Coronavirus 2019 NCOV No. 2 Bill 2020 be forthwith read a third time and passed. All in favour say aye. Aye. Any against? The ayes have it.
A bill entitled, "This bill contains 11 clauses and seeks to amend the Cinematograph Act, Chapter 2010, the Registration of Clubs Act, Chapter 2101, the Theatres and Dance Halls Act, Chapter 2103, the Family Law Guardianship of Minors Domicile and Maintenance Act, Chapter 4608, the Motor Vehicles and Road Traffic Act, Chapter 4850, the Bills of Sale Act, Chapter 8232, the Money Lenders Act, Chapter 8404, the Pawnbrokers Act, Chapter 8405, the Licensing of Dealers, Precious Metals and Stones Act, Chapter 8406, and the Old Metal and Marine Stores Act, Chapter 8407, in response to the 2019 novel coronavirus 2019 NCOV and for related matters.
The Minister of Finance.
Thank you, Madam Speaker. I beg to move that a bill entitled An Act to Amend the Public Procurement and Disposal of Public Property Act, number 1 of 2015, be now read a second time. Madam Speaker, the bill before the House has 10 clauses. The first clause is the standard title. The second clause defines the act that is being amended, which is the Public Procurement and Disposal of Public Property Act. The third clause is a standard commencement clause, which states that this act will come into effect on proclamation by the President. The fourth clause provides a new definition of the act of bid rigging. The fifth clause addresses Section 7 of the Act and deals with government-to-government contracts and other arrangements with international bodies and the question of specialist services. The sixth clause, Madam Speaker, is just a typographical consequential change. The seventh clause gives a specific time frame with respect to entities that can engage in public procurement. The eighth clause gives more time to the regulator, the Office of the Procurement Regulator, to respond to a submission from a party, an aggrieved party, or somebody seeking clarification. The ninth clause inserts the typical definition of a relative, and the 10th clause is simply procedural. So let me move now to the substantive clauses. Before I do that, Madam Speaker, I took note today in the Daily Express, an editorial, and really, I must say that our media must do better. I've been looking at our media now for 30 years, and I've seen a general deterioration in research, analysis, and, Madam Speaker, I don't know what they're shouting about. Could you protect me, please?
Members, let's proceed. Minister of Finance, I'm sure you have a certain amount of protection in that speaking booth.
It's just all the grumbling, Madam Speaker. It takes away from the presentation. So, Madam Speaker, as I said, I've been looking at editorials and articles in the media for the last 30 years, and I've seen a general deterioration in the level of research, the level of analysis, the level of fact-checking, and the level of argument. And today's Express editorial is no different. This editorial claims that this bill will gut the Procurement Act. And in the ordinary English meaning of that word, it essentially means reduce it to nothing. So when you gut a building, for example, you take out all the internal parts of the building. This is hyperbole, exaggeration, misdirection, and misinformation in the extreme, Madam Speaker. Because what this bill seeks to do is simply deal with certain specific matters. And those are the whole question of how this government would deal with other governments when entering into contractual arrangements with those governments, and also how we deal with matters such as specialized legal services and medical services and so on. The rest of the procurement regime, which is the procurement of goods and services for buildings, for infrastructure, for equipment, for services of many different types, which I dare say is over 95% of public procurement, remains intact. And therefore, it's pure hyperbole and exaggeration for the editorial writer to say that this bill will gut the act, in other words, reduce it to nothing. That is just ridiculous, Madam Speaker. And the editorial also goes on to complain that this bill will remove from the regulator the responsibility for disposal of public property. Again, that demonstrates a lack of research on the part of that particular newspaper, because I have in my possession a letter written to me on the 18th of December 2019, and this letter has already been read out in this Parliament, has been published in the newspapers. It's over a year ago, December 2019. And in that letter, the regulator, writing to me, said that Section 13(1)(o) of the Act prescribes that the function of the office are to act for, in the name and behalf of the state, to dispose of real property owned by the government in such manner as the government may consider appropriate and desirable. And this is what the regulator had to say to me, which has been said repeatedly in this Parliament over the last 12 months. The office is of the firm view that despite the mandate of the office to dispose of real property, the office should not, and it's in bold letters underlined, be responsible for direct disposal of any assets, inclusive of real property, as this will be a direct conflict of interest as it relates to its regulatory function. So the regulator wrote to me a year ago and said he should not be responsible for direct disposal of assets inclusive of real property, as that would be a conflict of interest. Yet, in today's editorial, as part of their assault, they complained how disappointed they were that one of the things we were doing was removing from the regulator the responsibility for disposal of public property. And it just goes to show there is no fact-checking, there's no research. But let's go further, Madam Speaker. I have compiled a list of the government-to-government arrangements entered into by this administration and, Madam Speaker, by the previous administration, Madam Speaker. And I have a very brief list here. And actually, I've gone all the way back to 2006. In May of 2006, the government of Trinidad and Tobago entered into an arrangement with the government of China for a construction and financing arrangement for the National Academy for the Performing Arts. In 2011, under the administration of the member for Siparia, the government of Trinidad and Tobago entered into a further arrangement with the government of China for additional work to that Napa building. That is under the UNC government. Under the UNC government, in March of 2013, the government of the member for Siparia entered into a government-to-government arrangement with the government of China for the construction and financing of the Couva Children's Hospital. On March the 15th, 2013, again under the government of the Member of Parliament for Siparia, the former UNC government entered into a government-to-government arrangement for the construction and financing of a number of sporting facilities around Trinidad and Tobago, the aquatic center, the cycling facility, and so on. And famously, Madam Speaker, just before the general election, the Honourable Member for Siparia, on a visit to China, saw a vessel somewhere and said, I want one of that. And the government subsequently entered into an arrangement with the government of China, that's the UNC government, for a Chinese long-range patrol vessel. Similarly, the government of the member for Siparia entered into a government-to-government arrangement with the government of Austria for design, construction, and financing of a hospital in Point Fortin. This government, Madam Speaker, has entered into an arrangement with the Exim Bank of Australia
for the financing of 2 Cape-class vessels. And there was a video recently, and you would see the lean machine that is about to come to Trinidad and Tobago to help us to protect our borders very shortly. This government has also entered into an arrangement with the Exim Bank of Australia for the financing of 2 ferries, 2 fast ferries, the APT James and the Bucko Reef. The APT James, I just checked its position this morning. It is just off the southern coast of Italy on its way to Trinidad and Tobago. The government of the Honorable Keith Rowley also entered into an arrangement with Austria following on the previous arrangement for the Point Fortin Hospital, for a new hospital in Sangre Grande. And finally, the other one that I have to list here today is an arrangement with the government of China for a construction of an industrial estate, Phoenix Park, in the Couva area. So, Madam Speaker, there's a long history of government-to-government arrangements. It goes back many, many, many years. And as you have seen, I have listed out all of the government-to-government arrangements between this government and the prior one headed by the government of the member of Siparia. And therefore, it's political hypocrisy for the UNC to now come and scream that the amendment to the law to continue the arrangements that have been in place for more than 10 years, including the 5 years that they were in government, should now be taken out, and it will gut the Procurement Act by doing that. Absolute nonsense, Madam Speaker. What we are saying, and what we on this side have been saying for years, and we have not diverted from our position, if it is beneficial to the citizens of Trinidad and Tobago, as it is alleged it was for the construction and financing of the Couva Hospital, if that is considered beneficial to the citizens of Trinidad and Tobago, the government of Trinidad and Tobago should have the flexibility to negotiate that contract with the government of China or any other sovereign government in the best interest of the people of Trinidad and Tobago. And it is absurd to demand that an arrangement with a foreign government must be administered by a non-elected person. We are accountable to the Parliament, Madam Speaker, and it is we that will account to the Parliament about government-to-government arrangements, as did the member for Siparia when that honourable member, was in government. So I don't think there's much more to say about that. Are you saying that no longer the government of Trinidad and Tobago must make arrangements with other governments for the provision of things like hospitals and fast patrol vessels and things like that? Are you saying that? I can't believe that that is what is being presented to us. And I really don't think there's anything more to say about that. Now let's move on. With respect to services, is it really being told to us and to the national community that if the government of Trinidad and Tobago requires legal services, we must put it out to tender so that Ramdean and Ramlogan will win the bid because they will be the lowest bidder, and the government of Trinidad and Tobago, the PNM government, must hire Ramdean and Ramlogan? That is the level of absurdity that you could carry that to. That is the level of absurdity. Clearly, it is a long-established practice in the Republic of Trinidad and Tobago since 1976 and before, that in terms of legal services, it must be left up to the Attorney General and the government to select counsel that they feel will serve their best interest. You can't tender legal services. That is an absurdity. And that is all I have to say about that. And with respect to medical services, Madam Speaker, if, heaven forbid, a member here became ill and needed emergency surgery, are we expected to go and get a quote from St. Clair Medical, and a quote from Mount Hope, and a quote from Southern Medical, and a quote from St. Augustine Private Hospital, and then when you get the quotes, you evaluate them and you award it to the lowest bidder? By the time that happened, we're dead, Madam Speaker. So it is absurd to tell a government or a parliament, for that matter, that we must subject medical services to the lowest tendering procedure. So there isn't much to say about that either. And the same applies to auditing services. And those are the things that we have pulled out that we said legal services, medical services, accounting and financial services would not be subject to the system that is in the Public Procurement Bill. And Madam Speaker, I don't think there's much more in this matter to speak about. All I will say, Madam Speaker, is that people need to understand what is going on here. Because there are a lot of commentators, and by the way, how much time do I have left, Madam Speaker? Madam Speaker, how much more time do I have?
3:59:34 is your full time.
Thank you very much. I have 14 minutes. Thank you very much. Madam Speaker, there's a lot of commentary on procurement in Trinidad and Tobago. But there are not too many people in Trinidad and Tobago who have done research on the matter, who have published papers on the matter, who have lectured on the matter, and who have academic qualifications specific to procurement. And therefore, it falls to me, Madam Speaker, to explain to those who do not know or may pretend not to know what this public procurement law is all about. In Trinidad and Tobago at this time, the whole question of competitive tendering by a state enterprise, and that is where most of the competitive tendering is done. There's been a move away from the Central Tenders Board for many, many years now under this administration, under the UNC government and the NER government and before. And in fact, there was an amendment to the Central Tenders Board Act, and this was many, many years ago, which allows the state to procure goods and services through NIPDEC and other state enterprises. And there's a reason for that. The reason was that it was felt at the time when that was done so many years ago that there were issues with respect to efficiency. And I don't think there's any argument with respect to that. So we have a well-developed culture in Trinidad and Tobago now for 25 years or more with respect to the vast majority of procurement being done by state enterprises. But the law as it currently stands in Trinidad and Tobago, and we have local cases and we have international precedent on this matter, but the law with respect to procurement by state enterprises, Madam Speaker, and I can refer you to a decision given by Justice of Appeal Warner in March of 2006, and that is the law currently in Trinidad and Tobago. And Justice of Appeal Warner, as she was then at the time, said, and this is the case law, it's supported by well-established case law all over the world, but most importantly within the Commonwealth, and the learning comes out of Australia and New Zealand. Justice of Appeal Warner held that judicial review of the decisions of a public body will not be appropriate where, one, the decision is commercial in nature, such as the purchase of goods or services, or in consequence of a tendering process. Two, its decisions are not subject to duties conferred by statute. Three, there is no allegation of fraud, corruption, or bad faith. And in this particular case, it was held that the aggrieved contractor in that particular matter was unable to obtain judicial review of a decision by a state enterprise to award a particular building contract. There's another case, and this was a case with respect to the aborted attempt to construct an overpass and interchange at the intersection of the Churchill-Roosevelt Highway and the Uriah Butler Highway, and this again was under another government. This was not under the PNM government. It was under the Pandey administration when John Humphrey was the Minister of Works and Transport, and there was an attempt to build something, I think they call it a golden bridge or something, but it never came off because at the time the contractor challenged the decision of the tender committee to award the contract to a particular entity. The matter went to court, and Justice Mohammed rendered it. The judicial review application was filed in 2001. And Justice Mohammed rendered his decision as he was then in May 2006 and made the same point that although, and in this case it was a Udicot matter like the other one, although Udicot was performing public functions when it invited tenders for the interchange project, there was insufficient public flavor in Udicot's action in the tendering process to render it open for judicial review. He also went on to say that when Udicot engaged in the tendering process, it was engaged in an activity which was intrinsically commercial and contractual in nature. And the whole point, the learning in all of this, is that unless you can demonstrate that is fraud or bad faith or corruption, the decisions of state enterprises with respect to procurement are not amenable to judicial review. What we are now doing in Trinidad and Tobago, by the Public Procurement and Disposal of Public Property Act, is we are now introducing public law elements into public procurement that did not previously exist. And from the time this act is proclaimed, whereas in the past the courts have chosen not to get involved in procurement matters unless fraud or bad faith can be demonstrated, the court can now be invited from the time this Procurement Act is proclaimed, the court can now be invited to review, overturn, repudiate awards of contract. So I want people to understand exactly what we are doing. Now, for the first time, once this Public Procurement Act is proclaimed, we will be inviting the courts to get involved in public procurement. And what that would mean, and let's go back to the bill before us, because we've all decided that this is something that we should do. So let us go back to the bill before us. There's no dispute as to whether we should do that or not. We have decided as a parliament we will do that. We will introduce public law elements into our procurement process, and therefore we will open the door for an aggrieved contractor or supplier to approach the court and ask for a contract. Forget the regulator. The regulator has his statutory function, but I'm going beyond the regulator into the domain of the High Court. We'll now be inviting the High Court to determine whether a contract award should continue, overturned, repudiated, varied as the case may be. But what that will do if we left the legislation as is would mean that if this government or any succeeding government would choose to enter into an arrangement with the government of the United Kingdom, the government of the United States, the government of China, the government of Australia, any government, to procure goods and services for the benefit of the citizens of Trinidad and Tobago, such as that Couva Hospital, and that's an important project in the context of what we are discussing. What it would mean is if we leave this act as is, it means that any government who would choose for the benefit of the citizens of Trinidad and Tobago to enter into an arrangement with another sovereign government, it would mean that an aggrieved person would be able to approach the court and completely repudiate, of course, if they have grounds, and completely repudiate that contract and demand that that arrangement with that sovereign government be scrapped and that project be abandoned. And certainly, I don't think any right-thinking person in Trinidad and Tobago wants to get to the stage where we have that kind of situation, because the government simply will not do business with us. Because when you enter into a concessional financing arrangement with another government, and I'm using the Couva Hospital as a case in point, because that was financed by way of a concessional loan at an interest rate of 2%, and on terms that are very generous for the people of Trinidad and Tobago. It is absurd for anybody to believe that if some person who is not accountable to the Parliament could interfere with the arrangements with another government, that any government will want to do business with Trinidad and Tobago again. And that is the practical reality, Madam Speaker. I just want to tidy up now some matters. There's a lot of misinformation outside there. As I said, that editorial is misinformation. I mean, to take out 5% of an act is certainly not gutting it when you leave the other 95%. But I have in my possession a letter circulating. It was written to the Honorable Prime Minister. It's dated the 12th of November 2020. And that letter to the Prime Minister states that there was a report submitted to the Senate, the other place, on the 30th of September 2020. And it is written by the President of the Joint Consultative Council for the Construction Industry. And this letter says that from this report, we have gleaned that the Office of the Procurement Regulator last responded to queries from the Finance Minister on the 18th of December 2019 and subsequently met with the Legislative Review Committee of Cabinet in March of 2020. And it is clarified in the report that the Office of the Procurement Regulator is currently awaiting action from the Minister of Finance. To be very kind and charitable and polite, Madam Speaker, that letter is inaccurate. I could have used other language to describe it. But let me tell you what the facts are, Madam Speaker. I asked the Attorney General, who has been working with the Office of the Procurement Regulator for months, including as recently as last month, that what are the facts? On the 8th of April 2020, so that's after March 2020, the Office of the Procurement Regulator wrote the Attorney General wrote the Office of the Procurement Regulator with respect to the Act. There was a virtual meeting with the Office of the Procurement Regulator on the 4th of May 2020. That is also after March. There was a virtual pre-LRC meeting with the team from the Office of the Procurement Regulator on the 14th of May 2020. In July of 2020, after Cabinet had made all of its deliberations with respect to the matters discussed with the regulator, in May, the Minister of Finance wrote the Attorney General submitting the bill, submitting the draft regulations, and asking for the Legislation Review Committee to attend to this public procurement bill because it was a matter of grave national importance. In the 14th of September, of course, we had an election in between. On the 14th of September 2020, there was a letter to the AG from the Office of the Procurement Regulator. On the 7th of October 2020, there was a virtual pre-LRC meeting between the AG and his team and the team of the Office of the Procurement Regulator. And on the 13th of October 2020, less than 2 months ago, draft regulations, revised regulations, were submitted to the Attorney General's office for consideration. So there has been intense debate, meetings, consultation, and dialogue between the government through the Legislation Review Committee and the Attorney General with the Procurement Regulator for the last 6 months, Madam Speaker. And therefore, Madam Speaker, I just want to put to rest that correspondence that's in the public domain. It is simply inaccurate. It gives the impression that we have done nothing since March. It's simply untrue. And therefore, Madam Speaker, to sum up, we are firm in our belief that it would be a travesty if we denied Trinidad and Tobago the opportunity to enter into arrangements with other sovereign governments. And we are firm in our belief that it would be an absurdity if legal and medical services were to be subjected to tender to be given to the lowest bidder, Madam Speaker. I beg to move.
Honourable members, I shall now propose the question for debate. The question is that the Public Procurement and Disposal of Property Amendment Bill 2020 be now read a second time. Member for Superior.
Thank you very much, Madam Speaker. for allowing me the opportunity to join in this debate. And I do not share the cheery mood of the Honourable Minister of Finance. In fact, I think today is a very disgraceful and shameful day in this Parliament. And I say that not only because of the matter in the present bill, but I say it because on such an important matter, there has been no consultation with the stakeholders to arrive at the positions in the amending bill. We were given this bill, I think, on Monday night, together with 4 other bills, all of which are very important bills, to prepare Tuesday, Wednesday, Thursday to come here to debate all 5 bills in one go. I know that you may be trying to keep me here all evening and keep our members here all evening, but none of that will make a difference on Sunday. We will go brave. I would like to remind members that it was under the partnership government, which I led, that procurement legislation was actually brought here, debated, and passed by this House. The other side, then in opposition, tried to do everything they could to frustrate that process. They absconded from the JSC, couldn't get a quorum. The JSC had to change the number to constitute that quorum in order to get the work done. Thereafter, they came to the House and said, yes, we will pass good law. Yes, procurement legislation is very good, but. And since then, from 2014-15, because the bill was passed in late 2014, in December, and became Act 1 of 2015. We partially proclaimed it and put a committee in place to assist with implementation, because it is a complex, novel piece of legislation for our jurisdiction. They came in then in later 2015, and when the minister tells us for 6 months they've been doing something, talking to each other and sharing letters with each other, it is 6 years this has been awaiting proclamation and full implementation. 6 years, Madam Speaker. So one is not surprised in a sense that they intend to delay. They've delayed it. I believe the delay is deliberate, and I'll share some points that I have. The delay has been deliberate on their part. In their last term in office, of matters that took place. And again, I'm very surprised at the Honourable Minister of Finance, because I know he said people think he's stupid. But I don't think he's stupid. I think he's very disingenuous. Very disingenuous. That the minister would come to tell us, look, we have government-to-government arrangements, agreements going back for decades. But that is the very reason why this piece of law came into force. This is why this piece of law was passed in this Parliament, to stop those kinds of arrangements because of the corruption involved. So to say, well, you know what, Superior, you did it, we did it way back when, okay, so it's well, fine and good. That is why I remember in 2010, Madam Speaker, the JCC and other stakeholders said, look, we have to bring procurement legislation. We have to deal with the corruption levels. These are some of the proposals. They gave me an entire package, legislative proposals, and I said, yes, we will lay these within 30 days when we form the government. And so said, so done, we laid it. Sent to the JSC, sent a second JSC, and eventually, as I say, the rest is history. That was passed in 2014. So that because you've done something the same way for decades, for eons, doesn't mean it is the right thing to do. As time goes, matters arose in several countries where they have brought in their procurement legislation. We looked at the Finland model, we looked at the Singapore model, we look at Jamaica, we look at Canada, we look at the United Kingdom, that all these models were looked at to arrive at that Act 1 of 2015. So it is nonsense, in my respectful view, to say that because this was done all the time, great it was done. And Honourable Minister of Finance, they say, I went to China and saw a vessel. And said, I want that. Madam Speaker, there was a process that we went through. There was a process using the armed forces, because under that law at that time, under the CTB, NIPDEC or the armed forces had a different process. And so it was the armed forces, the Coast Guard, that assisted us in going through a particular process to acquire that vessel. You see, and Minister will forget, or want us to forget, that it was right here in that last government we saw the fiasco of the Chinese Hezuba contract, if I pronounce that word correctly, the HDC contract. Government to government, right recently, $71 million for phase one, only for phase one. I think it's political hypocrisy to say keep government to government arrangements when we saw the scandal that was, when we saw how disadvantageous it was to the people of Trinidad and Tobago, that the same government had to pull it back. Maybe at a cost, they had to pull that back. Pull it back, that contract government to government. And so I say this political hypocrisy to say because we've done these government to government things for eons, for decades and decades, keep the status quo, no change. We do not agree with that position at all. A lot of work went in this legislation from all kinds of stakeholders. We do not agree with the Honourable Minister. And then Minister tells us as well, look, services, madam. Exempting services, what you're doing, you're setting up a parallel procurement process. A parallel process that will be regulated by the independent office of the procurement regulator under this act, and one you want to go back to the status quo that will be conducted by the cabinet, by the executive, by the politicians. That cannot be right. It cannot be right, and I'll tell you why. We had written to the we had caused to be written to the cabinet of the government of Trinidad and Tobago. A freedom of information application. And in that application, the question was, which matters did the Honourable Attorney General recuse himself from, and which ones did the Minister of National Security recuse himself from? Now, madam, let's understand, recusals, they were procurement issues. So this is where there was the existing procurement matters, where it goes to the cabinet to make a decision. So that this is fact. From the cabinet, we were told by letter dated July 7, 2020, that from 2016 to July 7, 2020, Minister Young recused himself from the cabinet 57 times. Minister Stuart Young refused himself from the cabinet, the Honourable Attorney General, 38 times, making 95 times that these two cabinet ministers left the cabinet, recused themselves for procurement issues. Procurement issues, Madam Speaker. And I will not go through all 95 of them today, but I will point out that some matters relating to Minister Young had to do with financial services. So in 2018, for example, the award of mandate to NCB Global Finance to arrange a 10-year fixed rate loan in the amount of TT $180.3 million. That was one that related, there was a conflict of interest, a relative was involved in that company, the minister left the cabinet. Yes, that's the existing law. But they were saying that under the procurement law, with an independent office, it should not be the cabinet colleagues determining an award going to a relative of a minister. Some unscrupulous official, Honourable Speaker, could use this to the hilt. So we have here 2018, award of contract to NCB Global Finance. We have here in the year 2020, award of a mandate to NCB Global Finance Limited to provide a 125 fixed rate loan for WASA. This one again, the minister recused himself because a relative was involved in the company that the contract was given to, the mandate was given to. Again in 2020, award of a mandate to NCB Global Finance Limited to provide 125 million fixed rate loan. Again, the minister recused himself because a relative was involved in that. So you want to take financial services out of this, put it in apparel, keep it in the status quo, and this is what will happen. That can never, ever be right. And that is why the Procurement Act was passed, to remove these from the arm's reach of the politicians, of the executive, granting to their colleagues contracts in the cabinet. Now, I would like to ask, we know of these two because the question was filed, and I'll come to the other one with the Honourable Attorney General. Which other minister recused himself, and for what?
Of under noise in the chamber that is making it difficult for me. There's a lot of, talk, please. Member for Superior.
Thank you. Yes. Thank you very much, Madam. We know of these two because the FOIA file gave us these answers. The question then, are there others that we don't know about who are getting contracts through the cabinet for friends, relatives? MP Keith Scotland is a brilliant lawyer. Has he recused himself from the cabinet at any time? MP Hines is a brilliant minister. Has he recused himself at any time? The question is whether any others have recused themselves and therefore are benefiting, their family members may benefit from that kind of status quo procurement issue. The Honourable Attorney General, you talk about those are financial services. The Honourable Attorney General, as I said, recused himself from the cabinet, and it had to do with medical services, madam. So again, this parallel, you're exempting, you're taking these out from the procurement law and leaving it under the existing status quo, which allows again the cabinet to grant to a relative of colleagues contracts. So look at the medical ones now. When you take out the medical, look what's happening. In the year 2018, the Honourable Attorney General had cause to recuse himself because the matter being considered by Cabinet was a proposal for the continued engagement of private healthcare institutions for the provision of surgical, radiological, and lab services for patients of the public healthcare system. Why did the Attorney General recuse himself from these medical services? Why? Is it that he has an interest in this company? Why did he see the need to recuse himself? That's the existing law, he did that. But the point is that has to change. It cannot be that the cabinet is granted unto other cabinet colleagues contracts. That can't be right. Further, on
Madam
the same
Speaker,
year,
Standing Order 48.6, the cabinet does not grant contracts to other cabinet members.
Member 48.6 will be that it's imputing improper motives. And I don't uphold the objection. It could be dealt with in response. Please.
thank you very much. And again in 2018, proposal for the continued engagement of private healthcare institutions for provision, surgical, radiological lab services, and so on. Here it is, medical services being procured with that existing system, which is a parallel system that you want to go back to when you move it out of this, from this particular Procurement Law, Act 1 of 2015. But it doesn't end there. In 2018, the Honourable Attorney General recused himself when a proposal for the remission of customs duty and VAT payable on a PET-CT scan machine imported by Alexandra Imaging Centre was being considered by the Cabinet. Why? What was the conflict of interest? But the point is that it is the existing system and we want to leave it like that. And I say, no, we cannot support that. We will not. Retention of customs duty and VAT again on a scan machine in the year 2019. So I don't know if it's the same scan machine or if it is another scan machine, but there are two recusals with respect to the PET-CT scan machine. So what you're going to be doing by removing these services is that you're going to put it back into the old procurement system, which is fraught with difficulty. It would take any unscrupulous official to exploit these to the benefit of friends and family, or not friends, family. And therefore, you will be running a parallel procurement system, which could end up raising serious constitutional issues, and I'll come back to that in a moment. But even more dangerous in this amendment, apart from saying moving out medical, moving out financial services and the others, you're saying that the minister may, by order, remove anything else, exempt anything else. And that exemption, that order, will take effect immediately it's made. And is subject to negative resolution, and that means it will take effect immediately. Immediately. And an unscrupulous official, Madam Speaker, can quickly go to the cabinet while it's in effect and remove something else and give themselves a contract and so on. By the time we come to negative, 840 days would have passed. How many contracts would have been awarded? How many things would have happened that order would be made to exempt persons from it? So that is a cause for grave worry, Madam Speaker. So the services issue, we have grave concern, and we cannot support the services issue. We move to, Madam Speaker, the issue of constitutionality. Now, several people have been talking about the first Parent Act was passed by a special majority, and the issue arose as to whether subsequent amending pieces of legislation could be passed with a simple majority. But there are serious constitutional issues, and it is not simple to say use Surratt and Barnes and the others, Northern and so on, and talk about proportionality. Because proportionality has to do with a legitimate aim. Is it a legitimate aim to create a parallel procurement system outside the independent office of the procurement regulator and put it in the hands of the status quo, which is the executive, the cabinet? How can that be a legitimate aim? And that can raise issues now having to do with constitutionality, about inequality of treatment, about unfairness, about discrimination, because you're using two different systems. One where you as an executive sitting making decisions, and then one where the independent office of the procurement regulator is being undermined. The Honourable Minister really raised a very confusing issue, which I'm still putting my mind to, and that's why he's very clever with being disingenuous, when he told us, you know, well, we had tendering under the CTB. That was 1961. I'll remind him of that. Thereafter, the law changed to allow the armed forces. That's how you could buy the boats and so on through them. There was an exemption for them from using CTB. And then NIPDEC was introduced by 1993, I believe, or the other way around. And up from 1993 now, there's been no change in the procurement law. The Ministry of Finance created a divestments manual, like rules. Does that have the force of law? Just a manual with rules created by the ministry about how you procure and how you dispose. But here it is now, the minister tells us, well, you know, state enterprises, judgment by Justice Warner and so on, not subject to judicial review. Not subject to judicial review. State enterprises with these contracts and so on. But that's the reason why you need this procurement law. That's why you need it. Because you don't have scrutiny. You will have scrutiny under this. But no, you don't want that to happen. So you say, let's go back. You don't want a court to come and overturn. That's exactly why you need the law. Minister, you're being disingenuous. These are the things that over the years, there's a Bala report from 1987, I think it is, with all the government-to-government contracts, all the corruption that went on with the Mount Hope complex, we could name all of them, French company, foreign company, all these government-to-government contracts, riddled with corruption. And that 1987 Bala report said, look, get rid of this government-to-government issue, too much. Then you have the private-public kinds of partnerships that could be subsumed under these same sections. And we remember the scandals, the Sandal scandals, where it was a disadvantageous deal to the people. If we had the procurement law, the government couldn't go out and sit down at a lunch table and make a deal. That is what we were told by none other than Arthur Lockjack, that They were eating lunch or dinner, and they made that arrangement. That's why we need the procurement legislation, Act 1 of 2015. That's why we need it. And you know, the minister started off by buffing the media. Typical kind of reaction. Buffing the media for their comments. But I want to share with you the voices of the people on the issue of this procurement legislation. We have the public sector, private sector, civil society group saying that they're deeply distressed about amendment to procurement legislation. They talked about the delays and the promises broken. PNM promises never materialized from since 2015, right down to this year. They talk about it saying that they're deeply concerned, and this is signed by Winston Riley, represented the JC, AmCham, the Chamber, TTMA, Trinidad and Tobago Transparency Institute, Trinidad and Tobago Local Content Chamber, and TTCSI. And they said that all these statements, this is still here in limbo and in abeyance. And they were deeply concerned that it had reached where it had reached. They said they had written to the Prime Minister on November 20th. They issued a press release reminding the Prime Minister of his commitment on September 29, 2020. And of course, now the rest is history, where we don't have that coming into effect in spite of all the promises. We also have the JCC, which tells us that the proposed amendment to Section 7 provides status quo to the Minister of Finance, and for all intents and purposes, nullifies the intent of the Act, the substantive intent of the Act. In particular, Section 7 of the Act is proposed to be amended to delete that where there is a treaty, there is an agreement and so on, that this is going to be removed because you would have to keep it still within the Act. So the treaty will not prevail above the substantive intent of the Act. And that too is a serious issue, which I raise on constitutionality. It's public funds you are spending. It's taxpayers' money that is being expended. And therefore, there must be scrutiny from an independent person. The Office of Procurement Regulator, in an advisory dated 3rd December 2020, that is yesterday, said, they maintain the position that Clause 5, which seeks to amend Section 7 of the Act of 2015-1, which is that they don't want to change. They're saying a thorough consultative process was undertaken between 2018 to present with stakeholders across various sectors. They provided feedback from their workshops, 20 workshops, 193 sensitization sessions, webinars held with over 1,400 suppliers, contractors. And during these consultations, stakeholders reiterated that there should be no amendment to Section 7 as it stands. No amendment. From the OPR and from all their consultations, no amendment. They emphasize that Section 7 should be given an opportunity to be tested, since there is a real possibility that local suppliers and contractors may be deprived of a fair and equitable chance to participate in procurement proceedings. And that is the same issue of constitutionality, of equality of opportunity, equitable chance to participate. They continue, any variation to this provision may undermine the objects of the Act, namely accountability, integrity, transparency, and value for money. At all times, stakeholders continue to emphasize that these arrangements under Section 7 ultimately will be repaid with public money, and so these transactions should fall within the ambit of the Act to achieve the objects of the Act. Additionally, there should be no exclusion from the OPR's oversight in respect of the procurement of legal, financial, accounting, auditing, medical, and any other service, as the Minister may by order determine. Should be none. No exemption. This is the Procurement Office. They've been working since 2018. They've done a lot of work, including the prep of the regulations. We would have thought you'd be coming here to lay the regulations. Instead, you come here to gut the Act. Minister said he's not gutting anything. What are you doing? You're taking out substance. You're taking out that which is important for the integrity of the process. You're taking out those things that will make a fair procurement and disposal process. Government making procurement law toothless. I commend former MP Botibari, who was very instrumental, together with MP Tim Gopi Singh, I believe, and A.G. Ram Logan, who served on the JSC for our side at that time. They did a tremendous job. They met with so many stakeholders. They got advice from the IDB and from the World Bank. They met with the procurement, the equivalent of the procurement regulator in Jamaica. They looked at models all around and came up with Act 1 of 2015, what is now Act 1 of 2015. And on what you're doing, by a simple majority, you want to dismantle that which was put in place by a special majority. Piece by piece, you're dismantling an independent institution by simple majority when it had been put in place brick by brick, line by line, provision by provision, by a special majority. Dr. Tiwari says the net effect of one of the early amendments was to reduce the power of the Procurement Board and to create a parallel structure of power by the creation of an appeals tribunal. They also came, this is their third amendment, also came to Parliament in 2017 to set up something that they call disposal of state lands. So they took disposal of state lands out of the procurement hands, but they also took disposal of things from a state enterprise and statutory authorities. So when we are there screaming procurement legislation, Petrogen could sell out everything. NIPDEC, sorry, not Petrogen, the Paria, Guaracara, NP stations, Port of Spain, all that gone, all gone, all gone. And now you're coming to further gut the law. You're further gutting it out, ripping the substance out of the law in order to set up a parallel procurement system that unscrupulous individuals can use to their benefit. So it was the Express that said, gutting the Procurement Act. It was Mr. Riley who said, it is a travesty what is happening. Gutting the Procurement Act, and that's what we are doing. We are giving up the independent procurement person to keep in place the status quo, to allow corruption on the part of unscrupulous individuals to occur. That is what we are doing with this piece of legislation. So let us just look at what's happening here with us. There's a judgment by Justice Jamadar in the Karen Court of Justice, in which he talks about the underpinnings of constitutionality. That constitutionality is not just about breaching sections 4 and 5, that there is a foundation that is found in the preamble of the Constitution. In that case, it was the Belize Constitution. We have it here in Trinidad and Tobago in our Constitution. That is the foundation. And when you breach those foundational principles, you are into the realm of unconstitutional behavior and action. My colleague will probably read some of the paragraphs from the judgment for you from Belize, and that really goes to the whole issue of constitutionality. So it's not just a text, he says. It's not just a text, it is the whole preamble which sets the stone to go forward, which is a jumping stone, the starting off point. He says that then, our Constitution demands from us that those principles of fairness and equity, of the rule of law, of transparency, accountability, and good governance, that those principles must be enshrined in our law. And that's what this procurement legislation was doing. So when we come to tamper with it, to dismantle it, to desecrate it, piece by piece by piece by taking it out, then we are, in fact, madam, in a serious constitutional crisis. With those words, I thank you very much.
Prime Minister.
Thank you very much, Madam Speaker. Madam Speaker, I joined this debate for many reasons, not the least of which is to defend the reputation of the People's National Movement. I have heard it said by my colleague from Siparia in her cantankerous presentation a moment ago that as far as she is concerned, PNM means People's National Movement. No, it means promises never kept. Well, Madam Speaker, that approach by my friend from Siparia symbolizes and summarizes a whole presentation. Because if anybody knows that PNM keeps its promise, it should be the member for Siparia. Because we promised her 11 lickings and all have been delivered. Madam Speaker, this matter, if it is allowed to be addressed in a very sane and sober manner, will not draw the kind of misrepresentation and cantankerous comments as we've just heard from the Leader of the Opposition. We will beg to disagree with fellow citizens on this matter, but we have to proceed. The government of Trinidad and Tobago ought not to find itself in a situation where, by virtue of the authority being put in somebody else's hand, that the government's position has been stymied in situations where the interests of the people of Trinidad and Tobago is concerned. I simply want to say what my view is, personal view, that of all the people on the government payroll, the only people who are held accountable in Trinidad and Tobago, or who really could be held accountable, are ministers of government. A minister of government is held accountable on a daily basis for matters within his or her portfolio and other matters. Even in people's private homes, you're held accountable 24 hours a day. So when the opposition gets up and make it look as if a minister has responsibility, and that is something to cry about and to misrepresent, and that all going to fall down on the country if the minister has responsibility for something, I say, Madam Speaker, we disagree, I disagree, and we are going to move on from there. Madam Speaker, the responsibility of the government is rooted in the representation of the People's Act. We are representing the 1.3 million people out there in the actions we take. And if there are certain responsibilities which devolve to us in our portfolios, who is it saying to us today, let somebody else have that responsibility, not you, who represent the people. Let somebody else, that's somebody else who will not be able to or will not be interested in holding responsible. So we don't want the government to have any responsibility for government-to-government relations because it should be done by the regulator. Is that what we're being told? Because if that is what we're being told, then that is a gross misrepresentation of the role of the regulator. The regulator is not to be a procurer. So what is this big thing about if this is taken out of the law, the regulator will not be able to function because the law that created the regulator would have been gutted? They like the phrase, gutting the law, gutting the law. But when you have nothing to argue, you argue the law. Madam Speaker, the regulator is not to procure. And if you're so concerned that the government should not procure it, the cabinet shouldn't do it, and the minister mustn't have responsibility, then tell us who? Tell us who. Because in this country, the country holds its cabinet responsible for every single governmental action. But what you're saying, put the responsibility in the hands of the minister and the government, but put the authority somewhere else by the regulator. The law doesn't say that. So they write the papers and some uninformed person talk about gutting the law, and the leader of the opposition comes in here, grabs it and swallows it and regurgitates it here today. Absolute poppycock, Madam Speaker. Madam Speaker, there are procurement issues within the government where the law requires that in every department you establish a procurement unit, and that unit is not the cabinet. I don't know if members of the media understand that. The law says, and one of the things we've done in the cabinet in the last many months is to deal with the public service, to ensure that this requirement of the law, to have the public service understand it, prepare for it, and now will follow it, because procurement will now be done by elements of procurement entities within departments and agencies, Madam Speaker. And let me just tell the country one thing too. When we didn't have this, we had a lot of corrupt people interfering with public money and being very corrupt about it. What the procurement law does, Madam Speaker, is to multiply those opportunities throughout the public service and throughout the country. And we hope and we trust that we have become less corrupt, because now we're going to have more opportunities for many more people to engage themselves in corruption. Because the law calls for a procurement department in every department. So every Tom, Dick and Harry, from tomorrow morning, when it is proclaimed, as it will be proclaimed, all these procurement units will be there. And I trust, Madam Speaker, that we have become more honest in Trinidad and Tobago, because more people are now going to be involved in procurement. I hope the country understands that. And Madam Speaker, what this law did when it was created, in 2015 this law was passed. The UNC wanted to use it politically, so on the way out of office and out of the way of governance, they hurriedly brought it to the parliament. They got our support because procurement legislation, updating the law and so on, we support that. Those are the days when opposition supported government. But the way the law is structured, after we supported the law, it fell to the president to appoint a regulator who is the linchpin in this legislation. I saw the government being beaten for not appointing the regulator. And all that we could tell our friends in the media who were sharing the leaks, it is not for the government to do. The law gave it to the president. It wasn't until 2018 that an appointment was made, and I think it was January 12, 2018, that requirement of the law for the appointment of a regulator by the president was done. And then the law also made provision, now that you have a regulator, for the regulator to go and prepare the regulations. And you would have heard the Attorney General or the Minister of Finance tell you how many to-ing and fro-ing and meetings and all, because the regulator was preparing the regulations. The Attorney General will tell you, if he joins this debate, that it was only in October 2020 that the draft regulations were finalized and made available to him. Up to that point, the government could not bring this to the parliament because it was not for us to do until the regulator had done that and we had settled on the regulations. We have done so, and we are here now. But of course, as I said, people who are not aware, not informed, or just have some malice going on will tell you the government this and the government that, and the opposition leaders out front, waving a flag, the tongue crier as usual, trying to give the impression that we have some interest in not procuring the law. Madam Speaker, these are the facts. October 2020, we had come to a point where the regulations were settled upon. In developing the regulations, from the law that we have passed, we discovered that there were one or two things that were what we call impractical. One is that you wanted to stymie it would stymie the government from having any government-to-government arrangements. Madam Speaker, as the head of this government, I know that there are different points of views. Largely, with contractors and their associates who have a problem with that, because their problem is that if you have government-to-government arrangements, they somehow have been excluded from getting a contract. And they make all kinds of allegations and accusations, much of it not substantiated by facts to be defended in a court of law or in a parliament, but just throw it out like the opposition leader, accuse and accuse and accuse. We disagree that we should tie the government hand, and I know the reason for that. Had we not been able to approach the Australian government at the level of Prime Minister to Prime Minister of Australia, we would not have been able to access OPIC funding in Australia to buy those 2 ferries to link Trinidad and Tobago, and the opposition would have loved that. They would have preferred to be able to say that there's no ferry service between Trinidad and Tobago and the government incompetent and Tobago fall down and all we get dead. That's what they wanted. And I make no apologies as Prime Minister of Trinidad and Tobago for using my authority as Prime Minister and approaching the government of Australia and getting it solved spectacularly. The one thing I can tell them, Madam Speaker, they could make all the allegations they want. They will never be able to turn up one iota of fact to support the allegation that there was corruption in it, and I'm done with that. Madam Speaker, they wrote the Australian opposition, they wrote the Australian Attorney General trying to imply that there was corruption. They're on their own with that. Madam Speaker, today I heard about the Sandal scandal. What exactly is the Sandal scandal? They chased away the Sandal family from Tobago who didn't want any part of them. And that's a scandal? Well, since that was a scandal, go and offer the people in Tobago the alternative. What was the alternative? Nothing. They believed that it was politically sound for them, so to the Sandal scandal. They have a right to fear the cabinet, Madam Speaker. The other few minutes that I have, I will use it to tell you why they fear the cabinet and why they fear ministerial authority and why they fear governmental authority. And you know what galls me, Madam Speaker? It's because I know they know what I know. I know they know what I know. And when they come here and trying to pretend to be defenders of the public purse and talking about corruption and have the gall to accuse this government of corruption, they know that I know what they know. But of course, there are those in the country who have no interest in the facts and would promote them to talk nonsense. Madam Speaker, to hear the opposition leader come here and speak about recusal as the basis for her presentation today, Madam Speaker, why does one recuse oneself in conducting public business in the cabinet? According to the opposition leader, senior counsel, it's because you're corrupt. And for the last 9 months have been beating like a steel band the names of 2 ministers. One who has a brother who works in a bank. And the Minister of Finance borrows money by the Ministry of Finance invite banks, all the banks, whenever they need to borrow money, to put in bids. And because that minister's brother works with a bank, he religiously takes no part in any business in the Ministry of Finance which comes before the cabinet, so he recuses himself. So the Minister of Finance goes out to borrow 50-odd times. Every time there's a borrowing involving the bank in which his brother works, he recuses himself from the operation. And that is what the opposition leader is using as the basis to paint this government as corrupt. Everybody knows the Attorney General is married to a family that has a lot of property in Port of Spain and from year naught have been treating with government rentals. So every time a matter comes up with those families into which he is married, he recuses himself and takes no part. And instead of saying that he has done the right thing, the opposition leader pretends she doesn't know right from wrong and is saying that recusal is corruption. Madam Speaker, let me tell my friend from Siparia what corruption really is, and that she should be concerned about. I want to read, how much more time do I have? 5 minutes? Okay. I want to read, Madam Speaker, with your leave. I want to read extensively from 2 pages of a document here. Since September 2015, the Dutch Fiscal Intelligence and Investigation Service, FIOD, is undertaking a criminal investigation into the suspicion of foreign bribery committed by the Damen Shipyard, a large Dutch vessel building and service company based in Groningen. The investigation is led by the Anti-Corruption Division of the Dutch National Prosecutor's Office for serious fraud, environmental crime, and asset confiscation. In 2015, take note of the year, in 2015, the prosecution received various signals from Damen that Damen was involved in bribery of foreign officials related to vessel buildings contracts awarded to Damen. These signals came from foreign authorities that were conducting corruption investigations themselves, the World Bank, and from Damen's external accountant, Ernst & Young. The signals involved multiple projects and multiple jurisdictions in South America and Africa and led to the above suspicion. I want to remind you, Madam Speaker, that it was in March 2015 that the member for Siparia, as Prime Minister of Trinidad and Tobago and her government, the same cabinet and minister that she's afraid of, we wake up one morning and heard them telling us that they have ordered 12 vessels from Damen, like 12 loaf bread. Like they ordered 12 hops from Damen, just like that. If you hear them behaving today in response to the reasonable action of this government, you wouldn't think it's the same people who one morning just announced we ordered 12 ships from Damen. Madam Speaker, the document goes on to say, in January 2017, based on the suspicion and further investigation, the offices of Damen in Groningen was raided, and so were the offices of Ernst & Young in Rotterdam. A large amount of administration and digital data was seized. The digital data seized at Damen has not yet been made accessible to FIOD due to problems related to the attorney-client privilege contained within the data set. The physical paper administration seized by Damen is available for FIOD, which is being investigated. Madam Speaker, it goes on to say specifically, Trinidad and Tobago. Trinidad and Tobago Coast Guard contract March 16, 2015. The contract entails the construction of 12 vessels. The total contract value is 177 million euros. The investigation to date has shown that in 2016, NSG, which is a middleman, sent Damen 13 invoices with references to the Trinidad and Tobago project for a total amount of 19 million euros. Ernst & Young mentions a total commission commitment to NSG and its Trinidad and Tobago's local partner, Best Marine Limited, and the St. Lucia affiliate, 10 Degree Services, of 23 million euros. That is $210 million in corruption, in commission paid for those 12 vessels that were bought hurriedly by the UNC under my friend from Siparia, who now suddenly wake up like Rip Van Winkle and suddenly know about corruption and about procurement and all of that, and accusing everybody left, right, and center. Even those who recuse themselves, she accused them of corruption. Madam Speaker, I end on a note asking my friend from Siparia that since she's so interested in the interest of Trinidad and Tobago, could you tell us who NSG was? Tell us who got the 210 million? Tell us what procurement process was used, and tell us why you should never again be allowed to handle public money in Trinidad and Tobago. Madam Speaker, where you ever hear that you could hire a lawyer on the basis of who gives you the lowest price? Where on earth have you ever heard that you choose a doctor on who gives you the lowest price for medical services? Any of us, God forbid, get sick, you want to know who is the best doctor in that area. Doesn't matter. You go into court to face the judge. You want to know who is the lawyer that has the most competence. When the state is going, even on a small matter, there are serious consequences. Even on small matters, you have to get Queen's Counsel to go, because if you go and you lose the matter, it has big price and big consequences. You want to come and tell me we must choose the lawyer of lowest price, and then former Attorney General, trained by her, would put in his bid, be the lowest bid, and you want to ask this government, as you're doing in the party and in your government, to hire people who are disgraced, who are appearing before court still, and because they win the bid, they will go before court, not on your Nelly. Madam Speaker, We stand by our position because it is reasonable and we can justify it to the people of Trinidad and Tobago and tell them why we have done. And we do so because we are the representative of the people. And if the people don't like what we have done, they know what they will do when we go forward, because we know that they know that we will do what is in their best interest. So don't come and tell me that we should pass a law that ties the government hands to hire the cheapest lawyer, ties the government hands that hire the cheapest consultant. Madam Speaker, with respect to why the government has to have the flexibility. A while ago, we wanted to hire for good reason, as it played out for very good reason. We wanted to hire a consultant in Washington.
Prime Minister, your time is now spent.
Thank you, Madam Speaker. I'll have a lot more time on the PNM platform.
Member for Naparima.
Thank you. Thank you very much, Madam Speaker. Madam Speaker, today is another dark day in the history of this august body. When a Prime Minister, and he's leaving, a Prime Minister comes in this honorable house to defend the indefensible. Madam Speaker, I would commend our Prime Minister, our esteemed Prime Minister, to follow linguistically and otherwise his esteemed erudite and globally respected colleague, the Prime Minister of Barbados, the Honorable Mia Mottley. The Honorable Mia Mottley would not use the words like poppycock, which I heard coming from my esteemed Prime Minister today. Madam Speaker, we have been summoned here today with 3 days' notice from 12:08 a.m. on Tuesday, 1 December, to today, Friday the 4th, to discuss 5 very important pieces of legislation. Madam Speaker, that represents disrespect from the Prime Minister and his government to the opposition and the 300,000 people we represent. How could you give 5 pieces of important legislation, including the public procurement and disposal of public property, and deliberately, mischievously give us less than a half day for each bit of legislation? But the Prime Minister likes to lecture us. But the Prime Minister, the Honorable Prime Minister, and he's my Prime Minister, the Prime Minister is part of a cabinet that witnessed 57 recusals from a cabinet member and 38 from another, and nobody, including the Prime Minister, couldn't pull one aside and say, fellow minister, it's looking bad. It's looking bad. 1, 2, 3 by the 20th. And the Prime Minister could come today and tell us that it is because one owns property and the other belongs to a family that is involved in business. But Madam Deputy Speaker, they do not like to hear about Singapore. But Singapore, I want to make the point, every aspect of procurement is handled by their legislation, the Singapore law and practice. I quote, "The government procurement regulations apply to contracting authorities, which is defined under Section 2 of the Act to include any ministry or department of government, organs of state, or also statutory bodies. Every manjack in Singapore must abide by the laws, and there are no exclusion in the laws such as we have to face today, because it says in Article 1.3 on that type of contract subject to procurement regulations, it says generally the regulations apply to our contracting authorities' procurement of goods or services or combination of goods and services by any contractual means with or without an option to buy the goods or services or combination of goods or services. And it talks about rental. For heaven's sake, rental. So that if we go to rent a property owned by anybody, including a minister, it comes under the procurement legislation of Singapore. I say no more. I could go on and on that. But the Minister of Finance, bless his soul, came today and sought to lecture the media on in particular the Trinidad Express. But today, I think this is one of the first times since I've been in this house that all three newspapers in Trinidad took a stand against what the government is doing here today. The finance minister spoke about the Express, but the Guardian also, he talks, hear the headline of the Guardian today, editorial. Procurement law delay concerns valid. Not the opposition talking. That is the Guardian, which some of us believe has a soft spot for the government. The Guardian editorial ends, it is important to underscore the importance of finally putting into effect a strong law, not the weakened nonsense that is before us today. Strong law to govern all, like Singapore, all aspects of the procurement process, ensuring that the taxpayers get full value for their money. And it ends by saying, this is long overdue. Everybody, what is wrong with this disconnected P&M administration? Every manjack is telling you there is something wrong with what you are doing today. The Newsday today, it says, now the government has proposed further amendments so wide as to raise alarm among civil society and the opposition leader herself. It says, will the door remain open for bubble to continue? Lord have mercy. They have no shame. They come here and they read things. They're very good at reading inadequate, researched, and not finalized things to say the UNC corrupt. And when you get down to the courts of law and come with an opinion from the courts of law, a judgment, they have none. They're very good at that. Very good. And we will not, as I said last week, we will not take any lectures on corruption from that government. Callous disregard for the views expressed by the opposition leader, who has said strongly and firmly that we will support no legislation until the government operationalizes the Public Procurement and Disposal of Public Property Act No. 1, 2015. And I want to stress the point. This is not bringing wishy-washy legislation as you have done today. You have gutted it. And I make no bones to say you have gutted the legislation by your actions you have taken today. So we tell you we are not going to give you any support for legislation if you do not operationalize. And this is what you bring today. This gutted Procurement Act. Well, that will not succeed. That attempt to pull wool over our eyes and pass a fast one with limited time to assess the thing. In management, they call this a poison pill, Mr. Deputy Speaker. If you want someone, if there's a business for sale and you do not want someone to buy it, you put a poison pill in it. They know we will not support poor legislation, so they have put a poison pill by gutting the legislation of the teeth that it has. The Prime Minister talks about procurement and corruption that we say we say that there is a strong nexus, and the research says that there is a strong nexus between corruption and limited oversight as would result from this legislation that is before us. I quote from its info, spotlightcorruption.org. It says, and I quote, corruption is particularly common in public procurement of the foreign bribery cases prosecuted under the OECD Anti-Bribery Convention. 57% involve bribes to obtain public contracts. So we are talking about a developed country, the developed countries, the OECD, and they're saying 57% involved bribes to obtain public contracts. And 28% of UK companies participating in EU public procurement said in 2017 that corruption prevented them from winning a contract. And corruption destroys countries because it ensures that corrupt companies cannot bid for public contracts, and that is essential to protect taxpayers' money and the integrity of public procurement. There's a tremendous body of research that says if you have weak procurement oversight and weak procurement practices, that problems arise. The OECD Foreign Bribery Report 2014 provides additional evidence that public procurement is vulnerable to corruption. So the Prime Minister comes and wants us to believe that they are sanctimonious and everybody else is corrupt, and therefore they do not need strong legislation. Well, we say, and my political leader said, we will not support them at all. We will not support them at all unless they do right by the people of Trinidad and Tobago and taxpayers' money. And that is why we have no shame in saying over and over again, paying 1.6 million in rent is immoral at this time. I want to make the point that the Damon's investigation is not about the government of Trinidad and Tobago. It is not. And do not play fast and loose with words. If it is the government, call name. Call name of the minister involved. It is, about, as far as I'm concerned, some third-level person in Barbados or St. Lucia. Let the law deal with him, but don't come trying to tarnish the name of our government with information that is not substantiated. So, Mr. Deputy Speaker, they forced us to come here today. Last night I didn't sleep because I'm trying to understand this thing in the interest of the people who elected me, and not having enough time. It was challenging. But you know, they had time. They had time because since 2016 they have been talking about bringing procurement legislation and the regulations to Parliament. In 2016, hear what they say, those who are without sin on that side. They said, and I quote, this PNM administration will cut out this cancer of corruption and waste as we fulfill our commitment to the people of Trinidad and Tobago to implement a modern, transparent, and fair public procurement system in 2016. But they're slothful, they're lazy, and they're incompetent. So 2016, nothing happened. 2017, hear them, I wish to announce that it is the government's intention to fully operationalize the new procurement system in 2017. Nothing happened. 2018, quote, we envisage that early 2018 the legislation will be operational. 2019 is a shame. 2019, the new procurement regime utilizing best practice. Well, look, Singapore different to what that gutted piece of nonsense that we have before us today. They said in 2019, the new procurement regime utilizing best practice could be in place in the first quarter of calendar 2019. And in 2020, again, procurement regulations are soon to be laid in Parliament. Soon to be laid in Parliament, 2020. You see in The Guardian, January 24, 2020, Minister Colm Imbert promised the nation. He said, it is expected to be, procurement regulations are expected to be implemented by the end of March. However, while he said it would be introduced in Parliament sometime in February, it will not be in its current form as the government intends to amend Section 7. We intend to do a slight amendment. I'm quoting the Minister of Finance. A slight amendment to this clause so that if the government of Trinidad and Tobago enters into arrangement with another government for the supply of goods and services, and there's a conflict between our rules and the procurement rules of that country, then that of the other state will apply. Not Trinidad's rule, you know. The minister is saying, I quote, either I'm not seeing correctly. He says, if we enter into a government or a government arrangement with another government, we do so to this clause so that if the government enters into an arrangement with another one for the supplies and goods and services, and there's a conflict between our rules and their procurement rules, then the rules of the other sovereign state will apply. That is unpatriotic. That is immoral. Who do we have making decisions for us? Madam Speaker, it's a P&M minister, a former P&M minister, a former finance minister, and she knew finance. She didn't have a degree in engineering. She was a finance person. And she said, it is Karen Nunes Teixeira. And she is saying, and I quote, she recalled there was an issue last year over a US $71 million deal for a Chinese construction company, China Jesuba, to build houses in South Trinidad. And she said the terms were so egregious. That is a P&M talking, you know, not somebody on the side. They were so egregious and not subject to any oversight or tendering procedure. And it was, of course, Section 7 and 24 were not enacted. So you see me? I will not be party to P&M incompetence. I will join my leader and I will not happily support incompetence if you do not bring and operationalize this procurement legislation. You could fool some of the people some of the time, but not all the people all the time. So what are the issues we have with the bill in the limited time I have? The 3/5 majority, we are told, is not applicable. My colleagues will present legal arguments in that regard. But there is something immoral to a layman. When you could pass legislation by a 3/5 majority and then change subsequently amended by a simple majority. That's a way of beating the system. As the guys on the block said, that is a way of dancing the system. You understand what I'm saying if you go on the block. It's something immoral, and even if it's possible, you don't do it. There's amendments to Section 7 to make the legislation inapplicable in government-to-government contracts. I've spoken about that, and that is a Pandora's box for corruption by future governments and this government. Amendment to Section 7 of the Act to remove from its scrutiny legal, financial, accounting, auditing, and medical services. Well, what else you leave? Tell me what you leave in the Act. That the procurement legislation will be applicable. And here is the creme de la creme in wickedness. It says, such other services as the minister may by order determine. So what's going on here? And that is subject to negative resolution. So a minister could get up a morning, decide that he's going to include anything, and then the legislation is null and void and of no effect. That is immoral. That is immoral. You know, they feel on that side that some of us didn't pass for secondary school of our choice. We're not rich. We didn't get in on the 20%. We didn't get in. We had to work hard. And all of us who stand here today, whether it is Dr. Bodo or Anita Haynes, a scholarship winner, we have earned our right to be in this parliament. And you will not fool us. And Eric Williams said years ago, and this is not a racial comment, because he said when they use massa, massa is an attitude, and they were black things, but this is a colonial piece of legislation. And I wish to say today and tell the Minister of Finance, massa day done. So, Madam Speaker, as a patriot, as a citizen of this country, as someone whose education was paid for by the taxpayers of Trinidad and Tobago, I have a duty to tell those on the other side, buck up for God's sake. Buck up. Do your research. Give us time to analyze. Let us work together so that we could make good legislation. And one thing I would like to be included as an aside, to that procurement, there should be a limit on recusals by anybody, anywhere, who have an input in decision-making on this.
Okay, just before I call on the Attorney General, I just want to remind members that the language we use to describe each other in this House is either by their portfolio or their constituency. So we can see the member for Tabakit, we can say the member for Faizabad. While we are friends, we're not on first name or other name basis. Attorney General.
Madam Speaker, I thank you for this opportunity to join in this debate, and I will start by immediately telling of my surprise in listening to the Leader of the Opposition's contribution. Madam Speaker, I genuinely have to wonder what the purpose of the Honourable Member's contribution was when one has regard to the actual law. The Leader of the Opposition spent a significant amount of time relative to her allegations, dealt with in part by the Honourable Prime Minister, as it concerns my colleague, the Minister of National Security, and myself. Indeed, Madam Speaker, being a happily married man, I'm sometimes surprised at the attention I get from some people on political platforms. But what I will say, Madam Speaker, is that I don't want any of it. And permit me, Madam Speaker, to read into the record a letter dated October 9th, 2020, written to me from the Integrity Commission. The Integrity Commission wrote to me, informing me effectively that a complaint dated March 5th, 2020 was brought against me under the provisions of Section 32 of the Integrity in Public Life Act by one Dr. Emir Crown, acting on behalf of his client, Ms. Suzette Lowe, both known UNC activists. In this letter, he stated inter alia, based on information that is in the public domain, it appears as though the Honourable Attorney General benefits from the government's leasing of a particular property, etc., owned by the Attorney General 50%. In addressing the matter, the Commission goes on effectively to say that Dr. Crown was informed that the Commission was satisfied that the relevant criteria and protocols leading up to the Cabinet's decision for the leasing by the government of that property had all been met and observed respectively by all persons in public life or exercising public function concerned with. And it goes on, Madam Speaker, at page 2, to say, concerned with the execution of those proceedings and protocols. In other words, the Commission found no evidence of any breach of the Act as regards the processes and protocols followed by which ultimately led to the decision by the Cabinet for the leasing of that property. Finally, and I wish to state this in particular for the member for Barataria Sanwan, who has particular fondness of referring to me on public platforms, which fondness I want to reject immediately and say I will have none of it, nor am I interested in it. Madam Speaker, the Integrity Commission says, finally, he was informed that you had dutifully observed all requirements of Section 14.3 of the Act. And what do they mean? Of the Integrity in Public Life Act. Madam Speaker, I have started by putting that on the record because the law in Trinidad and Tobago is set out exactly as the law in Singapore is with respect to the Integrity in Public Life Act, that if you perceive you may have a conflict of interest, that you must say so. The law does not say that you cannot be a member of a cabinet because it clearly recognizes that you may have come from a different life. And permit me, therefore, to say, Madam Speaker, simply to the member for Siparia and simply to the member for Barataria Sanwan, just stop it. Just stop it. Obeying the law is not to be abhorred. Obeying the law is to be complied with and to be complimented. So get over your passions, get over your distractions, and stop it. Madam Speaker, let's deal with the submission of the member for Siparia, now absent from the chamber as usual. The member for Siparia and the member for Naparima both say that they were waiting for 6 years for the public procurement law. Permit me to refer to the bill and permit me to refer to the parent law, Act number 1 of 2015, Madam Speaker, because neither Naparima or the member for Siparia had the courtesy to do that. Madam Speaker, first of all, the allegation came that this law requires somehow, by some magic, a 3/5 majority. Madam Speaker, it is trite law that a bill is required to receive a special majority under the Constitution of the Republic of Trinidad and Tobago pursuant to the Constitution, Section 54. There are different degrees of entrenchment. You may have a 3/5 majority, a 2/3 majority, a 3/4 majority. If you offend, quite simply, the separation of powers principle, certain aspects of Section 4 and Section 5 rights, and general other principles of constitutionality. Act number 1 of 2015 was passed with a special majority because, Madam Speaker, that act in certain sections, in particular sections 42, 43, 46, and 47 of that act, infringed upon rights. They allowed for the seizure of documents. They allowed for the compulsion to give evidence. Therefore, they tripped basic rights and required a 3/5 majority. The bill today, number 1, clause 4, defines a better version of bid rigging. Who requested that? The procurement regulator. Number 2, Section 5 treats with government-to-government and international obligation rules and which will prevail versus the Public Procurement Act, and also the disapplication for certain services. Clause 6 recommends the removal of subparagraph O of the powers of the regulator, quite simply because the regulator asked for it to be removed on the basis that the regulator wanted no part of the disposal of state assets, property, for and on behalf of the government. The leader of the opposition, who, in my respectful view, breached the Integrity in Public Life Act, one can argue, in giving herself silk because she gave herself a benefit, the honourable member, of extra money as senior counsel, ought to know as senior counsel that when the regulator says he wants no part of this particular provision for conflict of interest, it must be read in the context of amendments that this Parliament made in 2016. In 2016, the law was amended to add the fact that the Minister of Finance would produce regulations for the disposal of state lands, including leases. So the Leader of the Opposition, assisted by Barataria Sanwan, cannot read the Act as amended by the 2016 Act, which specifically provides in law the mechanism for the disposal of state lands. No, Madam Speaker, the Honourable Member for Siparia can't do that. Madam Speaker, the procurement regulator in Clause 7 asked us to not debar people from procurement proceedings simply because they had any criminal offense. That could be selling rotten tomatoes under the Municipal Corporations Act, under the Summary Offences Act. The procurement regulator asked us for persons involved with fraud for a limit of 3 years. We disagreed. We said, no, we want 10 years. After 10 years, your record will be clean. The procurement regulator asked for a further enlargement of time, and I'm going to come to that, to deal with enforcement proceedings or objections under the law. And the procurement regulator asked us to define the definition for a relative within conflict of interest aspects and who is excluded. Lastly, there's an observation because of proclamation as to how we treat with the tenure of people upon proclamation of the Act, assent of the Act versus proclamation of the Act. So permit me to do this. Madam Speaker, I encourage the media and especially the opposition to simply, in this case the opposition, read the law. Read Act number 1 of 2015 as amended by the Minister of Finance twice, and you will firmly understand that procurement is to be undertaken by procurement processes established in entities having procurement units. There is no circumstance where the Cabinet is engaged in procurement. The Cabinet makes decisions which are then actioned in a number of ways. And it is shameful and a betrayal of the holding of a legal degree for the Leader of the Opposition to want to tell us that the Cabinet is procuring, Madam Speaker, in the fashion the Honourable Member described. Madam Speaker, the fact is that the procurement regulator is the only person at law who can develop the regulations for submission to the Minister of Finance under the Act itself. Those regulations must come to the affirmative resolution passage in this House and in the Senate. The Public Procurement Regulator was appointed on the 12th of January 2018. And Madam Speaker, the Public Procurement Regulator cannot have an operationalized act unless the Office of Public Procurement Regulator gets on with the production of guidelines, manuals, e-procurement system, hearing rooms, electronic filing, and the host of things set out in the Act. There is no role and responsibility by way of initiation of decision in the Minister of Finance or this government. Naparima, who has also fled the chamber, is not able to understand that you could have passed the law 6 years ago, but Madam Speaker, it is only when the Public Procurement Regulator was installed that the regulations could start. As a matter of record, Madam Speaker, I received from the Public Procurement Regulator's office on the 13th of October 2020 the draft Public Procurement Regulations. And on that date, Madam Speaker, after we had had meetings 12th March 2020, 8th April 2020, 4th May 2020, 14th May 2020, 22nd July 2020, 14th September 2020, 7th October 2020, meetings and exchanges of correspondence respectfully in that basket. The Office of Public Procurement Regulator supplied us with regulations which demonstrate that for consultancy services, let me repeat that, in Part 7 of the draft regulations, consultancy services, attorneys at law, medical services, etc., that you would have to engage in a suite of provisions to get there. If you want to engage in public procurement involving consultancy services, Madam Speaker, you would effectively have to have a choice. You would have to have, Madam Speaker, under selection of consultants, either technical or commercial proposals combined in a single or double envelope system. You would have, Madam Speaker, to have a short listing of consultants. You would have to have technical and commercial considerations. You would have to effectively use either quality and cost-based selection, quality-based selection, fixed budget, least cost selection, consultants qualifications. And Madam Speaker, you would have to have at least 3 shortlisted candidates and go through a public procurement process. Now, Madam Speaker, in the Office of the Attorney General, Ministry of Legal Affairs, and in any ministry where legal services are required, Madam Speaker, that methodology simply cannot work. I put on the record now that I spoke with the President of the Law Association, who confirmed that the Office of the Public Procurement Regulator met with several members of the association, and all of the members of that association confirmed to the Public Procurement Regulator that the retention of legal services under this methodology simply cannot work, Madam Speaker. And they cannot work, Madam Speaker, because of what the law itself says. The Public Procurement Act, Madam Speaker, tells us what is to happen as we deal in particular with challenge proceedings in Part 5. Part 5 of the legislation, sections 49 to 53, deal with the fact that you have to have challenge proceedings. But, Madam Speaker, what the Leader of the Opposition is not telling you, and certainly I'm confident that other speakers following me will not on the opposition side, is that you have a maximum of 135 days of risk to procurement if we accept the methodology of the Public Procurement Regulator recommended in Part 7 of the draft regulations. To use that system, you apply it to the Act where you have public procurement challenge proceedings. Here's what happens. The minute somebody is invited to tender all 3 people, and you choose one, you have to tell all 3. Those 3 people then get to put in a review application. The review application must be heard within 7 days, and then after that, a decision must be given within 28 days. It's called 20 working days. After the 28 days, you then have 30 days to get the written decision. After 30 written days, you then have 21 days to go before the Public Procurement Review Board. After those 21 days, you have 28 days to go through the process of having a decision, Section 51K. You then have another 21 days, Section 51M, to appeal to the High Court. Madam Speaker, in other words, if you want to retain an attorney at law on an urgent basis, Madam Speaker, and you don't abuse the spirit and intent of the law as set out for emergency provisions, you would expose yourselves, in the Ramlogan-Ramdeen example given by the Minister of Finance, to them being invited, submitting the lowest cost, found out that the member for Port of Spain South received the brief by public procurement, they would object, and 135 days later, the matter still hasn't started. No lawyers appointed. That, Madam Speaker, in the UNC world is a perfect paradise for obstructionism, because, Madam Speaker, it is the UNC that is currently challenging the Interception of Communication Act. It is the UNC that challenged the public procurement legislation the Revenue Authority elemental pieces built upon valuation of lands and to look at property taxes. It is the UNC who has said that they will challenge every aspect of the law. You see, Madam Speaker, when we hear the member for Naparima say that it is unholy and that we ought to look to the law of Singapore, where was the member for Naparima when I pointed out in the law of Singapore, possession of a firearm is exposure to the death penalty? Where was the member when the honorable member for Naparima and the ridiculous submissions coming from the leader of the opposition that there is no precedent for this type of exception we cause to Section 7 of the Act? Madam Speaker, permit me to put on record, coming from no less an entity than the public procurement regulator himself, the following laws. Jamaica Public Procurement Act 2015, Guyana Public Procurement Act, Grenada Public Procurement and Disposal Act, UNCITRAL, Kenya Public Procurement and Disposal Act, CARICOM Model Public Procurement Bill, Uganda Public Procurement and Disposal Act, Philippines Public Procurement Law, all of which say that the priority is to be given to the government or to the international lenders, Madam Speaker, all of them. But today, we have to listen to the member for Siparia and the member for Naparima tell us that this is an unholy law. Madam Speaker, the elemental pieces that cause the operationalization of this act require the public procurement regulator to also be assisted by the appointment of the Public Procurement Appeal Panel, Madam Speaker. Only the President of the Republic has the opportunity to do that. Until the e-procurement systems are built in, until the structures are put together, the law cannot be proclaimed, Madam Speaker. And for the record, Madam Speaker, I have no conflict of interest that I have not declared in proper circumstances. Yes, Madam Speaker, I come from a business family. Yes, Madam Speaker, I recuse myself when appropriate to do so in every forum, including where it is I have investment in medical companies, etc., long before I came into public office. You see, Madam Speaker, I have declared all of those things to the Integrity Commission as well. And Madam Speaker, I make no apology for complying with the law. I confess that I take legal advice on the issues before I engage in consideration of public procurement or in consideration of matters of conflict of interest, and I will not accept and I reject the member for Siparia and her newfound assistant, the member for Barataria San Juan, on their fulminations on public platforms as to what is proper or not proper. Only they wish that we would be guilty on our side of failing to comply with the law. Madam Speaker, I thank you for this opportunity.
Member for Barataria San Juan.
Thank you. Thank you very much, Madam Speaker. Madam Speaker, thank you for recognizing me to join this debate on an act to amend the Public Procurement and Disposal of Public Property Act, Act number 1 of 2015. And Madam Speaker, after listening to the Attorney General, what I can say that shouting is not for the Parliament, but for the market. And maybe you should leave the shouting outside and really deal with the issues that are before us. What I heard was an extremely weak justification, a feeble attempt to justify an amendment to one of the most groundbreaking pieces of law in this country to water down and remove the teeth of the legislation. And they have exposed themselves, Madam Speaker, because they have indicated the reason why they want the law to remain as it is. Because when one person who sits in the cabinet, who is the Attorney General, can get $43 million in rental every 3 years, why will you want the law to change? And when one financial company benefits millions of dollars in interest payments, why would you want the law to change? why would you want those contracts to be scrutinized by an independent body, the procurement regulator? So they have exposed themselves to the reason why they want the law to remain as it is. They want the status quo. Because while thousands of our citizens are suffering on the outside, we have a handful of individuals in this country benefiting billions of dollars. And when the Attorney General can receive $43 million in rent, we have persons who are still yet today to receive $1,500.
Orders 48.1, 48.4, 48.6. There isn't even one to describe untruthfulness. That's a gross untruth. And I'd ask the member to stop it. Just stop it.
Attorney General. Attorney General. Yes, please. Yeah, well, you can't withdraw by saying it again, so you withdraw. Yes. Thank you very much. Member, I'd ask you to please refrain from that and continue. Please refrain from that.
I will move on, Madam Speaker. And Madam Speaker, what we have heard from the Attorney General is that a lot of talk about the timelines regarding the scrutiny of certain contracts. If we look at the amendment to this legislation at Clause 5, which amends Section 7, which now removes from the remit and the jurisdiction of the procurement regulator legal services, financial services, accounting and auditing services, medical services, or such other services as the minister by order determine. It means that any of these transactions or matters relating under these categories will no longer be captured under the framework that was established by the parent act, which is the Public Procurement Act. And the reason why the government at that time would have passed this law is because they understood that there is a need for good, transparent, and proper governance and accountability when dealing with public finances. Now, I am very disheartened to hear the Attorney General, who is the defender of the public's interests, come to this Parliament to defend such an egregious amendment that goes directly to the heart of transparency, accountability, and good governance. How could you stand as the guardian of the public interest and defend this amendment? This amendment effectively will create room and space for corruption. That is what it will do. This amendment will do that. Because, Madam Speaker, when you have levels of internal controls and accountability when it comes to legal fees and financial services, accounting, auditing, medical, you would understand that you need the procurement regulator to have some level of control and jurisdiction over these matters. And I heard that the Minister of Finance speak about a letter that was given to him by the procurement regulator, that he is comfortable with the amendment found at Clause 6, which is the removal of paragraph O in Section 13. But what the Minister of Finance didn't tell us is what was the view of the public procurement regulator with respect to Clause 5. He forgot to tell us that, or he deliberately didn't tell us that. Because there is a media release, Madam Speaker, where the public procurement regulator stated that he is totally against Clause 5, which amends Section 7. He's totally against it. He wants nothing to do with it. The procurement regulator wants to ensure that...
So we can deal with it in debate?
Yeah. It seems as though the Attorney General is unaware of this very important release. It's Public Advisory Number 15, 3rd of December 2020, Office of the Procurement Regulation, Madam Speaker. So we are bringing to the floor the issues that the persons, the stakeholders who are in charge of this legislation want, but yet the government is going diametrically opposed to this. Madam Speaker, when this amendment is passed, it's best we change back the name of the legislation to the Central Tenders Board, because you are going back to the CTB. You are effectively going back to the CTP. There will be no difference. You have watered down, you scrapped the legislation, you came, it was passed in 2014. The last government tried as much as it can to get this thing working, set up committee, partially proclaim the act. They came twice already to water down the legislation. One was the disposal of state lands. The other was to reduce the length of time of the procurement regulator. And now this time to come to exempt important services that should be under the scrutiny of the regulator. No, Madam Speaker, that cannot happen in this country. We must listen to the voices of the people out there. You have persons from the JCC, the Joint Consultant, the Afra-Raymond. You have all of these other civil society groups shouting at the government to hold their hand on this amendment, but yet they are going full speed ahead. And we heard the reason why. Because the Prime Minister stood in this Parliament and he said that because we are elected, we should be responsible for that. While you are elected, Madam Speaker.
Standing Order 53(1)(b). The third speaker to be talking about the same point.
Okay, so I'll give you a little leeway. Please continue.
It seems as though the Attorney General is a little troubled. But Madam Speaker, the Prime Minister stood and said that because you are a represented person in government, you have the right to deal with the procurement of goods and services. That is what the Prime Minister said. But what the Prime Minister forgot to tell the country is that you took an oath of office to uphold the Constitution and the law. You perform a fiduciary duty to the citizens of Trinidad and Tobago. So because you are elected...
One, please, Madam Speaker. I can't even understand what that is in relation to.
Which law? What are you talking about?
And please continue.
Madam Speaker, I can now understand why the Attorney General spent so much time in law school. But when you listen to what the Prime Minister has said, the Prime Minister has said that you have to look at government-to-government contracts. This is also being exempted. I agree that there must be some level of interaction, communication between government to government. But why are you removing from the regulator that scrutiny? We haven't heard a proper reason why, at this stage, that they are removing that level of scrutiny. Because we can see what happens when there is a level of international and government-to-government contracts. There are various examples. Right now, we are seeing what is happening with the hostile ships in Australia, that the procurement process for that particular deal is still clouded in a level of secrecy. We have seen what happened with sandals, that deal had to collapse, and the government said that they are very...
1B, Madam Speaker. Sandals again.
Nonsense.
Please continue.
Thank you very much, Madam Speaker. And Madam Speaker, when the government said, and the justification is that they will be held accountable by the Parliament, so therefore they can go ahead and exempt these services, what that simply means, Madam Speaker, is that we are passing a piece of legislation to ensure that there's a level of scrutiny. So when you look at the sandals deal, I'm going to give this example. We had filed several questions in this very Parliament, and we did not get the answers from the government. We have tried our best to get the answers, but it is only when we took the matter to the court we were able to see the memorandum of understanding between Sandals and the government. At that stage, we were able to see the amount of concessions, tax breaks that the...
On Standing Order 48(1), in all honesty. We're not even amending that section of the law.
So, I don't think anything any member in here would say I will consider dishonest. So, no need to tell me in all honesty. But I'll say to you, member for Barataria Sanwan, I have to uphold the Standing Order 48(1) at this point. Okay?
Madam Speaker, let me address the point that the Honourable Minister of Finance had raised. The Minister of Finance had raised the point that one of the other justifications for this particular amendment is that it will cause a level of frustration with respect to the contracts. That if a contract is ongoing, that some person might enter the courthouse and have the contract reviewed via judicial review. So that, therefore, it may make it a bit difficult, and it will have persons being a little more uncertain to enter into agreements and contracts with the government because of the uncertainty. But, Madam Speaker, the reason that we are passing this particular law is to give avenues to those persons who are treated unfairly. Because you have to have the playing field leveled. You must have a level playing field when it comes to the procurement of goods and services in this country. Why there's only one group of contractors would be allowed to get contracts when there are other persons who are disenfranchised? That is why, Madam Speaker, you have legislation like this to even the board. Because when you do these things, you encourage participation from the wider population. So when you exempt all of these services, you will have one particular attorney from the Office of the Attorney General who may be getting all the briefs. And he may be appointed to state companies, and he may be representing certain members of the government. So that is what we're trying to control. We are trying to control, Madam Speaker, spending by this government in a more transparent and effective manner. Because what happens is that when monies are lost through corruption, it reduces the goods and services of individuals in this country. And I want to go so far, Madam Speaker, and the Leader of the Opposition, who had a very brilliant contribution, would have raised the point with respect to the need for a special majority. And, Madam Speaker, the history of this bill, the Parent Act, was passed with a special majority. It required the support of both sides of the Parliament. Now you are bringing this particular bill that is before us with a simple majority to amend a special majority bill. Now, the point that I'm making, Madam Speaker, is this, is that enshrined in our Constitution is that Trinidad and Tobago is a sovereign democratic state. And what that implies, it implies that you must have the separation of powers, you must also have the rule of law. And the case that the member for Siparia, the Leader of the Opposition, referred to was Belize International Services Limited and the Attorney General of Belize, 2020 CCJ 9. And this is in the appellate jurisdiction of the CCJ. And this case, Madam Speaker, went on to speak about that particular preamble of the Constitution, which is very similar to Trinidad and Tobago, that there must be a level of fairness, equality of treatment. We have seen other pieces of legislation being struck down because although it did not infringe a Section 4 and 5 right, it may have infringed or run afoul of the separation of powers doctrine. For example, the case of Koirati coming out of Mauritius. So what this case said, essentially, Madam Speaker, is that there's a deep structure, and the deep structure has the separation of powers, the rule of law, and the independence of the judiciary. So basically, what happens is that you have two systems that run. And if you disenfranchise a certain system, then you are going to trip over some rights in terms of the equality of treatment, the fairness of treatment.
I rise on Standing Order 55-1B. This was word for word read out by the Leader of the Opposition. Respectfully.
So, again, Member for Barrier Samuel, I'm going to give you a little leeway, but all of your contributions thus far is ground that has been traversed extensively by a number of your own speakers. Okay, you yourself reference the Leader of the Opposition. So I'm going to give you a little leeway, but I'm not going to allow you to repeat for the rest of your contribution ground that we have already traversed.
Sure. And Madam Speaker, I take your guidance, and I thank you very much for your guidance. And what the basic point that I'm going to just end on this point is that there's a need for a special majority, because at the end of the day, this particular piece of legislation will cause it will create a level of discrimination and inequality of treatment to other individuals if it is passed in its current form, and it can in fact be struck down by the courts. So, Madam Speaker, I have 5 I believe 4 minutes left again to end my contribution. So what I'm going to say, Madam Speaker, is that we totally reject this amendment to this particular act. What I'm saying, Madam Speaker, is that this does not foster good governance at all. This is actually creating the dictatorship we have seen in this country by this present government with respect to their legislative agenda. We want to ensure in this side, Madam Speaker, that when we pass laws, that a bus shed doesn't cost $700,000, that one person does not get $43 million in rental, that there's no more fake oil scandals in this country, Madam Speaker. We want to ensure that the persons of Trinidad and Tobago and all of our citizens benefit through good governance, transparency, and accountability. And I thank you very much.
Member for Port of Spain North, St. Anne's West.
Thank you very much, Madam Speaker. Madam Speaker, I enter this debate today thinking very seriously about what this country has endured in the past few decades, when successive governments have had to go through procurement, and some have failed to protect the taxpayer willingly, some may argue unwittingly. And I was recalling as I sat there the genesis of this act, the Parent Act that we're seeking to make certain amendments to today via the current bill. And I was recalling my time when I was given the opportunity to serve as a temporary opposition senator. And the Parent Act was before the Senate at that stage. And these exact points were raised at that stage. The points were raised about having certain exceptions to the need for the procurement that is outlined in the parent legislation. And that's really one of the issues we're dealing with here today. To try and bring this debate back to the bill that is before us, if you would allow me, there are a few points I'd like to start by making. The first that has been missed by most is the definition of bid rigging. And the new definition that is being proposed for bid rigging is something that should not be opposed. Bid rigging will now mean collusive price fixing, anti-competitive behavior designed to unfairly influence the outcome of a competitive tender process in favor of one or more bidders. And as I read this definition, it brought home one of the cases that I referred to in last week's contribution, and the whole EMBD process and the litigation that is presently before the court on behalf of EMBD and the allegations made in there with respect to cartel behavior and bid rigging. But let's get to the meat of the bill here before us today, which is what is the Section 7 amendment that's being proposed. You see, I've listened carefully to the very weak arguments being made with respect to government contracts. And I recall in 2014, 2015, when we were debating the parent legislation, this was a big point at the time. And there may be many voices outside there who are screaming that they don't want government-to-government arrangements to continue in the manner that they are here, they have been taking place now, for very selfish reasons. And that's something the population and the public must always be aware of. Always listen and try and work out what is the agenda Is the agenda really the protection of the public's interest? Or is the agenda for those who are saying to subject government to government arrangements, to the strictest of sections of this legislation, to protect their own turf? And what I want to tell the population of Trinidad and Tobago here today is that it would grind to a halt the government-to-government arrangements that have taken place for decades and the government-to-government arrangements that are favorable for the people of Trinidad and Tobago, if those arrangements would be subject to the full gambit of this piece of legislation. So we reject that outright. Because what you're basically saying is you can't not only not trust the government of Trinidad and Tobago, but you can't trust the government of the other country with whom you're entering into an arrangement. And I take offense to one of the brushes being painted here today, which is the procurement of the vessels from the Australian people. Because you see, there is no shroud of secrecy, as just suggested by the last speaker. The last speaker, unfortunately, is getting himself very caught up, I observe, in just making these wild accusations and statements, and the last speaker is now becoming that person that the opposition pushes out there to throw these wild accusations. There is absolutely nothing secret about the procurement of the hostile vessels and the INCAT fast ferry. Nothing. The Prime Minister of Australia, the then Prime Minister of Australia, Prime Minister Turnbull, in speaking to the Prime Minister of Trinidad and Tobago, Dr. Rowley told him, listen, Trinidad has a history of using Australian fast ferries. We're in need of some fast ferries. We also want to increase our border patrol capabilities, and the Prime Minister of Australia is the one who said, listen, we've just started a new defense fund. Come and take a look at it. And invited the Prime Minister of Trinidad and Tobago to have a working visit in Australia. And I was on that trip. So there is no secrecy. We did not spend a single 24-hour period in one place in Australia. We had to literally be on planes every single day, moving from meeting to meeting, shipyard to shipyard, with the greatest levels of transparency. Every single day, the Prime Minister demanded that we put out a press release showing where we had been, the shipyards we had been to. When we returned from that trip, the Cabinet appointed a special committee. I chaired that committee, but it wasn't only of Cabinet members. It was of experts from UTT, maritime engineers and experts, attorneys at law, and then invited the two shipbuilders to Trinidad and Tobago to compete for the taxpayer money of Trinidad and Tobago. And by doing so, we got the best price for the people of Trinidad and Tobago, unlike stumbling on a dockyard somewhere in China and saying, I want one of those. And that is how the government does government-to-government arrangements in a proper manner, and we will continue to do so. So to sit here and listen to, oh, how did you all procure those vessels, and there's a shroud of secrecy, it is absolutely untrue. That's the first thing I wanted to deal with. So all of this attempt to mislead the population that there's something surreptitious, something wrong with government-to-government arrangements, and therefore they should be subject to the normal rigors of procurement. It simply doesn't work that way. Another benefit of government-to-government arrangements, Madam Speaker, through you to the population, is that you very frequently have the government of the country that you're procuring from making financing arrangements. So built into that financial arrangement system is also oversight. The Minister of Finance talked about EFIC. One of the meetings we had in Australia was with EFIC, which is a government bank that is providing the financing for these vessels. And we were able to access those good terms of financing because we had serviced all of the loans of the past with EFIC. But what the opposition and others don't want the population to know is these financial institutions protect their money. So they have built into the whole financial arrangement ticks and boxes that you must go through, hoops that you must go through to make sure things are done properly. So that is built into government-to-government arrangements. Now, let's get to the meat of all of the noise, all of the fallacy, all of the misleading commentary that I've been hearing, not only here today, disappointingly, but also on the outside. And you see, Madam Speaker, what I'm referring to now is the proposed amendment to Section 7.5 of the Act, where we're saying that the Act, meaning the Public Procurement and Disposal of Public Property Act, shall not apply to the following services provided to public bodies or state-controlled enterprises. 1, legal services. 2, B, financial services. C, accounting and auditing services. D, medical services. Or E, such other services as the minister may by order determine. Everybody knows exactly as the Prime Minister said, when it comes to legal services, you don't often put people to the rigors of a tender process for legal services. Exactly as the Attorney General said, you may have an injunction, you may have something quick that needs to be done now, immediate advice. You must have the ability as a government to go to the attorney of your choice based on competence, sometimes also based on the confidentiality or the confidence in dealing with the attorney you want to choose. Which government in the world has their hands tied in being able to choose an attorney? And if there's something wrong, as happened in 2010 to 2015, where unprecedented spending in legal services took place, there's a forum for that. $1.4 billion spent in 2010 to 2015 in legal services. But that is not a reason to tie the hands of a government from choosing the lawyer that they want. No, and I wanted to get to this point. I've avoided the conversation. I've not responded to the attacks. But today, to sit and listen to once again the member for Siparia, who every week wants to talk about me recusing myself 57 times, through you, Madam Speaker, I will now place on the Hansard for the people of Trinidad and Tobago what that is about. Because you see, the member for Siparia wouldn't know about decency in public office, and I'll come to that. I will provide the evidence to Trinidad and Tobago here today why I say that. But first of all, let me explain. There is nothing wrong with recusing yourself. Recusing yourself by definition is doing what is right, and I make no apologies. I continue to recuse. But through you, Madam Speaker, and they're trying to cloud it in financial services, let me explain to the population as quickly as I can. Every single time the Ministry of Finance goes out for financing, they invite all of the financial institutions, all of them. The technocrats at the Ministry of Finance, the experts then analyze it. Interest rate, tenor, whether it is going to need security, etc., etc., etc. What are the fees being charged? And they then put forward what is the best deal. That will continue to happen. It has happened from 2015 to now, and it will continue. So there is a very strict rigor, a test, an analysis being done on every single one of those occasions. And out of that, less than 3%, I think it's 2.7% of the financing for the state between 2015 and 2020 was won by NCB Global Finance, the bank that they all like to scream about. My younger brother is the CEO of NCB Global Finance. So with all of the decency that I've been brought up with, the understanding of the law, I took the decision from day one, from the time a note comes to Cabinet, once it mentions NCBGF, I am not going to participate in the conversation. And to hear that I am constantly, every week, including here today, having to be accused of doing something wrong, there's nothing wrong. That bank is not owned by the Young family. My younger brother works for the bank. He is an employee of the bank. And they have only won less than 3%. 3%. Not even the 10%, the 20%, the 30% kickbacks we've heard about. 3%. And I took a decision, once that bank is mentioned, I recuse myself. I make no apologies for it. None. And I take serious offense to having to sit here and listeners, the Young family does what is decent, and to be accused of doing something that is wrong. And I'm going to read something now into the Hansard. It is as a result of some forensic work done into a company called GISL, Government Information Services Limited. And you will never find anything like this with a member of the Young family's name on it. So what I am being accused of wrongdoing is by recusing myself, and I reject that. This is an email from somebody called Anthony Dial to Vasant Bharat, who is now a pariah, somebody who they don't like in the UNC, but he was then a minister of government. And CC'd in this email is to do with government work at GISL. CC'd in this email to do with what is being carried out at GISL on the 28th of December 2014 at 10:46 in the morning, a Sunday, from Anthony Dial to Vasant Bharat, bharatv@gov.tt, so a government address. CC'd is a Gregory Bissessar. Greg Bissessar, GREGBISSESSAR @gmail.com. So don't sit here, don't stand up on a platform every Monday night and attack when this is what you were part of. This is what you were encouraging. So a government minister from a government employee of GISL is copying the husband of the then Prime Minister. And I'm ashamed that the member for Siparia isn't here to listen to this. And it says, subject, analysis of social media, etc., re-billboards. Because you see what was going on here is the use of taxpayers' funds, taxpayers' money to promote UNC under the government. And the husband of the then Prime Minister is in the center of it. And the question has never been answered why Gregory Bissessar, Greg Bissessar @gmail.com was copied on this. But I must sit and listen when I recuse myself, which is the correct thing to do, not participate in decisions related to finance. That as the result, when it comes to cabinet, it is at the end of the competitive tender process. And let me tell the population, subject, analysis of social media, etc., re-billboards. Minister, this is an analysis still going on based on a trawl of all social media. As you see, the positives far outweigh the negatives. There are a lot of neutrals, but what happened is that the many negatives tended to be well-known people in the politics. What is clear is that apart from you and Suruj, the PP support kept their mouth shut and did not support. Interestingly, ministers have rapid responses, etc., but do not throw these assets on the side of the party. So it's an admission that ministers were using government funds for rapid response teams on their own behalves. Do not throw their assets on the side of the party or the Prime Minister when needed. So why wasn't Prime Minister copied? What is a husband being copied? Was he a public servant? Was he on a payroll? Had this happened, the initial reaction would have been vastly different. What I would like you to look at is the mechanism I'm using. It could be faster and provide instant reaction to any issue if you wish. It is part of the Project Icon social media component, which I'm soft launching in a few days. Of course, this capacity together with another asset that I will have on board will not be public. So that is surreptitious behavior, but will give us the ability to measure how much more closely and influence social media. Is this the Cambridge Analytica plan? Also, I sent you a preview of what our daily M&E fieldwork will produce. So we will be ready way ahead of anyone else in terms of public opinion research. It is something we will need to discuss on your return. But this report tells a story, and it is useful for you to look at its potential. Tony.
Madam Speaker, 48-1, please.
Overruled. Please continue.
I expect that. Because you see, for the first time, I'm placing on the Hansard a response to these malicious attacks. A response from hypocrite. This is a response to the hypocrites. Because you will never see an email like that with anybody from my family to do with the government. And I am being accused of some wrongdoing by recusing myself. So I say there is nothing wrong with including financial services, accounting and auditing services, because the government and the Ministry of Finance will continue to do what they're doing. So to keep trying to throw me into this conversation, I reject it. And there's a lot more of this. There is a lot more of it. But it is time that the people of Trinidad and Tobago know the hypocrisy. There's one other thing I'd like to respond to, because I don't want the population to be misled. I don't want the population to be misled about the last part of the contribution from who I thought was a young lawyer that had a future, the member for Barataria Sawan. He just made the most astounding proposition that I've ever heard come from a lawyer in this chamber. He's saying that this bill here today requires a special majority. He's saying that a simple majority and a special is needed. We have come with a simple majority to amend a special majority act, and there's a need for a special majority. Wrong. The parent legislation was already protected by the Constitution, by the parent legislation having the special majority. And what that means in law thereafter is amendments can be made, because the whole bill, an amendment is a change to the existing act. And then if the existing act has something that is changed, it is already captured by the first special majority. So don't attempt to mislead the population. So, Madam Speaker, I see you nodding at me. How much time do I have left?
Your time is now spent.
Thank you very much, Madam Speaker.
Member for Oropuchis.
Very much, Madam Speaker. Madam Speaker, it gives me no pleasure to intervene at this time on a bill that we have before us, an act to amend the Public Procurement and Disposal of Public Property Act number 1 of 2015. Madam Speaker, I've listened attentively to speakers on both sides of the House, and I would just, in my few minutes, seek to comment on a few of the issues raised. The Minister of Finance, if I can just begin there, because we began there, began with his grave difficulty with the newspapers and, in his sagely manner, decree that the media was becoming more and more amateurish and unprofessional and lacking in research and lacking in stature and lacking in everything because they disagree with him. But, Madam Speaker, it was both the Express, Guardian, and maybe other newspapers that disagreed so vehemently with him. Madam Speaker, I begin by saying that the Minister of Finance should admit that this amendment was drafted by John O'Halloran and Francis Privat. I think they drafted this amendment bill from some far unknown place with influence, with might, with an invisible hand. They came into the Ministry of Finance and drafted this amendment bill. John O'Halloran and Francis Privat. The younger folks may not recall, but it was ministers such as these under former PNM administrations that plundered, raided, emptied the treasury of Trinidad and Tobago, so that today when we go to a place called Scarborough in Canada, we can see taxpayers' money 45 stories high. And they would have brought this amendment because they would have known what they were doing. Today I have no apologies to say that the ministers and members on the other side came today to butcher the bill. They are the butchers of Port of Spain. When I have read this particular amendment bill, because the heart of the bill has been removed. Madam Speaker, others before me spoke about the December 3rd letter, public advisory from the Office of the Procurement Regulator. I will cite it, but not get into it. But I wanted for the record just to place on the record today that the Prime Minister took an approach, and the Minister
in which they said the government understands what it is doing. The problem in this society is the American Chamber don't understand. The problem in this society is the Trinidad and Tobago Chamber of Commerce don't understand. The problem here is the Trinidad and Tobago Manufacturers Association lack an understanding. The problem today is the Trinidad and Tobago Transparency Institute don't know what they're saying. The problem today, Madam Speaker, is the Trinidad and Tobago Local Content Chamber is clueless. The problem today, according to them, is the Joint Consultative Council for the Construction Industry got it wrong. The problem today is everybody got it wrong, but they got it right. That is their argument. So, Madam Speaker, it cannot be in a society like this, all these institutions got it wrong. Our job today is not to argue who more corrupt than the other, who thief more, who thief less. I think we turn off the national community with that type of thing. I just think we turn everybody off. Forget who did this and who is trying to change it today. Who is trying to change it for the better? To ensure that what has happened before, if you believe is wrongdoing, does not occur tomorrow and day after. That is the challenge here. It is not to go backward in the review mirror and this one did this one said that, this email came from that. Email came, this is the 10th time the Minister of National Security raised an email involving the member for Siparia's spouse or so. This is not the first time. If there was wrongdoing between 2014 and 2020, but surely the police, the DPP, would investigate and bring those who have committed a wrong to justice. But they come every time. This is the email, and listen to this one. So they are trying to distract. All week we had to look at this. The Minister of Finance tell him to distract. The king of distraction. Somebody told him it is in the papers, he's too stupid to be corrupt. And he chased them away. Not saying that he had a duty to report them to the police for seeking to bribe a public official. And one wonders when he chased them away, whether it was for them to go back and review the figures and come back with a better offer. One wonders, because had it not been the case, that would have been properly reported to the police. That is an offense against the law to offer a bribe to a public official that way. Madam Speaker, we heard that. Then another one on the other side talk about doubles and so on for the week. Then we had, coming down to the end, distraction after distraction. But what was very instructive this week, Madam Speaker, is that this bill, the government gave notice to the opposition that they are coming today with this bill. But Madam Speaker, this bill, unless I am wrong, was laid in the House today. Meaning, it is the first time it became public information. So a matter so controversial, of such weight, you lay it in one day, debate it in one day, seek to pass it in one day. The older heads would remember something called the Industrial Stabilization Act. This is what they did. They brought it in one day to 2 houses of Parliament. I will not be surprised if later tonight at 11 o'clock the Senate is meeting. I won't be surprised. This is their modus operandi. Madam Speaker, the public at large could not have had sight of this bill as a public document until a few hours ago. And that is a travesty of justice. That is undermining our democratic system. This amendment is not to amend some act to put in, change the number of weeks from 2 weeks to 3 weeks. This is gutting the most critical and revolutionary piece of legislation this country has passed in decades. And no public notice. Don't tell me they had it because somebody sneak a copy and give somebody. It was not made public, Madam Speaker. And the government stands today exposed on that count. The Prime Minister came, and Madam Speaker, he jumped high, he jumped low, he went to the left, he went to the right, talking about the Damen shipyard. It was not the first time he did this. We heard that before, it is on public record. The government of the Netherlands launched an investigation into Damen shipyard and so on, dealing with all their business globally, not in Trinidad and Tobago alone. But the Prime Minister don't want to tell us they investigated in Germany, in Barbados, in I think Czechoslovakia, Czech Republic. They investigated in other parts of the world. He didn't want to tell us that. He wanted to pin down Trinidad and Tobago because that suits his purpose. Again, we are dealing with 3-4 years. If anything had happened and persons or institutions have been brought before any court of law, surely you have had time to deal with that. Today, the Prime Minister, teasing the population, tell me who is this and who is that and why they got this. And as on a related matter, the Prime Minister and the Minister of National Security. I want to ask frontally the Prime Minister and National Security Minister, if in years to come, a Prime Minister, hypothetically, named Smith, and a Minister of National Security named James, hypothetically, and Smith and James go to England, and they say, we meet in Prime Minister to discuss buying a boat, and that means there's no corruption because the Prime Minister and Minister do it themselves. This is not the Pope and the Dharmachar. This is not the Imam and the Pundit. These are two politicians. We are not casting aspersions on their integrity, but we are saying as politicians, you ought not to get involved in procurement. And it befuddles me that they don't understand the point. Their point is we are honest people, so anything we do is good. How you could look at people like Diego Martin West and Port of Spain, North and Central, and say, we're doing anything dishonest. How dare you do that? That's the argument. The argument is not that. The argument is you cannot go, and we hear about Prime Minister Turnbull, I think it is. Now, I don't know Mr. Turnbull. I don't know where he came from. I don't know where he went to. I have respect for head of state and head of government and so on. But that doesn't mean you are infallible because you are the Prime Minister. All over the world, heads of government and heads of state, when they leave the state office, they go to the state jail. So saying that two prime ministers met in London and said, I need a boat. He said, long time we're doing business with you. Come down, come, let's take a look. That doesn't make it right. That doesn't make it right. The Minister of National Security admits in the most bewildering fashion, I personally went to all these shipyards. I looked at it. It looked good. We get the best price. He's saying, trust me because of who I am. The issue is not who you are, it's what office you are. That is the issue. And the minister from Diego Martin as well, Minister of Finance, I hear it again. The former Prime Minister member for Siparia went to China and she saw a boat and said, I like that, give me that. How you know that? You went to China? Were you in a handbag? Not that you could fit in her handbag, but were you in a handbag that you knew where she went and what she did and what boat she pointed to? They announced this with fanfare as if they were there. And I won't say he's big enough to fit in the handbag, but I'm certain, Madam Speaker, I'm certain he would have no part around the member for Siparia. Madam Speaker, to continue here. So the issue is the Dutch government and related agencies are undertaking an investigation. It's a global thing. It is not only Trinidad and Tobago. When and if there are findings or persons have been accused and charged and so on, come back and tell us that. But don't use that as a sort of thing to beat, the opposition. Madam Speaker, the member for Port of Spain again made this point, and I just want to touch on it now. This matter of the recusals. Now, the issue is not the recusal as an element of law, because you have to recuse yourself if you are conflicted. The issue is how many times are you conflicted? Suggesting that the very position you hold brings you into conflict. If it is that 58 times you have to leave a room, that suggests that the position you hold brings you into conflict. It is not an issue of the law, because you have acted according to law and process and so on, but you are conflicted. Now, I want to ask the Minister of National Security a simple question. We are always talking about recusal from Cabinet, but the member was also chairman of the Finance and General Purposes Committee, and may still be that. Did you recuse yourself from the F&GP as well, and how many times? You have the powerful position of chairman of F&GP, position held by Lenny Sate and so on before, position held generally by a Minister of Finance. In this government, they threw out Diego Martin Northeast. So you have Port of Spain, North St. Anne's West as chairman of FNGP. It is one of the most powerful subcommittee of cabinet. So you exercise influence. Every minister lobbies you. When you are FNGP chairman, ministers lobby you to get their bills. Get my note up. Could you help me with this note? We have to get this note passed. My ministry needs this. The ministers are lobbying you. And today, you leave the room, you slip out for 5 minutes and tell the ministers who need you, guys, you all be neutral and independent as my family interests. No, it don't work like that. It don't work like that. I tell the government today, if you had no interest in procurement, because in 2014, let me correct the Prime Minister, the then opposition in 2014 did not support the procurement law. They abstained. So the Prime Minister jumped up today, and as he moving from left to right, he said, in those days, the opposition used to support government, but you did not. You abstained. The record is there. It is there. They did not want it from day one. And today, I challenge this government. Have the courage. Have the fortitude. Stand up and repeal completely procurement legislation if you don't want it. If you don't want it, repeal it. But you come here to butcher it, to take the heart out. Now, the member for Siparia made that critical argument. The very fact that we called and we passed procurement, it was because we felt that even government-to-government arrangements, financial services, law, all of that need to be covered by regulator. By regulator. The Prime Minister said, and that's the only thing he said I think correct, that the regulator is not the authority determining a contract. They are the oversight. So anyone, the cabinet or any other government ministry favor for this or that, and they go through a process, the regulator is just an oversight. Why don't you want this regulator overseeing a government-to-government contract? What about that? If the regulator was overseeing it, you would not have that $500 million contract with HDC that went up in smoke. You would not have it. What is wrong with that? And the minister, the Prime Minister lists all the government-to-government arrangements. Austria, China, where we were involved in. Of course we were involved in that. But what is wrong with if that goes to the procurement regulator? Then they say legal challenge. But as it is now, people can challenge it legally. As it is now, there are elements of government-to-government contracts where if somebody has some, they can file a judicial review. They can go to court on some instrument and deal with it. Why are we afraid in 2020 to say let the chips fall as they may? But you see, the Minister of National Security is very clever with the point. Raising emails of the former, linking to former officials, and come with the whipping horse, EMBDC. And every week we'll hear about that from now on. There is no police matter. There is no DPP matter. There is no International Criminal Court matter. There is no criminal matter involving the EBC and any official of the former administration. What they did is to file a civil action. The EMBDC. They filed a civil action. When I say they, I mean the Attorney General. So the Attorney General, and I believe the Deputy Attorney General at that time, the Junior Attorney General, gone to the courthouse with a set of paper, file action against everybody, including me, and then stand up in the Parliament, action, the corruption cases. What corruption case? Because those are filing, those are civil things you put in the court. Where police come by my house is to ask where you live in. So no police involved in that. There's no DPP involved in that. But they come with this type of, attitude. Something wrong, civil actions. These are civil actions they themselves file. Nobody file. It's them. They go into the courthouse with a suitcase or paper and file themselves. That is what they did. Madam Speaker, the minister would have been, I think I have 2 or 3 minutes left. The minister would have done well to explain why in his ministry a tender went out, because this is why we must keep this law. This is why we must not amend the procurement law. Why a tender went out for CCTV cameras and invited persons to tender to supply camera and service. When the bids came in the box, they closed the box and within minutes announced to all the participants that they're extending the time of the bid. They said they're extending the time from September 2019 to January 2020. When January 2020 came, Madam Speaker, they single-handedly and unilaterally changed the whole system. They said we don't want service equipment and service at the same time. We give it to a Canadian contractor only equipment, but not service. So they changed the rules. They changed the rules of the game in midair. And today, a procurement regulator could have inquired into that. 85 million United States dollars. And they split it up so that the bidders in the first place were all out. Because if you had put in a bid for hardware and software, it is a different thing now if it's just hardware you want. So today, they owe the country an explanation as to why they canceled that bidding. Why they unilaterally, without any further bidding, took a Canadian contractor only for hardware. But if that was under procurement law in place, those regulators would have asked the right questions. And this is why today they are trying their best, their level best, to destroy, to decimate, to collapse, to gut the procurement legislation, and we will have no part of it. Madam Speaker, I thank you.
Member for Port of Spain South.
Madam Speaker, the honourable member for Oropouche East says that he is not looking back and going back in time to accuse and say who is more corrupt and who is less corrupt. But in the same breath, he called the names John O'Halloran and Francis Privat. What is he really trying to say? At about 8 years, I learned that people judge others by their standards. It was a harsh lesson. Madam Speaker, it was a Mother's Day, and all the children in the area were given their mothers presents. As a spoiled child, I did not give my mother any presents. In fact, I asked for lunch. And she looked at me very disappointed, and I said, I thought about it, and I said, you know, if it wasn't me, you wouldn't be a mother. So on Mother's Day, you must celebrate me. And my mother watched me and said, Lord, I hope everybody is not as low standard as you. So what the other side is doing is thinking that this is a Section 34 government, but it is not. We are not a Section 34 government. When we bring a bill to Parliament, we advertise it before, we give the other side notice, and we give them an opportunity to come and debate it in the public glare. We don't go in midnight and put far-reaching legislation, Madam Speaker, that affects the nation. And I say then to the members of the other side, this bill, and stop, Madam Speaker, do you recall the days when you used to have records that would stick? It is like a stock record every week. The honourable member for San Fernando West, he making millions of dollars in rent. The honourable member for Port of Spain North and St. Anne's East, he own a bank. It's like a stock record. We are here about an amendment to a bill, and Madam Speaker, one of my favorite songs, it's a Friday evening, but I'm not tired of working, but I want to do the people's work. I don't want to hear about some trite existence of some benefit that is not true, that the Integrity Commission cleared the honourable member of, or a recusal which is in keeping with all principles and practices of good governance in situations where you must recuse yourself. So what is it really? That you are damned for doing the correct thing and the record has been cleared? What I am here about, Madam Speaker, is a bill to amend certain sections of Act Number 1 of 2015, the procurement legislation. And let me deal directly with the Office of Procurement. Madam Speaker, what they didn't tell you is that what the Office of Procurement said about this bill is this: that the Office of Procurement Regulations has reviewed the public procurement bill and agrees with all the amendments except, and there's one exception, Section 7. So what we are to do here, Madam Speaker, is to look at Section 7 because we disagree. But he agrees with every other one, so there's no debate on the other sections. And I would now like to focus on that section and, Madam Speaker, show how that amendment is not an amendment that should be objected to. The history of this bill and this amendment stems, Madam Speaker, from the commitment made by the government on the 66th session of the United Nations, where the procurement policy was agreed to by Trinidad and Tobago. And it was introduced in this House, and yes, Madam Speaker, at that time, the opposition did not support the bill, but forgive us, we were drunk with deception. We started in Section 34. Every time we agree, it came back and bit us. So forgive us if coming in 2015, at the end of the tenure of that government, we didn't support anything. And I'm now told that we supported it. So, Madam Speaker, the point I make is this. When we come now to do the amendment, and I don't need to school the honorable member for San Juan Barataria in the law of the constitutionality of bills, a bill or a law could be passed at first with a special majority, and there can be amendments that follow that do not need a special majority. And this is one such instance, and I think that the honorable member for San Juan Barataria knows better, and he should apologize to this House for trying to mislead this House. If he does not know better, he fell asleep in constitutional law. Now, when therefore this bill came, there's a lot of talk, Madam Speaker, but there are no figures. In 2015, when this bill was first passed, it was a different time in the world, and it was a different time in Trinidad and Tobago. The government revenue in that year was 46.5 billion. The government revenue in 2020 is 31.4 billion, and estimated for 2021 to $39.9 billion. It means then that the government revenue is falling, and we need to partner with international bodies or private entities that could assist in the running and the development of the country. These amendments are important because we say that they create an atmosphere still under the protection and under the ambit of the Act that will allow the government to do so in a time of steady declining revenue and in a time of uncertainty globally and nationally. Madam Speaker, the proposed amendments, in my respectful view, and I'm told, that I'm not in a courthouse, but it's my respectful view, will help us to boost and buttress the existing legislation to bring to this country a procurement legislation that is up to the time. Here is the learning on legislation. Madam Speaker, since 1946, there's a case of French Church Export Corporation, and it says that legislation and rules of court are the servants and not the masters of the people. What you are seeing here is this government trying to make this legislation work for the people of Trinidad and Tobago. Where is the objection? Madam Speaker, I have heard it's over 2 hours we hear, And not one speaker from the opposite side has drilled down to say, well, this is the reason why we do not support this amendment, and go through the amendment to show what is the damage, what is the mischief that is created by the amendment, and therefore that is leading to their lack of support. It cannot be, Madam Speaker, that they are objecting to the amendment to the expansion of the definition of bid rigging. Because what this amendment does is that it seeks to give the legislation more teeth, and it targets persons who may have an intention to illegally affect the outcome of a bid. So there'll be no accusation, as the member for Oropuch East has said, about going and opening any box. Section 7 seems to be the focus. And remember, I said it's the only objection taken by the Office of Procurement. What this section does, Madam Speaker, what this proposed amendment does, it fixes uncertainty when there is a government-to-government arrangement, or when there's arrangement with the government and other entities, and it entrenches the obligations by the government made with its other contracting parties. Madam Speaker, what is wrong with that? How has the other side criticized that and eroded it? It therefore meets a crucial and it meets a fundamental requirement of international law and international business law. And that fundamental requirement is called certainty. Why doesn't the honorable member for San Juan Barataria read his law? Certainty means that when we contract and we agree on certain provisions, there will be nothing to come after that will dislodge that agreement between us. Which international financial institution will enter into agreements with the government of Trinidad and Tobago when there's uncertainty and their monies are involved? The government of Trinidad and Tobago is therefore trying to create a legislative framework that will enable the government to fulfill its international obligations. But more importantly, Madam Deputy Speaker, I did not try to take over the portfolio of the Honourable Minister of Finance when I quoted the figures of our declining revenue. Part of this and a benefit of this amendment, it will enable the government of Trinidad and Tobago to fully access sources of funding that may be financially beneficial to the country. Therefore, when we cite the global context, we find, Madam Speaker, that this act is important in that regard. There is a whole hue and cry without any support against this section. But do you know, Madam Speaker, that this amendment finds sibling in similar provisions and similar wording from the Parent Act, which is in the United Nations Commission on Trade, the law model, UNITRAL, and it's Article 3. It is patterned from Article 3. And this amendment then simply provides that when there is an agreement, there is certainty in the agreement. The next aspect is services that will be exempted. Madam Deputy Speaker, there's one aspect that is very close to me, legal services. Madam Deputy Speaker, one day between, I think it's 2013, I was successful in a matter, and I was going to collect my check. It was a paltry check because it was a sum for cost. So you know when you're collecting a check from the Office of the Attorney General, you have to sign a book. But human nature, you know, a book has up and down. My name was somewhere in the middle. And you know, you must take a peep. I was not prying. So I'm happy to collect my money, and I look up and I look down, and I saw names and I saw sums. And I say, I'll do 100 cases before I get the amount of money them people getting. I not call. I do have court closed, but I'm not calling no names, Madam Speaker. When I look up, I look up and I look down, and it was like a repeat because the names kept repeating themselves. And just for one check, you know, I had to do about 100 cases to get the amount in one check. I call up my senior, not calling any names. I said, John, you was an AG before. I doing something wrong. He says, Scotty, you're doing something right because you're sleeping very well in the night. Madam Speaker, Madam Speaker, Section 29 is so what I'm trying to say is don't talk to us about legal fees. Do not judge this government by your standards. Madam Speaker, where is the scandal? The scandal is the member for San Fernando. Where's the scandal? That he has family who that's a scandal? Or the honorable member for St. Anne? Seriously? That's what we hear about this Friday afternoon? There's none. So you have to manufacture one and it becomes boring, like that stock record, Madam Speaker. You know now they play these things with a little, you put it in and you hear, but that stock record used to be very annoying, you know. And then the record used to scratch. We want to move on. Tell us, madam, when I come, I want you to tell me, look, we're going wrong here, so I can focus on where we're going wrong and say, well, yes, let's amend this section. But don't just talk in the air. Madam Speaker, sorry. What we say is this. If you look at the amendments are not draconian. The amendments are not disproportionate. And one amendment that nobody has spoken about is this amendment where, Madam Deputy Speaker, where we're amending, I think it's Section 29C. Section 29C, Madam Deputy Speaker, is Madam Speakers, if you have a conviction, it could be for obscene language, well, let's use a more, for using insulting language, and the conviction could be 30 years old, you are debarred from being a part of a procurement process. How could that be fair? What this amendment does, it brings us in line with the cases of NI, it brings us in line with international practice in something that is called spent convictions. After 10 years, a conviction is spent. That is what I come here to debate, you know. I come here to debate serious business. Or if you have a minor conviction, for example, loitering, which should be rarely taken off the books, you are still debarred. What it does is say, no, it narrows it down. Corruption and fraud. And that relates to procurement. And we still give you a 10-year period. And if you have been of a good, clean record, you are still allowed to participate. That is the efficacy of this amendment. Where is the objection to that? It brings us within first world countries and over 39 countries from Russia to Ghana. Madam Speaker, my view is that this government has demonstrated that it has no part to do with any acts of dishonesty or any acts that will bring into disrepute the procurement legislation that as it existed. What, therefore, is the opposition? Is the opposition supposition? Well, suppose this happens, or this may happen, or where is the concrete evidence of any wrongdoing that will set the nation on alert not to support this amendment? Madam Speaker, every day, every member of parliament on this side, every minister, puts one foot behind the next and does his work. We don't complain if we get a bill the day before. We go on and we do the work. Why? I don't want to tell the honourable member for Superior how to distribute her resources, but there's something called division of labor. If there are 5 bills and there are 19 of you, divide it. But don't complain. Let's get down and do the work in a serious way. And we are saying that this amendment brings, Madam Speaker, the legislation into alignment with the needs of 2020, 2021, and beyond. And in closing, in this government, on this side, there is no Section 34, there is no O'Halloran, there is no Rishmi. There's just good governance and the right choice. Madam Deputy Speaker, I think that I have reached the cusp of my time, and this is my contribution to this bill. Thank you.
Member for Miaro.
Thank you very much. Thank you very much, Madam Speaker, for the opportunity to join in this debate at this late hour as we look to amend the Public Procurement and Disposal of Public Property Amendment Bill 2020. Now, Madam Speaker, I have sat here since 1:30 and I have listened attentively to all the speakers so far, both on the government bench and my colleagues on the side. And I must say that what I've gathered so far, most of the to and froing spoke about these perception and assumption of the ability to corruptly receive money somehow in terms of how contracts are awarded. And the purpose of this piece of legislation is really to prevent that. But Madam Speaker, I listened to the Prime Minister, I listened to the Minister of Finance, I listened to the Attorney General, and I've now listened to my colleague from Port of Spain South. And all that was spoken about these issues around contracts and government officials and so on, that is what this legislation is trying to cure. The legislation, the parent legislation, is attempting to cure exactly what the members are speaking about here today. But Madam Speaker, the amendment that has come to us, and I want to join with my colleagues on this side of the bench in condemning the government for this savage butchering of this procurement legislation, Madam Speaker. Because the purpose is to resolve the mischief that they've been speaking about all day today. And now the government comes to take out those pieces of the legislation that resolves that particular mischief, Madam Speaker. Madam Speaker, my colleague from Port of Spain South made some very good arguments, but I want to remind him that he spoke about the law uncertainty and that we are, the word that he used, supposition that perhaps something may happen and something may not happen. And while certainty is really part of something in the law that we need, I am certain that when these contracts are given, taxpayers' money have to be paid to these contractors. And the law, the amendments that they have brought today, is taking out that certainty. Because it means that if there is no proper oversight on some of these contractual arrangements, we are certain on this side that taxpayers' money can and will be brutalized at the end of the day. Madam Speaker, my colleague from Port of Spain South also said that no one on our side has discussed the clauses of the bill in any great detail. But Madam Speaker, I can tell you there are Trojan horses built into this bill, into this amendment. There are one or two fine points that make sense, and the vast majority of it does not. It's like a poison apple. It's all nice and red and shiny, but there are bits and pieces of poison on the inside that I believe if we, as an opposition, doesn't stand firm on and reject this, we will undermine the entire purpose of this piece of legislation, the parent legislation, Madam Speaker. Madam Speaker, besides the media, besides the people in this country, I think the world is speaking against this type of butchering of procurement legislation. And in my discourse over the next 10, 15 minutes, Madam Speaker, I will present that for you. Madam Speaker, the World Bank, in a study in February of 2020, has said that globally, 12% of GDP is spent on procurement. And if we were to look at the figures for Trinidad and Tobago in 2018, Madam Speaker, it is estimated that we spent $23.81 billion US dollars. That works out to about 160 billion TT dollars for our GDP. Now, if the World Bank is correct and 12% goes to procurement, it means that 19.2 billion TT dollars would have been spent on procurement. Now, Madam Speaker, when the finance minister spoke, he said that it's only 5% of the legislation is being routed out and 95% will remain there and remain strong. But Madam Speaker, that 5% is worth nearly 20 billion TT dollars that we have a duty to protect as a parliament, as representatives of the people. We have a duty to protect that. And Madam Speaker, quite frankly, I would like to see this bill passed in terms of the parent legislation untouched, because every day in the media, the perception that politicians are corrupt and all are we thief and all these other things that you hear in the public domain, and this legislation is to safeguard us. This legislation in its parent form is to prevent that sort of information, that sort of labels from being presented on parliamentarians in the future, Madam Speaker. Madam Speaker, over the last 5 years or so of this administration, they have engaged in leasing and purchasing of vessels, construction of buildings. You know, there has been so much of work that has been done without a proper procurement process, this transparent procurement process, which this procurement legislation looks to deliver to the country. Madam Speaker, when you take a look that the government basically spends about $442 million a year in buildings and rentals of government space, that's about $36 million a month, but there's not a proper procurement process. And this is all that we're asking, that this procurement legislation will clear up all of those issues so there will be no allegations of impropriety as we go on, so no one has to come here and defend himself or herself of any issues around that, Madam Speaker. Madam Speaker, the government, even in this COVID-19 response, had almost $20 billion at its disposal. Some of the money, the minister had indicated, and he quite clearly stated what went in terms of grants and grant support, but there were billions of dollars in goods and services procured. And there has been no explanation, there has been no transparency in terms of how that money was spent. And this parent legislation, it was designed to solve that mischief. And what we are trying to do today is to take out the teeth, take out the toughness of that legislation and leave the interpretation wide open. Madam Speaker, as you would know and has already been said, that this act was passed in 2014. It was partially proclaimed in 2015 to get the regulator's office going so regulations can be made. But I do not feel, Madam Speaker, that the government has ever pursued with interest the required infrastructure to give effect to the law. Madam Speaker, I have a copy of a letter that was sent under the heading, this is dated January 25th, 2016. It's under the letterhead of the Minister of Finance. Disbanding of the Procurement Implementation Oversight Committee. Madam Speaker, this is dated January 25th, 2016. And from the ringing of the bell
from the day this government took office, that was their intention. They have never had an intention to take public procurement seriously. When the first act that the finance minister did was to issue an instruction to disband this procurement implementation oversight committee. Madam Speaker, it is noteworthy, and has been mentioned by the member for Oropuch West, that the opposition at that time, led by Dr. Rowley, he and the team, they withdrew from the Joint Select Committee that was headed by Dr. Tiwari. The committee had the active support of all the independent senators, and they put together a very effective piece of legislation, Madam Speaker. And as indicated as well, in the House of Representatives, the PNM opposition abstained during the vote. So there is no proof. I am not convinced, Madam Speaker, that this government had any intention or still have any intention of getting good legislation in terms of dealing with public procurement, Madam Speaker. Madam Speaker, in 2017, 3 of our own very prominent citizens, Mr. Reginald Dumas, Mr. Victor Hart, Mr. Afro Raymond, they all wrote to the then president in terms of giving support to the parent legislation and asking the president to hold a hand in terms of the recommendations that were made at that time by the government. Now, Madam Speaker, this is the 3rd time that the government has brought pieces of legislation to amend the parent legislation that is given the opportunity to keep watering down this bill, watering it down. And I think this particular amendment before us today, Madam Speaker, I think this is the knife, this is the dagger in the heart of the legislation. Madam Speaker, if I were to take you back to 2009, the Off Commission of Inquiry, which was appointed by the then Prime Minister, Mr. Patrick Manning, after the very same, our current Prime Minister, Dr. Rowley, he came to the House of Representatives and made allegations of corruption on government contracts. And these are the same government-to-government contracts that the Honorable Prime Minister stood here today and made a rationale why it should not be covered under the terms of reference of our parent legislation. And the Off Commission, Madam Speaker, they issued on recommendation number 39, and if you allow me just to quote recommendation 39, the reviewing of tenders and the making of decisions upon the award of contracts should be undertaken in as transparent a manner as possible, including demonstrating a clear compliance with procurement rules as to allay suspicion of improper actions of potential corrupt influences, end quote. Madam Speaker, this administration has never implemented any of the recommendations of the Off Commission, and they continue to issue multi-million-dollar contracts even without basic transparency. Madam Speaker, Clause 5 of the legislation seeks to prevent procurement oversight of agreements between government and international financial organizations. The government, Madam Speaker, is effectively attempting to remove government-to-government arrangements and public-private partnerships from the ambit of the legislation. Now, this is happening, Madam Speaker, when the government has publicly indicated that it plans to privatize the Port of Spain. Madam Speaker, other contracts, most recently, including the construction of the headquarters for the Ministry of Health at a reported cost of $250 million, are also being undertaken through a PPP model. Madam Speaker, with the removal of government-to-government contracts from the ambit of the law, there could as well be a reoccurrence of this financial scandal involving the Housing Development Corporation and the China Zhenzhuba Group Engineering for the construction of 500 homes, which the Prime Minister had to personally intervene and stop it because it was not in accordance to what the Cabinet had asked for. So, Madam Speaker, it is worrying that the Prime Minister and members of the government could have adopted that position knowing fully well that if the procurement regulator had the power through the parent legislation, could have prevented that from happening. And up to today, Madam Speaker, we still do not know if that the scrapping of that contract, if the penalty, or if there was a penalty that the state had to pay for breaking that contract, Madam Speaker. Madam Speaker, any part of this watered-down law could cost taxpayers heavy sums through flawed contracts. On the 19th of January 2020, Madam Speaker, the Express newspaper recognized the government's attempt to reduce the reach of the law. And in its editorial, and if I can quote, if this were to happen, the whole point of the act would be undone. The newspaper told the government to abandon any plans to undermine the law. Madam Speaker, internationally, the best practice is that public procurement legislation must govern PPP and government-to-government arrangements. Major financial institutions, Madam Speaker, such as the World Bank, the Inter-American Development Bank, the European banks, they require transparent competitive bidding processes as a key condition for financing infrastructural projects. So it is a requirement of the very same agencies that the Prime Minister is saying that we will deter them and we will chase them away from funding our projects here. They are the very same ones who are saying this is what we need. This is what we need to ensure that we continue to finance your projects in your country, Madam Speaker. Madam Speaker, with that in mind, why is the government seeking to remove these types of contracts from the purview of the legislation? Madam Speaker, in doing a bit of research for this bill, I stumbled across, there's something called the World Bank Public-Private Partnership Legal Resource Center. And in one of their reports, under public procurement processes, they have written as part of their governance process that by including this in your procurement legislation, in your procurement processes, it leads to greater transparency, a level playing field for the bidders, giving the project greater legitimacy, setting out the qualities and experience required for each bidder, and getting value for money. And that is what is important to our taxpayers. Madam Speaker, what is wrong with the citizens of Trinidad and Tobago wanting this? That is the question that those opposite have not answered. What is wrong with the citizens of this country asking for this to remain in the legislation? Madam Speaker, in 2012, the 37-member Organization for Economic Cooperation and Development recommended, and it was accepted as well, that the principles of public governance should cover PPP contracts. Several reasons were advanced, including value for money again. So, Madam Speaker, I fail to understand, I fail to agree with the government's position today that they should be removing these 2 or 3 clauses in the legislation that weakens and really rips the teeth out of it at the end of the day. Clause 6, Madam Speaker, takes away the prime responsibility from the procurement regulator in terms of the disposal of state assets. Now, I too have seen the document issued yesterday by the Office of the Procurement Regulator, where he has said that all except clause 5, I believe it is, that he has no problem with. But, Madam Speaker, while the regulator's position is that disposal of state asset, it may, in effect, compromise their position because now they will now lose that bit of independence because they have to follow instructions from the government. I can understand where he's coming from. But, Madam Speaker, when you look at comparative legislation worldwide, all of these procurement legislation, Madam Speaker, it indicates and it includes that the disposal of assets, state assets, are a primary function of the regulatory authority. So I am going to urge the government to perhaps look at an arm or a branch or something in the regulator's office that must be responsible for the disposal of state assets, because worldwide it is part of the process. Madam Speaker, in 2004, there was a green paper on public procurement and disposal of public property in Trinidad by the Ministry of Finance. And in their view, they said that there must be transparency of process and increased accountability for asset management. Madam Speaker, that is a P&M administration back in 2004, and today this is another P&M administration that is adopting an opposite approach, Madam Speaker. Thank you very much, Madam Speaker.
Minister of Planning and Development.
Thank you very kindly, Madam Speaker. Madam Speaker, hypocrisy in politics may be the norm for some, but Madam Speaker, those of us on this side do not agree that that is the norm for us. Madam Speaker, you cannot show me a kobo and try to convince me that it is a dove. And Madam Speaker, I sat here in this House and listened to member after member of the opposition trying to give the impression that what we were doing, as they put it, was gutting the Procurement Act. And in fact, Madam Speaker, it was quite clear that none of the members on the other side even understand what are the amendments before us. None of the members on the other side even understand, I posit, the Procurement Act that already exists. They are giving the impression that contracts will be awarded by the regulator. Madam Speaker, the Cabinet, because of the constitutional responsibility to the people of Trinidad and Tobago, must remain responsible for certain types of procurement. What the regulator has to do and what the regulator has the authority to do is approve the procurement plan and strategies, and in reality, they cannot, the regulator cannot be allowed to approve all policy regarding procurement. So, Madam Speaker, I posit that those on the other side are talking nonsense. Madam Speaker, I sat here and heard the member for Siparia commend the former member for Caroni Central, Member Botiwari, of all people, who during his time as Minister of Planning and Development moved to dispose of state lands at Invaders Bay, moved to dispose of state lands at Chagaramas. Madam Speaker, we are still grappling with those issues at Chagaramas. Madam Speaker, you will recall the fiasco that took place when they wanted to build on the Eddie Hart ground. Members of the Trin City community had to go to court to stop that, even with Invaders Bay. Afra Raymond and others had to go to court to stop that. Madam Speaker, I want you to recall the sale of Apsara, the fire truck incident, the purchase of the jail at Santa Rosa. Madam Speaker, I could go on and on and on. And Madam Speaker, I make this point because even though those opposite us are saying that we did not participate in the Joint Select Committee on the procurement bill, I want to remind the public that, Madam Speaker, all during that time, and the member for Cypriot made the boast that 30 days after they came into office, they laid the procurement bill. Madam Speaker, they had the requisite majority to pass that piece of legislation without our involvement, Madam Speaker. Why did they wait until their last few months in office to pass that legislation? Madam Speaker, I posit it was a pretense to allow them to pretend to the population that they were so interested in procurement issues, all the while doing the things like disposing of Invaders Bay, disposing of the land at Chagaramas, and several other matters of which we are all familiar, Madam Speaker. Madam Speaker, I want to bring to the attention of this House the comparison between the Singapore and the Trinidad and Tobago legislations. And Madam Speaker, the member for Naparima continuously talks about the fact that we must look at the Singapore model for every single thing. And Madam Speaker, let me draw it to the attention of this House and the population regarding the comparison between the Singapore procurement legislation and the Trinidad and Tobago legislation. And let me say from the outset that our law compares very favorably with Singapore. Madam Speaker, Mr. Deputy Speaker, I'm sorry. Both pieces of legislation have adopted a hybrid model, whereby procedural rules and evaluation criteria are set. We have that, the Singapore legislation has that. And these criteria are set by the Office of the Procurement Regulator. Whilst operational functions and interpretation of rules and awarding of contracts are performed by line agencies, ministries, and state agencies. Singapore, the only difference is that Singapore has greater control by the regulator to set standards and to do investigations. And Mr. Deputy Speaker, these amendments which are before us today do not tamper with that ability. Mr. Deputy Speaker, what these amendments seek to do is to tighten the gaps in the existing legislation that can have the effect of weakening the original intent of Act Number 1 of 2015. And that intent is to provide for public procurement in accordance with the principles of good governance, namely accountability, transparency, integrity, and value for money. And Mr. Deputy Speaker, we note with interest that none of the members went into the substance of these amendments. Mr. Deputy Speaker, accountability is a key pillar in the new procurement regime and provides for stiff penalties for bid rigging. Under Clause 61B of Act Number 1 of 2015, anyone involved in or who participates in bid rigging, or even if it becomes evident that a public officer or anyone even indirectly influences in any manner any procurement proceedings, he or she is liable to a fine of $5 million and imprisonment for 10 years. Mr. Deputy Speaker, one must bear in mind that the new procurement regime, and specifically Part 5 of Act Number 1 of 2015, allows the supplier or contractor, if they feel aggrieved by the outcome of a tender process and has reason to believe that the process was not transparent, they can initiate what is called challenge proceedings against participants in the process. Transparency is another key pillar to be upheld in this new dispensation. But what are the implications of this, Mr. Deputy Speaker? The implications are that it must warrant clarity and unambiguity so that such persons can be held accountable. Therefore, the definition of bid rigging must be clear and unambiguous. The definition of bid rigging, therefore, must be robust so that a case may be proven. In Section 4 of the current Act, bid rigging is briefly defined as collusion between persons for the purpose of manipulating proceedings. We are of the view that this definition needed strengthening, so the amendment provides a more rigorous definition. It specifies that bid rigging means collusive price fixing and anti-competitive behavior designed to unfairly influence the outcome of a competitive tender process in favor of one or more bidders. The new definition, Mr. Deputy Speaker, therefore addresses all aspects of bid rigging. It presents a basis for gathering of evidence in a more effective investigation provided for under Part 4 of the Act. Now, Mr. Deputy Speaker, what we did here was strengthen the definition of bid rigging. None of the members on the opposite side made mention of this. And I wonder, Mr. Deputy Speaker, if it's because members on their side may have a problem with the whole issue of bid rigging. And Mr. Deputy Speaker, I crave your indulgence to refer to a newspaper article, Why RAM Was Fired, Cloud Over UNC Caroni Central Candidate, Trinidad Express, July 30th, 2020. And it says, RAM's dismissal involved the handling of a bid for 12 3-ton trucks for TSTT's use. David's letter to RAM stated, and David was the HR person at TSTT. The company, TSTT, views your actions and the findings of guilt made against you by the disciplinary tribunal as serious acts of misconduct, which resulted in financial losses to the company in the sum of $3,689,209.36, which includes the losses suffered in making the advance payment to the company, and that was the company that supposedly won the bid, as well as the additional losses to the company, TSTT, incurred in redoing the entire tender process. The dismissal letter was issued subsequent to a disciplinary hearing on the issue, which commenced on September 20th, 2017, and concluded on June 14th, 2018. According to the letter, RAM was negligent in the management of the entire process, in that he approved and or authorized for payment to the successful bidder an advance payment of $3.3 million, or 50% of the down payment, for the 12 3-ton trucks, misled and or misrepresented to the Chief Executive Officer and the Chief Financial Officer that the tender evaluation report provided as a term of payment an advance payment. In fact, he did so under false pretenses, failed to notify the Executive Vice President.
49, Deputy Speaker, Standing Order 49.
49 what you said? 49 said you what?
Standing Order 49, Deputy Speaker.
Overruled.
Ram was also accused of lack of due care and attention, and also was
Again, 49. Hold on. Chief Whip. According to 49, Standing Order 49, by alleging that a member is sub judice, a member shall be confirming to the House that the paragraph 1 is applicable and accept responsibility for advising so the House. All right, again, you have made it, you have made your Standing Order point. Right, I overrule based on the information that I have before me. Proceed.
as the head of the asset management of the company and a person holding a senior management role, you displayed a clear lack of proper leadership and/or concern for the assets and funds of the company, as well as a lack of due care and attention in ensuring compliance with the company's procedures for making payment to suppliers, which caused the company to pay out the sum of $3,307,873.
Madam, Mr. Deputy Speaker, I raise on a point of Standing Order 48, Mr. Deputy Speaker.
Yes, I'm recognizing member.
I water here and be careful. Mr. Deputy Speaker, I rise on a point of order.
Listen, members, please. First of all, Laventel West, please have on your mask. I am recognizing the member for. Hold on 1 second. Excuse. Member for Carney Central at this time, and then you'll have your opportunity. 1 second.
Please have a seat.
Hold on, member. He's making a point of order.
It's 40,
member.
95 time. 95 time recusal. You know about recusal.
Member for Carney Central. What's your point of order?
Mr. Deputy Speaker, I raise on a point of Standing Order 49. This matter is before the courts of Trinidad and Tobago.
And again, you are making that assertion, and I'm saying I have no such information. Overruled. Member, proceed.
Mr. Deputy Speaker.
Deputy Speaker, I seek guidance. If the matter, no.
Speaker, thank you. Mr. Deputy Speaker, The letter further said that RAM assessed the company as a supplier that was qualified to supply TSTT with the bucket trucks, but the...
You can have the discourse at the back if you also desire.
The company, TSTT, the company was unable to show by its financial information that it had the ability to sustain the services to be offered, and TSTT said it had neither the experience, capacity, or competence known to TSTT to supply the bucket trucks, had no performance record, track record, historical perspective, quoting sizes and lists of other companies.
I'm standing on 49, Deputy Speaker. She's prejudicing the case.
1 second. Have a seat, have a seat, have a seat. Members, please. And Chief Whip, who determines that? That's my simple question. Proceed.
Thank you, Mr. Deputy Speaker. Mr. Deputy Speaker, the letter to RAM also stated that RAM erroneously determined that the mandatory pre-qualification criteria applicable to bidders could be waived on the basis that they were vendors on TSTT's system, when none of the bidders had ever previously supplied 3-ton trucks with aerial lift and accessories to TSTT. And Mr. Deputy Speaker, RAM was then the chairman of the tender assessment company, stated that all decisions of the committee were unanimous, and he stood by that decision. And Mr. Deputy Speaker, the information at TSTT showed that this was erroneous.
Member, your time has now elapsed.
Sorry, sir?
Your time has now elapsed.
Mr. Deputy Speaker, I think it's highly unfair because half my time was taken up by the other side raising objections. Mr. Deputy Speaker, may I have injury time, please?
Again, Honourable Member, at this time, I will not be in a position because, again, I do not want to set a precedent. You will have to, again, your time is up.
Thank you, Mr. Deputy Speaker. Mr. Deputy Speaker, it seems that the Caroni Central representatives have...
Okay, member. I recognize the member for Couva South.
Thank you, Mr. Deputy Speaker. Mr. Deputy Speaker, what we have just witnessed in this House from the point of view of the Minister of Planning and Development and the member for Aruka Maloney.
Members, proceed.
Is what I would call a very unsavory attack on the member for Caroni Central, knowing fully well that this matter involving the member for Caroni Central is currently being...
Members.
Parliament by...
Member for Couva South. Member for Couva South. Members. Leader. Hello. Members. Okay. First of all, member for Caroni Central, I do not want you to disturb the session, especially when you are not in your actual seat. So could you please get to your actual seats, please? Well, you were sitting at that chair just now, right? But no problem. You decide. Member for Laventille West, could you retract that statement, please? Retract, please.
Mr. Deputy Speaker, I'm sorry.
Just retract the statement that you just made. It reached my ear. Just retract the statement you last made.
I'm speaking of someone outside of this house, Mr. Deputy. I retract the statement, Mr. Deputy Speaker, for your ease and comfort.
Thank you. Right. And again, also, leader of government business, please do not entertain the crosstalk with the member. Proceed. Proceed.
This is a very important debate as it relates to the people of Trinidad and Tobago. And the conduct we are seeing here really sends a very strong signal about the trivialization of this matter based on the conduct from the government side. Because you cannot use the parliament to unceremoniously attack a sitting member of this house, knowing fully well what is before the courts of this country, Mr. Deputy Speaker. Mr. Deputy Speaker, the member for Aruka Maloney, in her contribution, spoke about hypocrisy in politics may be the norm for some in politics. And you cannot be a kobo and tell me it is a dove. Well, what I have seen here really has me thinking about the quotations used by the member for Aruka Maloney. And in relation to this piece of legislation, Mr. Deputy Speaker, the Public Procurement and Disposal of Public Property Amendment Bill 2020. I want to tell the government that to understand why the opposition has taken this position in this particular piece of legislation, you have to go back. You have to go back to Lockjoint, and you have to go back to the Mount Hope Medical Sciences Complex and Study Tech, and you have to go back to the Hall of Justice and Higgs and Hill, and you have to come to present day, Mr. Deputy Speaker, as it relates to what transpired, as it relates to $100 million and a fiasco at A&V Oil and Gas, Mr. Deputy Speaker. These are the things that we on this side are concerned about. And Mr. Deputy Speaker, Mr. Deputy Speaker, we know about the Cabo Star, we know about Bridgman, and we know why they stopped the Superfast Glacier to facilitate what they wanted to do from a government's point of view. So nobody on that side will stand up here and attempt to be sanctimonious in their conduct in this parliament.
His mere presence is offensive. Offensive language, sir.
Overruled.
And Mr. Deputy Speaker, I am responding to the interventions of speakers on the government side. And the member for Aruka Maloney said that speaker after speaker spoke about the bill being gutted, and those on the opposition side did not understand the proposed amendments. And she went on, the member for Aruka Maloney went on to attack a former colleague of mine from the point of view of Caroni Central as it relates to this particular piece of legislation. and also came to the conclusion that the government at the time, led by the member for Siparia, did not want to pass the legislation because they only passed it with a couple months to go in office during, well, with our term coming to an end, Mr. Deputy Speaker. But I want, Mr. Deputy Speaker, to quote from an article today in today's Express, written by the former member for Caroni Central, Dr. Bohindranath Tiwari, a former Minister of Planning, and also the Member of Parliament for Caroni Central, under the headline or under the heading, Creating Highways to Corruption by Making Procurement Law Toothless. And I want to put this in a historical perspective too, also, Mr. Deputy Speaker, because, Mr. Deputy Speaker, when the member for Siparia campaigned to convince the population of this country that the UNC and the partnership needed the support to become the government of Trinidad and Tobago, Mr. Deputy Speaker, we committed ourselves to facilitating or following through on procurement legislation. And the work began in about 2012. And I want to quote Ms. Kamla Persad-Bissessar's Prime Minister assigned me as a Senator of Planning and Sustainable Development to chair the JSC on procurement to get the job done. This was in 2012. This was 2012, after the committee had already met for 1 year without making much headway. 1 year without making much headway. So the work began in 2011.
Speaker, Standing Order 55-1B. This has been traversed several times.
I remember I'll give you a little leeway, but tying the point, because again, we are now on the almost the 12th speaker, and it have been said on a numerous occasions. So again, tie it in quickly and
Yes,
move on.
I'm guided. I'm responding to the member for Karuka Maloney because, you see, we wanted to move on. We wanted to get on with the work as it relates to the procurement legislation. And if you would permit me, just one paragraph to tie in the point and embellish the point, Mr. Deputy Speaker. When in opposition, the Prime Minister, Keith Rowley, as leader of the opposition then, who was a member of the Joint Select Committee, blocked and tackled for years, pulled his team from the committee in an attempt to derail the work of the committee. And because of this act of irresponsibility, I had to change the structure of the quorum, which then required one member of the opposition to be present for a quorum to representation of both houses of parliament. Instead, in order to make the derailing and sabotage of the committee's work continuing impossible, I took the job of getting strong legislation passed by Parliament seriously, and in spite of many setbacks, got it done. That is the commitment, that is the work of the party that I belong to, the government which I belong to, and to hear that the member for Ruka Maloney stand and say that we did not want to pursue, we did not want to persevere, Mr. Deputy Speaker, is pure hypocrisy on the part of those on the other side. And Mr. Deputy Speaker, we must understand, and I could understand, because you see, we all have a responsibility in terms of accountability and transparency in the affairs of the government of Trinidad and Tobago. We all have that responsibility, and the opposition is fulfilling its responsibility here this evening. And I want to ask members of the government, because one of the objectives of the Act is to promote local industry development, sustainable procurement and sustainable development in public procurement and the disposal of public property. And it defines sustainable procurement as a process whereby public bodies must meet their needs for goods, works, or services in a way that achieves value for money on a long-term basis in terms of generating benefits not only to the public body, but also to the economy and the wider society, whilst minimizing damage to the environment, Mr. Deputy Speaker. And Mr. Deputy Speaker, we have heard about the establishment of the Office of the Procurement Regulator. We have heard about the hiring of the Procurement Regulator and the establishment of the Public Procurement Revenue Board and so on, and the Procurement Depository and so on, Mr. Deputy Speaker. But in proposing the amendments, and in piloting the amendments here, Mr. Deputy Speaker, I have not heard what the government has done to move the implementation of what we would may term sustainable procurement. And this goes beyond process and procedure, Mr. Deputy Speaker. It calls for a fundamental change in the thinking and mindset, a fundamental change in culture. And under the parent legislation, Mr. Deputy Speaker, because during his presentation when the Prime Minister made his intervention, Mr. Deputy Speaker, and I'm trying to find my notes as it relates to what the Prime Minister said. And the Prime Minister, during his presentation, indicated that if the Cabinet is not to procure, he bob and weaved and was full of a certain deportment and energy to tell us or tell us what to do. And the law called for procurement units in every public body, government ministry, or department. And he hoped that the country will become less corrupt, Mr. Deputy Speaker. Mr. Deputy Speaker, in relation to the Parent Act, a public body takes into consideration the office of the President, the Parliament, the Judiciary, the Ministry or Department of a division of a ministry, the Tobago House of Assembly or a division of the Tobago House of Assembly, a municipal corporation established under the Municipal Corporations Act, a regional health authority established under the Regional Health Authority, a statutory body responsibility for which is assigned to a Minister of Government, a state-controlled enterprise, a service commission established under the Constitution or any written law, Mr. Deputy Speaker, and I could go on and on, Mr. Deputy Speaker. And what is important in terms of in addition to the proposed amendments, we have not heard the government speak as it relates to the operationalization of the bill or of the process. And I ask today, and I hope that the Minister of Finance, in his winding up to this particular piece of legislation here today, could tell us how many government bodies, state agencies, are fully manned with procurement units and the relevant or the accompanying handbooks and so on. How many members of the public service, whether in the established organizational structure on what we would call contract labor, has been properly trained as it relates to what will entail procurement units in the respective government departments, Mr. Deputy Speaker. Not one of them has sought to address that here today, whilst the Prime Minister will tell us he expects Trinidad and Tobago to be less corrupt based on what the government is doing. This is a sham. This is a public relations exercise on the part of the government of Trinidad and Tobago. And this is why the opposition has a responsibility to call them out and to indicate to the national community why the parliament is being abused.
For recognizing, I respectfully stand on Standing Order 55, 1A and B, Mr. Deputy Speaker.
Overruled.
Thank you, Mr. Deputy Speaker. So, Mr. Deputy Speaker, the government must walk the talk. And this is a reason why we have a responsibility to tell the national community again and again that we cannot trust the government based on its modus operandi and its intention, Mr. Deputy Speaker. And Mr. Deputy Speaker, as it relates to the issue of operationalization and regulations and so on, I want to just reflect a bit because the Minister of Finance during his presentation launched what I would call a broad-based attack on the media of Trinidad and Tobago today. I think this was really a dark day because the media is part of what we would term to be the fourth estate in the country. And
Remember, you have 2 more minutes.
The media has a role in preserving the interests of all of the citizens of the country. And the minister, for some reason, seemed to be obsessed with the Express because he took a similar line in 2019 when the Express did an editorial which he termed to be misleading and uninformed. And the Honorable Minister indicated that he has taken note of the uninformed and misleading editorial in today's Express, that is the 14th of January, which he claims that having received the draft regulation from the procurement regulator just over 1 month ago, and he went on to say that Section 63 of the Act makes it clear that the public procurement legislation are made by the minister on the recommendation, and if he believes that if the Express believes that the minister must be a rubber stamp or a post office box. But the minister has not demonstrated in any form and fashion his commitment to procurement and moving the process forward and so on, Mr. Deputy Speaker. And that is why the Express, like other arms of the media, is concerned about the direction that this government has taken as it relates to the proposed amendments here today and the billions of dollars of taxpayers' money. The media has a responsibility to play its role from the point of view of efficiency and accountability in the transparency of taxpayers' money. And also, if the minister should be willing to answer why has the Trinidad and Tobago Chamber of Commerce called him out on the proposed amendments to Section 7 of the Act. I thank you, Mr. Deputy Speaker.
I recognize the Minister of Finance.
Thank you very much, Mr. Deputy Speaker. Let me just deal with a point made by the last contributor. And I would urge all members of Parliament, we are all parliamentarians here, we all enjoy freedom of speech, and I don't think any member of Parliament, whether on the government side or the opposition side, should encourage MPs not to speak out. I think it is really unfortunate that a member of parliament would seek to imply that the media has some sort of superior right of free speech to members of parliament, and that really weakens the positions of MPs. And you're encouraging the media in their mistaken belief that they, in articulating views and opinions and facts, are superior to members of parliament. This is something we as MPs must guard very jealously. So that, in my opinion, was an egregious error on the part of the member of parliament for Couva South. Don't encourage them. We have every right to say what we feel, and we have every right to state our opinion, and we have every right to criticize the media as they criticize us every single day. And I have no particular issue, Mr. Deputy Speaker, with the Express. The Guardian and the Newsday are equally guilty. So I'm not singling out anybody. And I'm not afraid of them. So let me move now to the issues at hand. I took some notes of comments made by the Leader of the Opposition. And the Leader of the Opposition told us that the reason why the UNC is opposed to the clause in the bill which seeks to exclude government-to-government arrangements from the authority of the Office of Procurement Regulation, and I recorded what the Leader of the Opposition said, that there is corruption in government-to-government contracts, and that is why these arrangements must be stopped. So let me go back to my list, Mr. Deputy Speaker. You had, under the UNC, a government-to-government arrangement for work on the National Academy for Performing Arts. And the leader said there's been corruption for years in government-to-government arrangements. So is the Leader of the Opposition saying there was corruption in the arrangement for additional work on the National Academy for Performing Arts under the UNC? The Couva Children's Hospital, I can remember so well when they opened a non-functional hospital just before the election. A non-functional hospital, it was still a construction site, still a construction site, still had work to be done. Was that Couva Children's Hospital one of those government-to-government contracts which was corrupt? The sporting facilities, the aquatic center, the cycling center, done under the UNC in a government-to-government arrangement with China. Is the Leader of the Opposition saying that government-to-government contract was corrupt? And the famous Chinese long-range patrol vessel. And I repeat, I take possession of my words, Mr. Deputy Speaker. I am satisfied that it is true that on a visit to China, the then Prime Minister, the member for Superior, saw a Chinese vessel and said, I want one like that. And I'm taking possession of these words, Mr. Deputy Speaker. Let them prove me wrong. Was that government-to-government arrangement for that Chinese vessel corrupt? And, you know, we have a lot of political hypocrisy in this parliament today. I heard the member for Oropouche East. If there ever was somebody who engaged in political hypocrisy, it is him. Complaining about government-to-government arrangements and dredging up the ghost of Lockjoint. I happen to know personally, and I'm taking responsibility for these words, that the member for Oropouche East was intimately involved in the negotiations for the government-to-government contract with the Austrian government for the Point Fortin Hospital project. Intimately involved. And he will come here in this house and be such a political hypocrite to say that these government-to-government contracts have corruption. He was involved in the negotiation for the Point Fortin Hospital. And I say that without any fear of contradiction. Let them prove me wrong. So I really would like to know, these 1, 2, 3, 4, 5, and that's the 5 that are on this list. I'm sure I'd have more. these 5 government-to-government contracts, were those the ones the member for Siparia said were corrupt, and that's why we must stop this? It is just words, Mr. Deputy Speaker. They just throw out words, words that have no meaning, absolutely no meaning. And what is disappointing about this debate, Mr. Deputy Speaker, what is disappointing is that there's a lack of recognition of the fact that the whole question of procurement is a very complex area of law. It's not for amateurs. I would not dare to come in here and talk at length about open heart surgery. I know nothing about that. And I doubt few others in here who are not medical doctors would dare to venture into the intricacies of open heart surgery. But everybody and their nenen feels that they're an expert on procurement. Everybody inside of here thinks they're an expert on procurement. They have no training in the subject matter. They have no knowledge in the subject matter, but they want to talk. So, Mr. Deputy Speaker, let me just say a few things. I would have expected one of the luminaries on that side to talk about a concept in procurement that is called public-public cooperation. Now, this has been written on extensively. There are many books on the subject of public-public cooperation. I would have expected the luminaries on the other side to do some research into the procurement rules and regulations in the European Union. It is one of the most advanced areas in the world as far as public procurement law is concerned. I would have expected the luminaries on the other side, if they really want to debate this amendment, to come and explain the rationale behind the exemptions in the European public procurement law. And one of the most primary exemptions is the exemption of public cooperation. It's in the European law. And if contracting states decide to cooperate in the public interest by entering into a contract between themselves, so Germany will want to enter into a contract with France in the public interest, it is exempt from the procurement regulations in the European Union. Standard practice all over the world. Public cooperation, that's what it's called. Not one of them bothered to read one single semicolon in the literature with respect to why you exempt public cooperation. Instead, they just came, they regurgitated wholly irrelevant things, they repeated themselves, and that is why there were so many points of order, Mr. Deputy Speaker, all wholly irrelevant, wholly irrelevant. It's a feature of world procurement that when sovereign governments seek to contract with each other in the public interest, this contracting is not subject to normal public rules. And the operative phrase is in the public interest. So the Couva Hospital was in the public interest. The Cape-class vessels from Australia are in the public interest. And I reject absolutely the half-baked amateur presentations about what is required in an arrangement between two public authorities in the public interest. And I would urge those who want to talk about these things, do some research, understand procurement law. It's embarrassing, absolutely embarrassing. And just to answer one of the things that was shouted out by the member for Oropouche East, that he referred to a statement made by me about bribery, and he said I should have taken it to the police. Well, for your information, I did. There's a written report to the Commissioner of Police about attempted bribery in respect of a contract in the airport. And I also put on record that I am on affidavit in a matter dealing with prosecution of international fraud with respect to attempted bribery, with respect to that project. I don't fool around. The members opposite just like to talk. I'm putting on record, yes, that matter was reported to the police by me, and I'm on affidavit in respect to that matter. I don't joke around. So I just put that into the record to debunk that nonsense. So let us go now to what we are being told. We are being told that the Office of Procurement Regulation is not in agreement with the amendment to Clause 5. And before I go to that, let me just deal with a matter raised by my colleague, the Minister of Planning and Development. And we have indeed made a very sophisticated amendment to the clause and definition that deals with bid rigging. Previously, the clause was a bit weak, and it simply spoke about collusion in the tendering process. We have brought in a definition, and this comes straight out of the European Union procurement rules. We've expanded the definition to make it clear what collusion is. Bid rigging means collusive price fixing and anti-competitive behavior designed to unfairly influence the outcome of a competitive tender process in favor of one or more bidders. And there is a matter before the court. I will not say what it is, but there is a matter before the court. And the member for Oropouche East always gets very sensitive when that matter is brought up, where there are allegations of collusive price fixing and anti-competitive behavior with respect to contracts awarded under the UNC administration. So we are now seeking to tighten that definition so that will come to an end, hopefully. But let me now go, Mr. Deputy Speaker, to the points made by the Office of the Procurement Regulator, telling us that we should not amend Section 7 of the Act, and we should not exempt government-to-government arrangements from the ambit of the Procurement Regulator. My colleague, the Attorney General, made the point that in a matrix presented to this PNM government, and also presented to others with respect to what is the applicable law in all the other countries that have procurement legislation, that in the majority of countries that have procurement legislation, government-to-government arrangements are exempt from the normal rules of procurement. That is a fact. And that brings me now to a matter. Again, I'm very disappointed in some of the submissions from the persons on the other side who somehow were called to the bar. I still wonder about that, how some of these people were called to the bar. But there is an interesting case, Mr. Deputy Speaker, very interesting case, which deals with the whole question of the separation of powers and the whole question of Section 13 of the Constitution. And that, in that particular case, Mr. Deputy Speaker, what the court was looking at was the whole question as to how Section 13 of the Constitution operates. And in that matter, Mr. Deputy Speaker, the whole question of what is reasonably justifiable was examined. And Section 13(1) speaks to what is reasonably justifiable in a society that has a proper respect for the rights and freedoms of individuals. And in this particular case, there was a discussion of something called the Barrow approach. And the Barrow that is being spoken about here is Justice of Appeal Barrow. And Mr. Barrow, Justice of Appeal Barrow, looked at 3 cases. He looked at Morgan versus the Attorney General. He looked at De Freitas versus the Permanent Secretary of the Ministry of Agriculture. And he looked at Attorney General versus Northern Construction. And if I were to summarize the discussion of the Barrow approach, Barrow, and I'm reading now from the judgment, Barrow went on to state that in deciding whether Section 13(1) is breached, following the Templeton approach, and that is Lord Templeton we are speaking about, which he accepted, the court is entitled to compare the legislation at hand with comparable legislation from other democracies. And that's what's important. The fact of the matter is, all over the world, government-to-government arrangements are exempt from normal procurement arrangements. It's in legislation and it's in practice. And the reason why I've read this, because I heard that weak amateur attempt to tell us that this legislation requires a special majority because it breaches Section 13 of the Constitution. And that is why I've referred to this particular case law, where Justice of Appeal Barrow made the point that the court is entitled to compare the legislation at hand with comparable legislation from other democracies. And if virtually all other democracies exempt government-to-government arrangements from procurement regulation, then I think we on this side will be very safe. The members opposite are free to go to the court and try and prove that the amendment to Section 7 breaches Section 13, but you'll have a very hard time. And I would have hoped that in this discussion, that is the kind of in-depth learning we would have been subjected to. All I just heard was rah-rah from the members on the other side. A set of noise, a set of amateur submissions, Mr. Deputy Speaker. As the Prime Minister has pointed out, we are of the view that it is in the public interest to exempt government-to-government arrangements from the oversight of the procurement regulator. And we are firm in this view. And we have stated this view over and over and over for years. And the whole point of what we are doing today is we must get on with the job. We need to proclaim the Public Procurement Act. And if we are caught in endless arguments, circular arguments over and over and over this section, in which we, the elected officials, we, the accountable people, we, the people who have been elected by citizens to represent them, if we are firm in our view that it is in the public interest to exempt government-to-government arrangements from the oversight of the procurement regulator, then we would be delinquent in our duties to allow this to further delay the proclamation of this act, Mr. Deputy Speaker, and we have no intention of doing so. We believe that we are correct. We believe there's sufficient precedent for this, there's sufficient authority for this, and we believe this is the right thing to do. And this is why we have brought this matter to the Parliament today, and this is why we will ask for this matter to be put to the vote. The only other thing I would want to say.
I beg to move that this House continue to sit until the conclusion of all the matters before it.
Honourable members, the question is that this House do continue to sit until the completion of all the business before it. All in favour say aye. Aye. Any against? The ayes have it. Minister of Finance.
Could you tell me how much more time I have, Madam Speaker?
You have 1 minute.
Right. I was about to wrap up. I simply want to dismiss out of hand as absolutely absurd propositions from the other side that if a member of Parliament requires surgery to save his life or her life, we need to get 3 quotes for that and subject it to oversight by the regulator, which, as the AG has said, could take 123 days. I reject that as absurd. And I reject as absurd that when we want legal services, we must put that out for 3 quotes, which could end up with somebody who is in opposition to the government providing the lowest bid. I beg to move, Madam Speaker.
Honourable members, the question is that the Public Procurement and Disposal of Property Amendment Bill 2020 be now read a second time. All in favour say aye. Aye. Any against? The ayes have it.
A bill entitled An Act to Amend the Public Procurement and Disposal of Public Property Act number 1 of 2015.
Minister of Finance.
Thank you, Madam Speaker. I beg to move that the Public Procurement and Disposal of Public Property Amendment Bill 2020 be committed to the Committee of the Whole.
Honourable members, the question is that the Public Procurement and Disposal of Public Property Amendment Bill 2020 be committed to the Committee of the Whole. All in favour say aye. Aye. Any against? The ayes have it. This House will now go into the Committee of the Whole to consider the bill clause by clause. Are we ready? So, can we do 1 to 2, and then 3, and then the rest a block? Okay, thank you.
Clauses 1 to 2.
The question is that clauses 1 to 2 stand part of the bill. The question is that clauses 1 to 2 now stand part of the bill. Those in favour say aye. Aye. Those against say no. I think the ayes have it. Clauses 1 to 2 now stand part of the bill.
Clause 3.
The question is that clause 3 stand part of the bill. Minister of Finance.
Thank you very much, Madam Attorney General. Sorry, I'm sorry. I went way back in time. Madam Speaker, I went back about 10 years.
It must be something with the Attorney General. I almost called you the Attorney General.
You almost called me that. Okay, an amendment has been circulated. It is really a stylistic approach. This is what has been put to us by the Chief Parliamentary Counsel, and I accept the CPC's learning. So I would just ask, Madam Speaker, that we amend 3, delete and replace with the following: this act shall come into effect on such date as is set by the President by proclamation.
Whip. Okay. The question is that clause 3 be amended as circulated. Those in favour say aye. Aye. Those against say no. I think the ayes have it. The question is that clause 3 as amended now stand part of the bill. Those in favour say aye. Aye. Those against say no. I think the ayes have it.
Clauses 4 to 10.
The question is that clauses 4 to 10 stand part of the bill. The question is that clauses 4 to 10 now stand part of the bill. Those in favour say aye. Aye. Those against say no. I think the ayes have it. Clauses 4 to 10 now stand part of the bill. Honourable members, the question is that the bill as amended be now reported to the House. Those in favor say aye. Those against say no. I think the ayes have it. This committee meeting is now adjourned. The House will be seated.
Out that the opposition once again has more members than are allowed at this time.
Okay, so
I try my best.
Okay, I'll just ask. Could you just
But
sort that out, please?
They don't care about procedure, you know.
And now, members do appreciate if there's a call for division, there's an established protocol that we'll follow. Okay, so unless that occurs, we know our balance will be maintained by our whips. Thank you. The Minister of Finance.
Thank you very much, Madam Speaker. I wish to report that the Public Procurement and Disposal of Public Property Amendment Bill 2020 was considered in Committee of the Whole and approved with one amendment. I now beg to move that the House agree with this report from the committee.
Honourable members, the question is that this House agree with the committee's report on the Public Procurement and Disposal of Public Property Amendment Bill 2020. All in favour say aye. Aye. Any against? No. The ayes have it. Minister of Finance.
Very much, Madam Speaker. Again, unfamiliarity with the rules. I beg to move that the Public Procurement and Disposal of Public Property Amendment Bill 2020 be forthwith read a third time and passed.
Honourable members, the question is that the Public Procurement and Disposal of Public Property Amendment Bill 2020 be forthwith read a third time and passed. All in favour say aye. Aye. Any against? No. Okay, so members, now that we've called for division, we all know that members will be allowed a maximum of 3 minutes to return to the chamber before we begin the count. When we begin the count, even though a member is not in there, the member will be allowed to vote once we have not announced the numbers. The marshal and their assistants will call members in. So we'll wait 3 minutes from now. Honourable members, the division will now commence. Clerk.
Mrs. Robinson-Regis. Aye. Dr. Rowley. Aye. Mr. Al-Rawi.
Aye.
Mr. Imbert. Mr. Young.
Yes.
Mr. Hines.
Aye.
Mr. Dialsingh.
Yes.
Mr. Ford.
Aye.
Mrs. Webster-Roy. Ms. Cujo.
Aye.
Dr. Gadsby-Dolly.
Aye.
Mr. Gonzalez.
Aye.
Mr. McClatchy.
Aye.
Mr. Cummings. Mr. Richards. Mr. Manning. Mr. Leons. Mrs. Morris Julian. Mr. Dino Briga. Mr. Scotland. Mr. Monroe. Mr. Lee. Mrs. Persad-Bissessar.
No.
Ms. Amin. Ms. Amin. Mr. Charles.
No.
Dr. Moonilal.
No.
Mr. Paray.
No.
Mr. Indarsingh.
No.
Dr. Budo.
No.
Mr. Hosein.
No.
Mr. Padarat. Ms. Haynes.
No.
Mr. Tanku.
No.
Ms. Mohit. Mr. Rambali.
No.
Dr. Ragbir.
No.
Mr. Ram.
No.
Dr. Sitran. Mr. Ratiram. Madam Speaker, the results of the division is as follows. 21 members voting for, 18 members voting against, and 0 abstentions.
Honourable members, on a division, 21 members voted for, 18 members voted against. There were no abstentions. The bill is carried.
A bill entitled An Act to Amend the Public Procurement and Disposal of Public Property Act No. 1 of 2015.
The Minister of Finance.
I will proceed.
The Minister of Finance.
Thank you, Madam. I'm always ready like Hulk. Madam Speaker, I beg to move that a bill entitled The Miscellaneous Amendments, Powers of Statutory Authorities, and Matters Related to Certain Boards Bill 2020 be now read a second time. Madam Speaker, the bill before the House has a few clauses, exactly 8, and I will go through them. The first 2 clauses are the standard clauses. The first clause is the title. The second clause is the commencement provision. In the third clause, we are amending the National Lotteries Control Act to increase the size of the board. Madam Speaker, this is a very old piece of legislation which has been in effect in Trinidad and Tobago for many, many years. And for some reason, it's quite unusual, the board of the national lotteries is limited to 5 persons, a chairman and 4 others. And this, over the years, has made it difficult for respective governments, whether this government or the one before or others before, to appoint persons with the necessary skill set, necessary range of expertise and training, and also to allow members of that board to be part of committees that deal with various matters that would come before the Lotteries Board to function effectively. With a board of just 5 people, if 2 people are absent or 3 people are absent, it would make it impossible for the board to function. So this very simple amendment is simply deleting the word "for," as I indicated in section 3.2 of the Act, the chairman plus 4. We are now making it the chairman plus 8. And I think members opposite will understand the practicality of this amendment. It is an anachronism to have a board as important as this, limited to just 5 people. The next clause in the bill amends the Tobago House of Assembly Act, and it inserts after section 51 in that act the following section. 51A. The Secretary may, with the approval of the Minister, raise money by the issue of securities for the purposes of meeting any of the obligations and discharging of any of the functions of the Assembly. The Minister may guarantee the discharge by the Assembly of its obligations in respect of any issuance of securities under this section in such manner and on such conditions as he thinks fit. And for the purpose of this section, security has the meaning assigned to it under the Securities Act. Again, Madam Speaker, this amendment is born out of practicality. Under the previous UNC administration, and actually I have to stop saying that is the former, because we now have won 2 elections back to back. But under the UNC administration of the 2010 to 2015 period, there is a famous case with respect to a building being constructed for the Tobago House of Assembly, and a debate as to whether the House of Assembly was empowered to enter into build, own, lease, transfer arrangements with a contractor to construct that building. That matter is still before the courts, so I would not go into any great detail. It is sub judice. That is a fact, unlike some of the other matters we heard today where no evidence was presented. I don't doubt it may be so, but no evidence was presented. But I can tell you factually, there is a matter before the courts. The House of Assembly won the matter at first instance. The matter went to appeal. It was reversed, and it has now gone to the highest court for a final determination. But the dispute in that particular piece of litigation was over the borrowing powers of the Tobago House of Assembly. Quite recently, in a previous budget statement, I announced that the Tobago House of Assembly would be given authority by the Minister of Finance to enter into loan financing arrangements for development projects in Tobago. The House of Assembly has been engaged for quite some time now in seeking to raise the necessary finance for these development projects, primarily infrastructure projects in Tobago. And that was a decision on the part of the government to assist the Tobago House of Assembly, and by extension the residents of Tobago, to get more access to funding to do infrastructure work and development projects in Tobago. And the House of Assembly has run into some difficulty because there's an interpretation of the law that the Minister of Finance can authorize direct borrowing by the House of Assembly from a single financial institution. But it is the norm in the modern era, Madam Speaker, that quite often when government or quasi-government entities go to market to raise financing, that the financing is done by way of a syndicated loan arrangement, where a number of commercial banks and financial institutions would participate in the financing. So in this particular case, the House of Assembly went to market, and it was difficult for the bank involved to arrange out of its own resources the entire $300 million. The bank had the ability to disburse a smaller amount. But if it was a syndicated loan arrangement where a bond would be issued, and this is where the definition in this clause comes into play, that for the purposes of this section, security has the meaning assigned to it under the Securities Act. So if the financing could be done by way of a bond, which is a security, then there was sufficient liquidity in the banking sector to easily raise the $300 million. But one single bank at this time did not or does not have the capacity to give the Tobago House of Assembly the $300 million. So we are changing the Act, the Tobago House of Assembly Act, to allow the Tobago House of Assembly to borrow either by way of direct loan financing or by way of a security, namely a bond, a syndicated bond, with the approval of the Minister of Finance. And that is the purpose of this amendment. And the protection that is being given here is that it must be done with the approval of the Minister of Finance. And by the way, just as an aside, the dispute with respect to that other matter, which is before the court still, was as to whether the Minister of Finance had given approval or not. That does not apply in this case because we are making it crystal clear that the borrowing must be done with the approval of the Minister of Finance, whoever he or she may be. The fifth clause amends the law with respect to the National Institute of Higher Education, Research, Science and Technology. The acronym is NIHRST for those who may not be aware. And again, that act is an anachronism where it mandates a fixed board comprising 14 persons. And it is even more anachronistic in that it does not specify any specific qualifications and experience for those 14 people. It simply says it must be 14. And again, it's difficult to find 14 people who would want to serve on the board of an entity of that nature. So simply to make it easier for this government and any other government that may come afterwards, we're simply reducing it from 14 to 7, and we think 7 is appropriate for the size of that board, of that institution. So there's no mischief in any of this. And in fact, NIHRST has suffered over the years in this government and other governments, even the UNC government, in that from time to time there were not 14 members on the board of NIHRST, which rendered the board functus. So we're just clearing that up and now changing it from 14 to 7. With respect to the Children's Authority Act, and again, the purpose of the amendment to the Children's Authority Act is quite simple, and it changes the age of the person representing youth on the board from 30 to 35 years. The next amendment is an amendment to the Water and Sewage Authority Act, and this follows again the amendment we are proposing for the Tobago House of Assembly to allow the Water and Sewage Authority to borrow either by way of a direct loan from a single financial institution or by way of a syndicated loan through a bond issue or security from a series of financial institutions. So it's identical in intent and effect to the amendment to the Tobago House of Assembly Act. Similarly, the Trinidad and Tobago Electricity Commission, we are amending the Act in a similar way by allowing the Electricity Commission to borrow for purposes that the Minister of Finance may approve. Again, that is a very old act which has limited the Trinidad and Tobago Electricity Commission in its borrowing. And we've also included now the definition of security. So again, the Trinidad and Tobago Electricity Commission can borrow for infrastructure needs, for development purposes, for procurement of equipment, for improvement of the electricity supply by way of a syndicated financing arrangement. I beg to move, Madam Speaker.
Honourable members, I shall now propose the question for debate. The question is that the miscellaneous amendments, powers of statutory authorities, and matters related to certain boards Bill 2020 be now read a second time. Member for Mian.
Thank you, Madam Speaker. Madam Speaker, thank you very much for acknowledging me to join and respond to the Minister of Finance on this very short but very critical piece of legislation that raises a lot of questions in the public domain. Madam Speaker, it is really baffling to see that the government has lumped several distinctive and different pieces of measure into this single catch-all bill. Is what I refer to it to. This seems to be a legislative shortcut that really is resulting in these very important matters not receiving the sufficiency of consideration during the debates that should happen in this House and in the other place. Madam Speaker, this bill that the government has brought before us today is seeking to grant the authority to three of the most inefficient and poorly administered public entities to borrow money to continue to run their debt-ridden organizations, Madam Speaker. Madam Speaker, without any checks and balances, this would almost surely lead to further waste, lack of accountability, and efficiency. This government's response, Madam Speaker, to waste, disorganization, and lack of transparency clearly is to give more money to the current administrators. In other words, throw more money down an ever-deepening hole, Madam Speaker. Madam Speaker, if we look at the clauses that has been presented by the Minister of Finance before us today, let's start at Clause 3, where the government is expanding the board members of the National Lotteries Control Board from 4 to 8. And, Madam Speaker, I would like to ask, what are the skill sets, if any, is the government seeking to attract by increasing these numbers? What is the position of the board? And what is this new skill set they are bringing on to increase the efficiency of that organization? The minister has not provided that information, Madam Speaker. Madam Speaker, is the increase in numbers fixing a legal or an administrative failure of the existing board? The minister has failed to advise if that is the case as well. Madam Speaker, by raising from 4 to 8, would this lead to greater efficiencies or profitability at the NLCB. Madam Speaker, instead of expanding the number of directors, it may have been better judgment to appoint more competent and more knowledgeable directors in the industry to ensure profitability of the organization, Madam Speaker. Madam Speaker, if we go on to clause 4, and to me, Madam Speaker, this is probably one of the most potentially dangerous and reckless measures that this government can take at this time, and I'll tell you why. Madam Speaker, this clause is giving the Tobago House of Assembly some powers to borrow money on their own. And all we have to do is look at the track record of the THA, Madam Speaker. The Tobago House of Assembly has had a long track record of playing fast and loose with the public purse, Madam Speaker. In 2016, if I can take you back to the Auditor General's report, Madam Speaker, one example, it revealed that vouchers totaling $500 million were not produced for examination. Madam Speaker, another report in 2013 of the same Auditor General reports, it revealed that the THA had exceeded its approved estimates by $23.7 million. In 2013 as well, Madam Speaker, the THA was the only public entity to have overspent. So this is why I am very guarded by this particular measure, Madam Speaker. The Auditor General has repeatedly reported that the THA was not transparent, accountable, or compliant with taxpayers' dollars. As recently as 2017, Madam Speaker, there was a difference of $703 million between the balance in the cash book and the sum shown at the bank in the bank reconciliation statement. In 2014, Madam Speaker, my research revealed that the THA breached financial codes and spent an additional $49 million on the URP program. Madam Speaker, and it can go on, and I am very wary that the state, that the government is allowing this particular enterprise the opportunity to be able to borrow more money on its own, adding to an already overburdened national debt, Madam Speaker. Madam Speaker, the THA's financial predicament has a lot to do with mismanagement and the absence of oversight, transparency, and accountability. Granting the THA the additional right to raise funds in its operation is like giving someone the keys to the vault. The government is simply funding this inefficiency, Madam Speaker. Madam Speaker, if we look at clause 6, it is a duplication of the power that has been given to, that is going to be given to the Tobago House of Assembly, to the Water and Sewerage Authority. Madam Speaker, clause 6.1, I asked the question, what is the intention and the need to increase the number of directors of the Water and Sewerage Authority from 9 to 11? Again, the same questions of what is the missing competency, what is the gap that they are trying to fill. The minister has not advised this House as to the rationale behind this increase in the board of directors. Is there a particular skill that they are looking for, a skill that the board does not have, and they are increasing the numbers to bridge that gap, Madam Speaker? Madam Speaker, clause 6.2 is another example of, again, taxpayers' funds being open to more waste and mismanagement at the end of the day. By the government's own admission, Madam Speaker, WASA is overstaffed by about 2,000 workers. I believe that this measure is really an attempted sleight of hand by the government, and I explain to you why, Madam Speaker. I recall vividly in the budget presentation of the Minister of Finance, he said that the annual subsidy to WASA was being reduced from $1.6 billion to $1 billion. I, like many taxpayers in this country, naturally would have felt that at long last, WASA was being made to put into some efficiency system and perhaps get along and pay its own way as you go along. But instead, Madam Speaker, we are seeing here today that WASA is going to be given the ability to borrow money internally. Is that an option where the state does not give them the money, but they can borrow on their own, so the net effect remains zero? We end up back in the same position. I am wary of that, Madam Speaker. Perhaps the minister, in his wrapping up, he can identify what was the rationale behind that. Madam Speaker, what is also more surprising is that this measure concerning WASA is before us today, and it is even before the cabinet sub-appointed, that committee on WASA, even submits a report. So this measure is being taken without the benefit of that report that supposed to put WASA on a particular track towards efficiency and better service, Madam Speaker. I'm surprised that this has come before that. Madam Speaker, even before the report is presented, the Minister of Public Utilities as well in the public domain has said that there would be an increase in tariffs at some point in time for more efficiency. So again, you have this request for borrowing coming before even that report and having the minister speak about the increase in tariffs and so on. I find it a bit confusing and a bit surprising that this is before us here today. So what it's telling me, Madam Speaker, with the ability of WASA to borrow, customers may be continuing to pay for WASA's inefficiency without any sort of guarantee of an improvement in supply of water, an improvement in services in general. And Madam Speaker, you would know the constituency that I represent, we are burdened and saddled with issues of water on a continuous basis. Madam Speaker, if we look at Clause 7, again, it's a replication of the issue with the Tobago House of Assembly with WASA, where there is an attempt, again, to allow a debt-strapped enterprise to borrow money on its own. I know the minister spoke about a specific type of borrowing and so on. But when you look at the debt that has already accumulated in these agencies, Madam Speaker, it worries me that we are giving these agencies free rein to go and borrow more without a serious consideration or a conversation about increasing efficiencies and so on. So, Madam Speaker, if you look at TNTech itself currently has a debt of over $4 billion. So I am worried that we're giving them the authority to borrow more money on top of that. Madam Speaker, as with WASA and TNTech, the government should really insist, part of the rationale to allow them to borrow more money is that they must show a clear path to become efficient and be financially solvent within a specific time frame, rather than giving them this open checkbook to borrow money. Madam Speaker, the government is increasing the debt burden on taxpayers. The national debt, including contingent liabilities, is more than $125 billion. You know, there are many in the country, Madam Speaker, keep saying that, you know, we are mortgaging the lives of our children and our grandchildren by adding more debt onto this that we already have. So, Madam Speaker, while the bill seems to be a very simple one with just 8 clauses, it speaks to some serious financial ramifications. And the minister in his opening has not, and I know he had half an hour and he did not use it. I was expecting the minister to really come and explain in some more detail the rationale behind several of those measures. So, Madam Speaker, I just want to close by stating that we all in this country understand the state of the economy, the state of the finances of the Treasury, and we need to be more prudent. We need to let these state organizations be more efficient and put some more controls in terms of how they borrow, what they borrow, when they borrow. So, Madam Speaker, With those few words, I want to thank you.
Member for Faizabad. You'll give it. Sorry, Prime Minister, I didn't see.
Thank you very much, Madam Speaker. My apologies for my late recognition. Thank my colleague from Faizabad for giving way. Madam Speaker, this being a debate, I thought I would join based on what is the flavor of the moment. The member for Mayaro has represented his party well, and for that he should be congratulated. This is not the first time that Tobago is presented in this way, Madam Speaker. I simply want to remind my colleagues on the other side, especially the new ones, that the name of this country is Trinidad and Tobago. And if Tobagonians were as cantankerous and as unreasonable as you are, they would ask their representatives in this House, and I'm not one of them, I'm Diego Martin West, but they would ask their representatives to tell you that if you are not prepared to acknowledge Tobago's interests in this country, then you are not qualified to speak about Tobago. Yes, this matter has to do with the Tobago House of Assembly. And everything that he has said about the Tobago House of Assembly this evening can be easily said and more about the corporations in Trinidad. So to use the Auditor General report to recognize that there's a place called Tobago is simply trying to place a wedge in a crack that you think you've observed. Madam Speaker, I am not here this evening to defend the Tobago House of Assembly's record in the Auditor General's report, because I know how those reports are written and I know how to read them and how to interpret them. The fact that it has been said that $700 million was not seen recorded one way in one book and the other book, I don't jump to the conclusion that somebody has stolen it, or that that should disqualify the Assembly and the people of Tobago from achieving their aspirations of what they seem to think is a raison d'etre for their being in this nation. They're fighting, and in this very parliament now they're arguing, and we all are working on it, internal self-government. So an argument that you have a problem with how much they get sends the wrong signal to the people of Tobago. I've heard it said here in Trinidad, recently, in this parliament of Trinidad and Tobago, by no less a person than the leader of the opposition, former Prime Minister, who did a computation to show that Tobago was getting too much, because that is their attitude, that is their position about Tobago. Every time we go to do anything here for Tobago, the opposition comes up and makes an argument about it that they're getting too much. And the mathematics was this: divide the population by the budget, and that will determine the size of the allocation for Tobago. And Tobago only has 60,000 people, and they're getting $4 billion, and that is too much. Madam Speaker, that is not how we are going to run, and we will run this country. Madam Speaker, the best representation of what has just been presented there about Tobago from Mayaro, from the member from Mayaro, is that we just had a general election. And if you had all this to say about Tobago, why didn't you join the general election and say it in Tobago? It would have been the correct opportunity to stand in Tobago with your candidate and defend your record and anybody else's record and tell Tobago in Tobago that they're getting too much or they're behaving too badly. But you didn't do that. You want to run the country, but time and again, you wouldn't even put up a candidate in Tobago. In a matter of weeks, there'll be a Tobago House of Assembly election. And Madam Speaker, I will be surprised if they put up a candidate. But they'll come to the Parliament today and make an issue where there's none about the government acceding to the request of the administration in Tobago as part of the national financial and fiscal management to borrow money in an authority that has executive responsibility. The Tobago House of Assembly has executive responsibility. And if you have a problem with them borrowing money, you should have a bigger problem with them looking after the children in Tobago, the health system in Tobago, the roads in Tobago, and the people of Tobago. Your argument is without merit, without substance or reason. Madam Speaker, the fact that the THA is going to be allowed to borrow money with the approval of the Minister of Finance under the country's constitution is not open check to borrow, as he has said. It is not an open check. As a matter of fact, I would expect the Tobagonians to say, some of them would say that the Minister of Finance should not have to give permission for the THA to borrow because it makes the THA look like a little boy. But there is responsibility and there are checks and balances. And if the Tobago House of Assembly, in managing its affairs in the national allocation of funds, in collaboration with the Ministry of Finance under the authority and responsibility of the Minister of Finance, who will be the ultimate person who is responsible for any borrowing that they do. Because if they come to the Minister of Finance and request to borrow over and above the allocation or within the allocation, it then will become the duty and the day work of the Minister of Finance to determine whether or not he approves that borrowing. And therefore, no member of this House could come here and sensibly say that by allowing them to borrow so that their cash flow or the development program could be handled more efficiently is giving Tobago an open check. That is just mischief, Madam Speaker, and it fits in with the negative presentation of the entire national business of my colleagues. They seem to know nothing or want nothing with anything good. It matters not what you present in front of them. They will come up with some concern, some issue to portray to the public as though they should be disquiet. Imagine my colleague from Mara gets up here and makes an issue of the fact that the government in managing the affairs of state, this cabinet which is running the country's business properly, has a working boards committee. And in examining the work that has to be done at WASA, the cabinet determines that WASA will be better served with a slightly bigger board so that more skills can be put there, so that more subcommittees of the cabinet can function, because WASA is a major billion-dollar enterprise that requires broader management at the level of the board. But for him, that's a big issue. Adding 2 persons to the board is a big issue. Madam Speaker, I wonder if he knows the antecedents of the party he's a member of. I recall, Madam Speaker, when the UNC came into government, the board, the number of members on the Central Bank board was settled for decades. The UNC wanted to get at individuals on the board and could not in the normal scheme of things. You know what they did? They increased the number of members on the Central Bank board by X, where X is any number. I can't remember the exact number of persons. Oh yes. They added 7 persons to the board of the Central Bank to be able to do what they wanted to do on the Central Bank board, and it was all vindictiveness against an individual. And he has the unmitigated gall to represent them today to come here and ask me and ask my government why we are putting 2 members on WASA board. We are putting 2 members of WASA's board to improve the management of WASA in the public interest. Madam Speaker, given what we are facing at WASA, nobody is happy with the arrangements in that organization. But we're not leaving it so. The signal of putting 2 persons on that board should have been clear that the government intends to take seriously what has to be done there. I mean, at a recent board committee meeting, a case was made and accepted that given WASA's role that we expected in treating with groundwater as against surface water, we need to get on the board of WASA a geologist, especially one that has some idea about hydrogeology if he or she is available, because such a person would be valuable on the board. And if we can get 1 or 2 more engineers and accountants, and by the time you look at the broad spectrum of skills that would be required at WASA, an IT person, a human resource person, if we can get 11 people with those skills, then you can have both subcommittees for the various aspects of work that has to be done. And that is why, Madam Speaker, today in the Parliament, a simple matter of extending the board to 11 to bring those skills there. And how is it interpreted? With the worst possible complexion. Because, Madam Speaker, there are some people who believe that nothing good could happen in this country, and there's no honest person in this country. I say to them, Madam Speaker, talk for yourself and your dreams and your own vision. Madam Speaker, the THA gets its money in tranches from the Ministry of Finance. The THA is a body which, once its financial accounts are in order, could and should be able to go to a bank and borrow reasonable sums of money, justifying it first to the bank and secondly to the Minister of Finance or vice versa. And it's all part of a normal operation. Because sometimes, Madam Speaker, cash flow, not having the cash flow could be costly, even though you'll pay eventually and have to pay. The member make a big thing, implying, inserting into his argument that, yes, the government is giving WASA all this money, and now it's going to allow WASA to borrow. And of course, he adds 1 + 1 = 2. In his kindergarten maths. And as far as he knows, WASA going to get twice as much money to waste. But instead, Madam Speaker, what is it? It is that the Minister of Finance has to borrow and service everybody who he is servicing in the country under the government's responsibility. And if there's an agency that ought to have its accounts in order so as to be able to borrow on its own, that is where you need to be, rather than have the Minister of Finance borrow it and then pass it to the agency. By borrowing at central government and passing it to the agency, that is not the best management model. The best management model is for the agency to be able to manage its own internal accounts by borrowing and spending and then reporting to the Minister of Finance and dealing with it in that way. That is where we are heading. Because we are fixing problems in this country. And we have to have this constant niggling of the worst by people who are either uninformed, because today I will simply say my colleague didn't mean harm. He was just uninformed on these matters, but being in a group, they say if you with the dogs, the fleas are going to be with you. Madam Speaker, being in a group that has this thing about Tobago, where as soon as you mention Tobago, some of them get up in this house and compare Tobago with the corporation in Tabaquita, Paro, or in Pinal, or in Chaguanas. Tobago is not a corporation. Tobago is an integral part of the nation of Trinidad and Tobago. The name of this nation is not Trinidad and Chaguanas, or Trinidad and Diego Martin, or Trinidad and Point 14. It is Trinidad and Tobago. And if you all don't understand that, you had better understand it now or be permanently disqualified from leadership in this country, because you cannot run Trinidad and Tobago by treating Tobago in that way and talking about Tobago in that way and ignoring Tobago in that way. And if you had any appropriate leadership, you wouldn't put yourself in this situation. I thank you, Madam Speaker.
Thank you, Madam Speaker. As I join this debate with what I would call a very brief intervention, having listened very attentively to the Prime Minister in his discourse, and apparently he seemed to have been fixated with the response of my colleague, the member for Mayaro. And the member for Mayaro was merely utilizing the opportunity afforded to him in participating in this debate to ask questions or seek some answers from the government of Trinidad and Tobago as it relates to the intended amendments of the miscellaneous amendments, the powers of statutory authorities and matters related to certain boards, Bill 2020. And in piloting the bill, the Minister of Finance indicated that this was a very simple exercise here this evening. And all my colleague attempted to do, based on his knowledge and his research, and based on wanting the government to continue to be accountable to the people of Trinidad and Tobago, he posed some simple questions. At no point in time did my colleague from Mayaro give any indication that we are opposed to the whole issue of the Union of Trinidad and Tobago, or we want to separate Trinidad and Tobago, this sense of divisiveness that apparently was portrayed by the Prime Minister of the country. Madam Speaker, it is the responsibility of the opposition to seek the answers, and Clause 4 of the bill simply points in the direction of the bill would amend the Tobago House of Assembly Act, Chapter 2503, by us inserting a new Section 51A to empower the Tobago House of Assembly with the approval of the Minister of Finance to raise money by the issue of securities for the purposes of meeting any of its obligations or discharging any of its functions. And this clause would also empower the Minister of Finance to guarantee the borrowings accordingly. And it is also a similar wording as it relates to Clause 6, where it states, paragraph B, I'm just reading a part of the amendment, or the intended amendment, Madam Speaker, as it relates to, would insert a new 26A to empower the authority with the approval of the Minister of Finance to raise money by the issue of securities for the purpose of meeting.
Just for means of clarification, because just so we could get the answer correct. Are you on Clause 6 or on Clause 7?
No, I was looking at Clause 4 and at Clause 6 in relation to the issue of raising.
Okay, so Clause 6 in my version of the bill is the Children's Authority Act. I don't know if I have a wrong version, because I observed the same thing with member Mayaro.
Okay, well, Madam Speaker, I am reading from a document that I downloaded from the Parliament. I stand to be corrected and guided, but I was focusing on the issue, really, as it relates to the amendment to the Water and Sewerage Authority Act, Chapter 5440, as it relates to where the intended amendment is to insert a new 26A to empower the authority with the approval of the Minister of Finance to raise the money by the issue of securities for the purposes of meeting any of its obligations or discharging any of its function. And the member simply wanted or was seeking from someone on the side of the government, and probably in his winding up, the Minister of Finance probably to point in some direction of the sums of monies and so on. In terms of governance and accountability and so on, it was no way intended to try to project, like if the opposition is seeking, based on its answers, on behalf of the taxpaying public of this country, to drive any wedge between the people of Trinidad and Tobago, or that the United National Congress, from a political point of view and a party's point of view, is against the people of Trinidad and Tobago, because I could clearly recollect being part of a government that was led by the member for Superior. The conduct and the work of the government was always on behalf of the people of Trinidad and Tobago, and always promoting the union of Trinidad and Tobago, which has existed from a historical point of view. And we will continue to fulfill that responsibility, because there's a current Joint Select Committee of this Parliament examining the work, or working towards what we would call internal self-government and so on, for the people of Tobago from a legislative point of view. And the opposition has its membership from this House and the other place, and we are working side by side with the representatives of the government in achieving the work of the Joint Select Committee, which has been established under your watch, Madam Speaker. But more importantly, Madam Speaker, with respect to the increase in the number of commissioners at WASA, and the board being increased from 9 commissioners to 11 commissioners, Madam Speaker, as the Member of Parliament for Couva South, I have a responsibility to ask, in the context of the skill sets that the government is looking for or seeking to add to the board, what is the speciality that will be added on that will take WASA in a different direction? Because, Madam Speaker, only yesterday, I think that it was in the public domain that a new board was appointed at WASA. A board that indicated, from what I read in the public domain, that it brought the tenure of the previous board came to an end on Monday of this week. And the board, the newly appointed board, under Commissioner or Chairman Seeley, was tasked with the responsibility of the transformation of WASA by focusing on the following: to build confidence in the operation of the of the water sector and the government's strategic intent. 2, to cultivate the operational efficiency and customer service. And 3, to restructure the water and wastewater section, Madam Speaker. And more importantly, I am forced to ask the question, what will 2 commissioners do to improve, or an additional 2 commissioners will do to improve what the customers, or how do they stand to benefit from the addition of these 2 commissioners in terms of the customers of the Water and Sewerage Authority? And you may ask why I'm posing this question. Over the last 5 years, this is a government in its 2nd term, and I think that this is probably the 3rd board which they have appointed. And at no point in time has the water supply, the efficiency of WASA has improved to the constituents of Couva South over the last 5 years, and this is in the 6th year of this government. And I am forced to ask this question, on behalf of all the constituents of Kufa South. Only last week, I had to join my colleague, the Member of Parliament for Caroni Central, in walking to the Freeport Water Works Station to get answers from the management of WASA based on the most inefficient water supply that the people of Central Trinidad, and not only Central, because somebody might jump up and say that Indarsingh only advocating on behalf of the constituents of Kufa South and Central Trinidad. But I want to say that I read the news and I'm in the public domain, and it is all over Trinidad and Tobago in terms of the water supply, inconsistent water supply, to the point that even for the Diwali holiday, I was bombarded with over 20 calls by constituents who was at what I would call psychological pain and suffering and trauma based on the water supply that they would have not received from WASA, Madam Speaker. And Madam Speaker, in addition to the improvement in the efficiency and what will come, we must never forget, Madam Speaker, and we would want to know, and we must be concerned, because are these two commissioners simply going to toe the political line of the existing government? Because we have been told in the budget presentation of the Minister of Finance, Madam Speaker, that the Cabinet of Trinidad and Tobago has established a subcommittee that is intended to examine the way forward for WASA, and a report was supposed to be handed in by the 30th of November. Is it a fait accompli now that, based on the work of the subcommittee, and this has been handed in, because I have...
Member, it's a bit late, and I think the ground, I've allowed you a lot of leeway. Okay? All of the ground that you've covered thus far has been quite well dealt with by the member from Yarra. So I'll ask you to go on to some fresh point, please.
No problem, Madam Speaker. I'm guided in relation to what will be the outcome in terms of the future of us. We wait with bated breath. Madam Speaker, as it relates to the amendments to the age of the board of the Children's Authority, the government is seeking to change the age of the person serving on the board from 30 to 35. What is this increase in the age seek to achieve? Because we are focusing, or we are being told, it was from a youth point of view. And the increase in the age, will it widen the options available for the government in selecting the members of the board? And I think that, Madam Speaker, I think that the minister with responsibility for youth in the Parliament of, in the Cabinet of Trinidad and Tobago should focus on standardizing the age by which we define youth in the country, taking into consideration, Madam Speaker, that the Commonwealth considers youth to be between the ages of 15 and 29, and in terms of there's a difference between the United Nations and the Commonwealth in terms of the analysis of what is the age category for youth. And going forward, probably it is the responsibility of the Minister of Youth and also the Cabinet to look or examine this issue of defining or standardizing the age category as it relates to youth in Trinidad and Tobago. And Madam Speaker, on one final issue, as it relates to the change from child psychologist to psychologist. Within recent times, Madam Speaker, we as a society, we have been littered with a number of issues affecting minors and affecting young children and affecting women in Trinidad and Tobago. And the government is seeking to change the wording in the legislation from child psychologist to psychologist, citing that there's a dearth of child psychologists in the country. I think that the government has seen the number of issues from a social point of view, which has been confronting families, confronting the vulnerable people, and throughout the length and breadth of the country. And I think that it is incumbent upon them. Apparently, they have realized now that there's the need to tackle this issue head on, and they are trying to fill this or try to address the issue of finding the appropriate skill set to deal with this social problem that is afflicting families throughout the length and breadth of the country. And Madam Speaker, as I said, with the increase in media reports of sexual abuse, it implies that there's an increasing prevalence of sexual abuse and therefore increasing vulnerabilities to be treated. The reason why child psychologists were first identified as essential to the Children's Authority was because of the demography that the authority seeks to serve in terms of children. Now I take the opportunity to make that appeal because I think that someone in the government should attempt to demonstrate to us how the vacancies will be filled, or how in addition to appointing someone to the board, where are we going to find the necessary skill set outside of the board to address families and to address those who are in need of the counseling and support and the guidance and so on, Madam Speaker. So, Madam Speaker, whilst the government might attempt to want to convince the population here this evening that the amendments from the point of view of the Tobago House of Assembly or the Children's Authority or the Water and Sewerage Authority and the Trinidad and Tobago Electricity Commission and the National Lotteries Control Board, and also at the level of the National Institute of Higher Education and Learning, is a very simplistic exercise because it is one that is simply focusing primarily on increasing the complement of persons who are willing to serve on these institutions. It goes beyond that because it takes into consideration hundreds of millions of dollars in terms of expenditure, probably billions of dollars. And I think that that is the direction my colleague from Mayaro was focused on when he attempted to seek the answers from the government of Trinidad and Tobago. So, Madam Speaker, from where we sit, we will continue to hold the government accountable. We will continue to ask the question in the interest of transparency and good governance. I thank you.
Attorney General.
Thank you, Madam Speaker. Madam Speaker, if ever I've seen someone rush to a podium to quickly make apology for a colleague of his own, it is Couva South. I compliment him on being a generous man in attempting to support his colleague, the member for Mayaro, from the exposure that the Prime Minister made this afternoon in relation to the opposition's position on Tobago. More perhaps succinctly put, their position in not being involved in the affairs of Tobago. You see, the last person with great passion was the member for Couva North in the last Parliament. There was no more an active speaker on matters concerning Tobago than Ramona Ramdial. Quickly put out to pasture, never to be seen again, following in the footsteps of Chrislyn Moore and the Tobago representatives of Delmon Baker and Vanilla Allen Toppin. So, Honourable Member for Mayaro, through you, Madam Speaker, you may want to be careful in being seen to be the advocate for Tobago in that UNC opposition, lest you find yourself out to pasture more quickly than not. Madam Speaker, the member for Mayaro said that there was no, in fact, the honourable member was quite bold in his opening to say that he was quite surprised at this bill. He said that he was in shock because he thought that the bill needed to be separated into elemental parts and that he couldn't figure out what the connection to the various matters in the bill involved. Madam Speaker, permit me to quickly say, it's divided neatly into two columns. On the left-hand column, we're looking at the harmonization of methods of borrowing. On the right-hand column, we're looking at the structure of boards. On that left-hand column, Madam Speaker, the borrowing power of the THA, WASA, and TNTEC have to be addressed and are plainly connected and obvious. On the right-hand column, the composition of the NLCB, NEHURST, WASA, and the Children's Authority are again plainly connected. And permit me to address the two columns in those brackets as they're set out in the clauses of the bill. Madam Speaker, the borrowing powers of the three entities that we look at in the bill, that is the THA in Clause 4, WASA in Clause 7, and TNTEC in Clause 8. This is critical to the modern operation of financing in this country. I have joined this debate in my capacity as the Attorney General and Minister of Legal Affairs, specifically because the legal opinions to be rendered in respect of borrowings as they concern guarantees, as they concern bonds, loans, etc., comes to the desk of the Attorney General for certification from the Ministry of Finance. When we look at the loops that the Treasury Solicitor has to jump through and that the Solicitor General has to jump through in trying to allow for modern methods of borrowing to prevail, it is immediately apparent that the WASA Act, the THA Act, and the TNTEC Act have to be brought into modern form. Why is that, Madam Speaker? Because when we look to the legislation, we see that the first thing that jumps out to us is that there is an ambiguity in the law that needs to be dealt with in certain circumstances. What do I mean? The Interpretation Act sets out the powers in Section 37 that happens when a written law is referred to in the establishment of a body corporate. When you establish a body corporate, by Section 37 of the Interpretation Act, you're vesting in that body, when established, the power to sue, be sued, to contract, and to be contracted with. You're also giving it the power to dispose of such property and to regulate own procedure and business. Put that into the context of WASA, TNTEC, and the THA, and look at the specific renovations that we're proposing in the legislation, and you will note, Madam Speaker, that when we look to the Water and Sewage Authority, when we look to the Tobago House of Assembly, and when we look to the TNTEC provisions, that we're dealing with archaic language, which now puts us in a zone of ambiguity. The last thing that you want to have in law when you're certifying borrowing is that your capacity to borrow is compromised because of an argument as to whether you are ultra vires or intra vires the legislation. Put simply in layman language, does the law say clearly that you have the power to do the thing that you want? So, Madam Speaker, let's look to the Tobago House of Assembly. The Tobago House of Assembly specifically involves an amendment to the law where we are looking at what the THA can do in its structure. And permit me to get you to that clause, Madam Speaker. We are looking at the THA Act in Section 51. Section 51 of the THA Act, Madam Speaker, and permit me to get to it specifically. It's a little bit harder on the podium than on a desk spread out. The Secretary may, with the approval of the Assembly, borrow by way of overdraft such sums as the Assembly considers fit for discharge of its functions. B, with the approval of the Minister, borrow sums by way of term loans for the purpose of capital investment. The mischief in this law is the reference to term loans. When you take the Interpretation Act, Section 37, and you look at the power that the Interpretation Act causes, you would have to put yourself in the realm of statutory interpretation on a purposive methodology to imply that modern methods of borrowing, that is securities, bonds, etc., in the widest sense as contained in the securities legislation where that term is defined, you would have to stretch the interpretation to allow for borrowing which is more than term loans for capital investment. Madam Speaker, therefore, it is imperative when we are seeking to amend this legislation that we bring it into modern purpose. The most modern of purposes to be found as to what a definition of a security is to be found in the Securities Act, where there is a proper set out of the definition of security. It is contained at page 28 of the legislation, chapter 8302, that's the Securities Act. And there is a wide definition of security which is purposefully incorporated into this amendment to the law so that there is flexibility going forward. Why is that so? Madam Speaker, the traditional instruments of borrowing have evolved over time. The Minister of Finance has already touched upon that, but I wanted for the record to state the reason for that. It is also the same purpose in the WASA Act. In the Water and Sewage Authority Act, Madam Speaker, we are looking to the definition in clause 20, in section 26. In section 26, there is a need also to again expand the fact that the Minister of Finance may allow for borrowing sums required for meeting any obligations and discharging any functions. And that, Madam Speaker, is critical when you're looking at, as the Honourable Prime Minister put it, the cash flow of WASA. The Tea and Tech Act was slightly more ahead of the other pieces. When you look to financial provisions in Part 5 at Section 21 of the Tea and Tech Act, the Tea and Tech Act had one anachronism. It was reference to President. As Attorney General, that sometimes caused confusion for borrowers as to whether that meant President in own discretion or President qua Cabinet, meaning as the Cabinet. It, of course, means as the Cabinet. But it was important to amend that law to tidy it up, again put the claw back to the definition of security. And, Madam Speaker, that is critical when you're looking at the fact that WASA and TNTEC in Trinidad and Tobago are heavily subsidized industries and authorities, and in one case a commission, and that therefore the flexibility must be there for terms of borrowing. Now, to deal with Mayara's point that there is somehow no form of check and balance, I'd perhaps say that my learned colleague is not aware. Certainly attorneys opposite, if they are familiar with this area, ought to know that the Minister of Finance under the Exchequer and Audit provisions, and where appropriate under external loans or developmental loans, has the oversight as Treasury and has the responsibility at Cabinet to treat with financing, etc. There is always oversight. Further, there is oversight in the Constitution by the application of Section 116 of the Constitution. That is why we refer the Auditor General and audited accounts to the inspection of the Auditor General and also to the laying of reports, which then go to joint select committees, which are standing committees in this Parliament. So I wish to simply reject the argument coming from Mayaro that there is no form of oversight and position. Madam Speaker, the member for Couva South raised the issue of what can 2 more members do on a board, 2 more commissioners. I'd like to point out what you can do with less. Madam Speaker, it's public knowledge. Member for Siparia ran a cabinet, if I'm not mistaken, of 34 people, 34 ministries. The Honourable Dr. Keith Rowley as Prime Minister, the member for Diego Martin West, cut that down to 23 ministries and did further cuts again. But Madam Speaker, we were able in that time to run a country in significantly more difficult circumstances, 95% drop in revenue from an oil and gas perspective, with fewer ministries, and therefore it's not so much what 2 people can do or 2 commissioners can do, but what 2 competent people can do in that scenario. I'd like to say that my colleague, the member, the Minister of Public Utilities, has the watching coordination of the report coming to Cabinet. I am sure the Honourable Member, my colleague, would have been eager to join in this debate. We had not anticipated some of these arguments, but he is fully prepared to join this debate if given the opportunity. But I'd like to say that the Honourable Prime Minister hit the nail on the head. It is the fact that in the expansion of capacity, professions, and knowledge on the Water and Sewage Authority that we will get the better skills, particularly when you're looking to water resources and winning. Madam Speaker, the Honourable Member for Couva South also raised the point of saying that Couva South had not seen any water or improvement in the last 5 years. I'd like to just put on the record, the last time I checked, the member for Siparia was serving in the UNC government. The member for Siparia served in the Bastio Pandey government. The member for Siparia served as Prime Minister in the PP government, as it was called then. Surely this country has not forgotten water for all, the pipe man, who had more pipe than not, who was supposed to be laying pipe where. But according to the UNC, when they spent 5 years between 2010 to 2015, everybody had water. Couva South had water. I find it astronomical that Couva South would come here today to say that all of a sudden people don't have water, when the truth is that instead of addressing the winning of water, reservoir management, the move away from desalination water and into pipe-borne water coming from wells, etc., or from distribution ends and mains that were actually working, that what the UNC government did instead was to put on the Beetham wastewater plant. And I certainly can see very little other than litigation coming out of that particular billion-dollar project. So I would urge my good friend, the member for Couva South, take it easy. Don't take too much basket, because this is certainly not a war that can be won. Permit me to get very quickly, Madam Speaker, to the position of the Children's Authority. And I'd like to publicly compliment my colleague, the member for Tobago East, the member with responsibility for children affairs and gender affairs, for taking a serious hands-on approach and working as a team member with all the rest of us. It's no secret that the Office of the Attorney General did a massive amount of work for children in conjunction with our colleagues, the Minister of National Security, the member for Tobago East as well. But Madam Speaker, we have to be careful in taking what other people say. When Couva South tells us the universal age is up to 29, no, Madam Speaker. The age must be looked in the context of the Children's Authority and the learning tells us and the experience tells us that you cannot find a graduate in child psychology. In particular, you cannot find a graduate under 30 years old to fit the youth category with certain skill sets. And therefore, it is imperative, and it was Tobago East that brought the note to Cabinet to identify the difficulties in securing a member onto the board of directors of the Children's Authority. In keeping that watchful eye, it was Tobago East that said, we have to help our children by broadening the age category. Madam Speaker, that applies to the very concept of child psychologists. In fact, the issue of whether we have child psychologists is a very real one. There is, in the experience of education in Trinidad and Tobago, psychologists. The subset of child psychology is not in fact taught at master's level in Trinidad and Tobago. And yes, we do need to have more dedicated attention in that field, but until we do, we have to take a step outside of child psychology and go to the broader elements of psychology. I am not sure if my colleague for Faizabad is going to speak next. If he is, I can say that we both had a conversation in relation to a few matters which I agree with. But Madam Speaker, permit me to end on a very important note. This country needs to publicly acknowledge a servant beyond servants. We lost just this month, just recently, Angela Moore, who sat as an expert drafter, a consultant, and worked upon the greatest number of laws in Trinidad and Tobago to treat with children. And I wish on behalf of the government and the entire Parliament to publicly salute her memory, to publicly salute her family, to uphold the passion that that honorable lady demonstrated in the umpteen hours that she sat with me as Attorney General in particular, working on the children's package of laws, tirelessly, never with complaint, ad hoc, as we develop laws for Trinidad and Tobago. Permit me to be so bold, Madam Speaker, to speak on behalf of the entire Parliament when we say a simple thank you to a beautiful daughter of Trinidad and Tobago for her work in relation to the children of this country, as it is grounded as well in the reflections on the amendments to the Children's Authority. I know I am out of time, Madam Speaker. May I ask how much more time I have?
You have, Attorney General, just about a minute.
I will take it that I am out of time, and I thank you, Madam Speaker, for the opportunity to contribute to this bill, and I thank my colleagues for bringing these well-connected matters squarely intent upon developing the interests of the people of Trinidad and Tobago, if even it is only that the UNC doesn't have the courage to even run a representative other than a proxy known as Watson Duke in the island of Tobago. Thank you, Madam Speaker.
Just to inform you, I have 10 more seconds left. I now call upon the member for, this is Shogunas West. Thank you.
Thank you, Madam Speaker, for giving me the opportunity, allowing me the opportunity to contribute to this important debate. Madam Speaker, as I start, let me first join our Honorable Attorney General in extending condolences as he did, and also, bringing those sentiments in the House, which we wish can somehow bring some reprieve to those who are mourning for one reason or the other. We also want to take this opportunity on this side to say that we are certainly in a state of solemnity when we think of all those who are victims, all those women who are victims of sexual abuse, murders, domestic violence, we would like to say from our side, and I'm sure, joining on the Honorable Attorney General, we really wish to extend our solemnity on this occasion and would wish to offer support in whatever way we can. That being said, Madam Speaker, it is correct that we have this particular bill, statutory authorities, miscellaneous amendment, statutory authorities, matters related to certain boards. And yes, it does allow amendments which would give certain powers, certainly, to have issuance of securities that, would allow borrowing power and what have you. But I want to respond to some of the comments in terms of the Honorable Attorney General speaking about member for Couva South and member for Mayaro and some of my colleagues on this side. And the point I wish to make is that, Madam Speaker, to paraphrase the words of the Attorney General, I do not like when it is we have to debate and we raise certain concerns, valid concerns about spending monies, and we are talking about accountability, even with our twin sister isle, that we are pitted as though we are against Tobago. And I want to paraphrase the Honorable Attorney General today when he said, just stop it. Just stop it. It is not our business here to pit one set of members against, the Tobago population. And it is certainly not our intention. In fact, member for Couva South and myself, I know I speak for him when we say that we are honored to sit in the JSC, the Constitution Amendment, Tobago Self-Government Government Bill 2020. And that is something that I know that we don't serve any hidden agendas. We try to contribute in the best way possible on that matter to ensure that you keep a unitary state, Trinidad and Tobago, and to ensure that we get the best for the peoples of Trinidad and Tobago. Madam Speaker, I want to say on a personal note that as far as I can remember, I have been going to Tobago myself. In fact, the preferred choice of, tourist destination and the preferred choice for us for relaxation is going to Tobago. And I have been doing that up to when the pandemic started earlier this year. But otherwise, Madam Speaker, I really take offense that we are so broad-brushed as though we have an agenda against Tobago. It is not so, and I want to again say, just stop it. The business of the opposition is to critique constructively what is being presented in the Parliament. And Madam Speaker, I dare say that that is what member for Mayaro did, and as well as my other colleagues who followed. This is what we are about. So to our Honorable Prime Minister, I want to say that we are really not against Tobago people. We really want to see that the best laws are implemented, the best policies are implemented so that we can have the best for the peoples of Trinidad and Tobago. Now, we want to talk about, Madam Speaker, I know that one of the questions which was posed by the Honorable Attorney General, how many members, if you have 2 more members, and what they can do. And Madam Speaker, the point remains this. It is very simple. We have a serious water shortage problem in this country. When you look at memes that pass in social media, the most and by far the most popular meme is that there's an umbrella over all of the water dams in Trinidad and Tobago when there's flooding all over in the constituencies. And there's a reason for that. It is because there's a vast shortage of water. Even at Couva South, my colleague was saying that, Member of Parliament for Couva South, that there are water problems. Member for Couva North. And I myself, Madam Speaker, up to this week, earlier this week, I had somebody complaining about how long it is taking to get back the restoration of normal water supply. This continues to plague people. And in a pandemic, you can imagine a shortage of water. What does it mean for people if it is you have shortage of water? Now, that is one matter, please, Madam Speaker. But I also want to say that, you know, in fixing the problems of the country, this is what we are all here collectively to do. And I have looked at this particular bill, and one of the issues that stood out for me, and I know colleagues to follow may take up on this point, is that we are talking about borrowing powers of Tobago House of Assembly. Now, the point about it is that they already have borrowing powers. So the question was that, yes, you may have legislation here which will somehow enhance that borrowing power, but to what end? Is there what was the mischief that was intended here? When we are talking about delivery to Tobago people and this whole notion, as I say, pitting Trinidad, us on this side against Tobago people, as though we only belong to Trinidad, we belong to Tobago as well. We belong to this Twin Island Republic of Trinidad and Tobago. I want to say that the records will show that since the first quarter of 2017, Madam Speaker, you had the breakdown in the ferry service. Who spoke out against that? Members on the other side or members on this side? In fact, hoteliers started to close down.
Bill, Standing Order 48-1. This bill is specific to the borrowing powers of the House of Assembly. It has nothing to do with the ferry service or those other extraneous matters.
One person. Yes, I only recognize the Minister of Finance. So so Member for Chaguanas West, I uphold the objection, and if please we can stick now to the bill. A lot of the points have been raised already, certainly in terms of the explanation of what the opposition has set out to do by the two previous speakers. So I'll ask you please to be mindful of Standing Order 48-1, and please try not to repeat the points that have been made already. Thank you.
Madam Speaker, I'm guided, and I thank you for that ruling. Madam Speaker, the simple point that I would want to make is that when you have in a debate which has just occurred, and Madam Speaker, I don't care to repeat anything that I've said before, but when you have a debate and we on this side are being painted as though we are somehow inherently objecting to anything going towards Tobago, towards the Tobago House of Assembly, I am saying, Madam Speaker, that when you look at the track record of events, public events which have plagued Tobago, we on this side have spoken out. So I was simply referring to one of those matters before, and I will say that when matters have arisen traditionally with Tobago people, we on this side continue to speak out on that. When we raise a question about during the pandemic that you are spending $50 million,
and I will ask you to move on.
Yes, please. I am guided. So, Madam Speaker, one of the things that I want to say is that in terms of the bill itself, I have asked squarely, Madam Speaker, and I don't wish to rehash it, that when you are talking about enhancing the borrowing power, because this is what you're seeking, obviously, to do at Clause 4 with the Tobago House of Assembly Act, to raise monies by issuing of securities. In my limited knowledge, Madam Speaker, and I must confess, I hope that the Honourable Minister of Finance will give some clarity to this, that the THA is not necessarily like the other categories of entities that we see here. So that when you're adding on this power to issue securities, I'm saying that the THA is already, it possesses the power to borrow monies as it sees fit. And there are certain checks and balances which are in place, and therefore the question is, why is it that this clause is coming here at this point in time? So, Madam Speaker, that is the main point I would want to point out here. My colleagues before have spoken about the increase in the number of the members to the different boards. That is something that I share as well. And, Madam Speaker, when we look at the bill in totality, the question is, we would like to see that if this is being implemented, some kind of assurance that it is going to bring some kind of effective output, that we can see that there's greater delivery of services, as member for Couva South has said, greater services under certainly the utility entities such as WASA and TNTEC. So, Madam Speaker, with these few words, I thank you again, and I wish to thank my colleagues on this side who have risen to support our position on this side in relation to this statutory authorities bill. Thank you.
Member for Tobago West.
Thank you, Madam Speaker. Madam Speaker, it's a privilege for me to join this debate this afternoon, and I joined this afternoon, Madam Speaker, I wasn't prepared to speak, but after hearing the contribution of the member for Mayaro, followed by his colleagues, I felt like it was important for me to add my 2 cents and to join this debate as a Tobagonian, Madam Speaker. I have been in this Parliament for 11 years. This is my 11th year, Madam Speaker, serving in this Parliament. And we have consistently heard from the United National Congress and their partners the very worst of Tobago. Every time this government tries to do something for Tobago, whether it's increasing autonomy or giving some type of assistance to the Tobago economy and the Tobago people, the members of the opposition, the member of the UNC, whether they are in opposition or in government, always speak out against it, always saying that Tobago is getting too much. Madam Speaker, I stand here today hurt and disheartened to listen to that contribution from that member of Parliament for Mayaro. After sitting here for 5 years, he is no new member, Madam Speaker. Madam Speaker, I stand here today a 38-year-old. The Tobago House of Assembly today celebrates 40 years of existence. 40 long, strong years of standing in the gap for the people of Tobago, championing our development, the development of our people, the development of our economy. And to be a Tobagonian, we have been getting 4% or less of the budget over the years. And for the UNC to stand before us today, we have been arguing, we have been fighting for the ability to borrow so that we can move closer and closer to realizing the dreams and the aspirations of Tobagonians and fulfilling our development agenda in a more predictable way, in a more effective way. 40 years, Madam Speaker. It is embarrassing to stand here after 40 years, as a 38-year-old, to face the Parliament to ask for the ability to borrow. Watching state enterprises year after year having the freedom to borrow. And to listen to all these allegations about Tobago having all these issues with the Auditor General and not submitting our financials on time. Over the years, Madam Speaker, yes, there has been challenges, but no way in any of these reports can you find any public figure in Tobago stealing money. We cannot say the same for Trinidad. We cannot say the same for many of the ministries, especially under their watch, Madam Speaker. I turn to the reports from the Auditor General and the PAC today. For Mayaro, outstanding. For Siparia, all their financials are outstanding over 5 years, Madam Speaker. I want to give you more direct and detailed information. Siparia has not submitted for 2014, 2015, 2016, 2017, 2018, 2019, or 2020. I turn to Mayaro, Madam Speaker, have not submitted financials to the PAC for 2009, 10, 11, 12, 13, 14, 15, 16, 17, 18, 19, 20. I turn to Couva Tabakit, Madam Speaker, and they have not submitted financials to the PAC for 2006, 7, 8, 9, 10, all the way to 2020, Madam Speaker, and that is based on the information from the PAC of this Parliament. So to stand here to speak down on the Tobago House of Assembly, they should be ashamed, Madam Speaker. And after the member for Mayara made a mess of it, you have all the other following speakers coming to give us some half-dead apology as a Tobagoan, a 38-year-old Tobagoan celebrating 40 years of a Tobago House of Assembly, where we have been flying the flag of Tobago high, and we become more and more beautiful each and every year despite the allocations from Trinidad. I say keep your sappy, sour, half-dead apology. So, Madam Speaker, and this UNC that is now trying to give us all this sweet talk, we have been fighting and speaking on behalf of the people of Tobago, trying to get internal self-government, trying to pass this legislation through the Parliament, trying to get their support at the different committee levels. I look forward to your support when we face this Parliament once again. I have sat here in this Parliament and heard members of the UNC call the Tobago House of Assembly and call Tobagoans lazy, Madam Speaker.
Speaker 48.1. This debate is about teachers' ability to borrow or internal self-government.
48.6 as well, please.
So, member for Tobago West, I uphold 48.1. I ask you to come back. I overrule 48.6.
I would connect the dots, Madam Speaker. Madam Speaker, we stand here asking to borrow not because we feel to borrow, Madam Speaker. It is to realize our dreams and our aspirations towards building our economy, towards improving our productivity, towards contributing to the GDP of this country, Madam Speaker. So to be called lazy and unproductive and that we don't contribute to the national economy of this country,
Madam
it is a
Speaker,
shame, Madam Speaker. I'm
48.6,
speaking
no one
about
at this
my
side
experience
imputed
here
anything
and the reason why we are
about
borrowing.
being lazy and so on.
1 minute. I can't see you using 48.6 to say that you didn't impute. I would expect you would say 48.6, somebody imputing something against you. So I overrule. Please continue.
Madam Speaker, we are asking to borrow, I repeat, to utilize these funds to develop Tobago in a more predictable and effective manner so that we can no longer be called lazy by the UNC. We can no longer be called unproductive by the opposition, Madam Speaker. We can no longer be called, we're sitting there lazy and looking to be rapists and preying on the tourists. We have experienced that as Tobagoans, and we want to graduate out of being called that by the opposition. So I'm not surprised by the presentation of those opposite, Madam Speaker.
48.6, Madam Speaker, please.
I think you're asking me to rule on something that I just ruled before, and I overrule. Please continue.
Thank you very much, Madam Speaker. They don't like to hear the truth. Madam Speaker, in 2012, the Tobago House of Assembly faced Moody's for a credit rating. We received a Moody's credit rating of Baa1, and that indicated the outlook, and Moody's would have indicated that our outlook was stable, Madam Speaker. The Tobago House of Assembly, the ratings given to the Tobago House of Assembly was the first sub-sovereign ratings to be issued to an English-speaking Caribbean country. And I want to say, Madam Speaker, this is not me speaking, this is Moody's saying. The Tobago House of Assembly financial performance was relatively strong, in part due to the institutional constraints regarding debt issuance, which included self-imposed limits undertaken by the current administration, that is the PNM administration, based on the prudence of the Tobago House of Assembly managing Tobago people's financial affairs. Madam Speaker, the fact that we make this request, and this request could be about 40 years old, Madam Speaker, is in keeping with where we want to go as Tobagonians, our aspirations for our economy and the dreams of our people. I think that this ratings over the years has sent a strong signal, in fact, stating about how the Tobago House of Assembly conducts its affairs in keeping with international policies, international procedures, and international parameters. Madam Speaker, this request to receive this ability to borrow that had been granted only by this administration after decades, Madam Speaker, speaks to us asserting our autonomy towards becoming more self-reliant and self-sufficient, Madam Speaker. Over the years, it has never been about missing funds, Madam Speaker, but about administrative documents that could not have been found at the time. And that could be said for many other ministries. And later on, the research and the investigations would have been done, and we had been able to come up and prove that nobody in the Tobago House of Assembly, no secretary, no politician, no PNMite, nobody in the Tobago House of Assembly was stealing money from the Tobago House of Assembly. We don't have a life sport project where anybody walk away with any $34 million or any scandals of that sort over our years. So I stand here, Madam Speaker, as a proud Tobagonian, as a proud PNMite, as a proud member of this government and this cabinet, who has made the necessary steps and taken the necessary action, as difficult as they have been, in a time of little, Madam Speaker, to offer to Tobago the type of financial assistance, the type of financial support that it deserves, bringing Tobago side by Trinidad each and every step along the way. We have a long way to go, Madam Speaker. So I don't even think it's necessary for me to come here and speak. I should not have to. This should be understood by each and every parliamentarian who sit here and watch Tobago get 4% of the budget while you enjoy 96% of the budget, along with the ability to borrow and to pursue your economic goals freely. Here we are, still begging a parliament. I want to thank the Prime Minister, the Minister of Finance, the members of the Cabinet who have seen it fit to provide this level of assistance, this level of support. And we are not waiting to get internal self-government. We are taking steps little by little, increasing the autonomy, and increasing the authority of the Tobago House of Assembly, granting to Tobagonians the type of life, the type of leadership, the type of management that it deserves, Madam Speaker, in a time of little. When they had the chance to perform and to show this love that they claim for Tobago, they gave us nothing, Madam Speaker, precious nothing. And if you look around Tobago and you make the comparison between their time of leadership and our time of leadership, it is very clear, Madam Speaker. So I stand here confidently, and I support this bill to grant Tobago House of Assembly and the people of Tobago the ability to borrow so we can advance our development mandate. With or without the opposition, this People's National Movement is hell-bent about taking Tobagonians to the next level, with or without the opposition. And it is because of that same posture that they have shown over the years for decades. They cannot stand in Tobago. They won't get a vote. They can't vie for a seat. And even as they hide behind other parties, not a single vote for you. Not a single vote for you. You came as DAC, NAR, TOFDAC, TOP, Tobago Forwards, PDP, not a seat for you.
48-1, Madam
So,
Speaker.
Madam
What's the
Speaker,
relevance of all of this?
we stand
48-1, Madam
resoundingly
Speaker.
with this government.
Please continue.
We stand resoundingly with this government. The people of Tobago, the Tobago House of Assembly, and we thank you for hearing our cries and hearing our pleas. And we continue to work hand in hand with this government as we continue to build Tobago and develop a brighter Tobago for Tobagoanians. We will not be fooled, Madam Speaker. We have seen all we have to see and heard all we have to hear, Madam Speaker, and we know the UNC and we know what they stand for, Madam Speaker. The people of Tobagoanians will not be fooled, and we will continue to support this government and the People's National Movement, because that's the only place and the only way we can get development in Tobago. So I want to thank you, Madam Speaker, and I want to thank this government, and I hope this bill is passed. And since you love us so much, go ahead and give us that vote. Give us your support. Thank you very much.
Thank you very much, Madam Speaker, for the opportunity to make a very brief intervention. And it's really specifically with regards to Clause 6, dealing with child psychology, the amendment there. And I have a slightly different perspective. I know my colleague for Cuba South would have mentioned this before. But before I go there, I just want to reiterate that we on this side have nothing against Tobago, Madam Speaker. In fact, I'm speaking so late in this debate because I gave way to the Honourable Member for Diego Martin West, the Prime Minister, who I know is from Tobago. So that speaks volume. I also want to say that during the term of the People's Partnership Government, we completed the Scarborough Hospital. But Madam Speaker, most importantly, I want to say, and this is actually interesting because it connects Tobago and what I want to say about psychology. And I just want to say that my daughter spent 3 months in Tobago doing an internship in her master's in psychology by choice. I think the member for Tobago East would be aware of that because I would have been traveling back and forth during that time. So that's my connection to Tobago. But Madam Speaker, I just wanted to make a few brief comments and to say that anything that is brought to this Parliament, any measure that is brought to this Parliament in support of the work of the Children's Authority, we are on this side, and I will say right at the onset that this amendment, I understand the need for this amendment, and I'm speaking particularly about Section 7(2)(b), which is to change the reference from child psychology to simply psychology. Because as we know, the Children's Authority has had its fair share of challenges. I mean, the reports would indicate that over 4,000, upwards of 4,000 complaints are made to the Children's Authority on an annual basis. So the problem here really is that there is a shortage of child psychologists worldwide. And in fact, in Trinidad, there might just be one child psychologist. So I can understand that finding a suitable member to serve on the board of the Children's Authority would have been a challenge. And I think I can understand why we are in this predicament, and therefore I understand the need for the government to do this. But I also think, Madam Speaker, it's an opportune time just to have a look at how we will address this problem. And I understand that we are going to replace child psychologists by psychologists. And this is really an opportunity as well to look at the issue of psychology in Trinidad and Tobago. And the first thing I realized in my research in this matter, because I spoke with the president of the Trinidad and Tobago Association of Psychologists, was to try to determine how many psychologists actually practice and work in Trinidad and Tobago. And the president of the association could not give me the answer. And Madam Speaker, the reason she could not give me the answer is because the Trinidad and Tobago Association of Psychologists, a body incorporated by law in this Parliament in 2000, is just a representative body. It is not a licensing body or a regulatory body. And this is a very important point. So it means that the psychologists who register with the TTAP do so voluntarily. There is no obligation. So the president, and I speak with her permission, indicated to me that there are 113 financial members. I believe that there are more psychologists practicing in Trinidad and Tobago, but I mean, it speaks volumes that we are not able to identify the number of psychologists. And that's another issue, Madam Speaker, because that in itself is a worrisome thing, because this specialty of psychology is very important. There's a difference between psychology and psychiatry, as I'm sure all my colleagues in this House know. Psychiatrist is a medical doctor qualified and so on, and would be governed by the Medical Board Act of Trinidad and Tobago and registered per se. But psychologists play a very, very important role in terms of supporting the work of psychiatrists and even avoiding patients having to get or clients having to get to see a psychiatrist. So they have a very important role, and there are two issues really that need to be addressed. And I know this would have come to the attention of the Minister of Health and the Attorney General in submissions and so on. But if the issue I really want to raise and to address and to ask us to look at is to look at the issue of regulation, of regulating the profession of psychology. Now, interestingly, psychiatric social workers who form part of a mental health team are governed by the Act, which is the Professions Related to Medicine Act, but psychologists are not. So the benefits of regulating the profession of psychology are many. Most importantly, it would be in the interest of protecting patients. In my own specialty, for example, Madam Speaker, the issue of postpartum psychosis. And in fact, I know there was a question raised earlier about the maternal death. I don't want to go there, but just to say that in England, for example, in the UK, European countries, one of the commonest causes of maternal deaths now is postpartum psychosis leading to suicide and so on. And those kind of things can be averted, with the intervention of a proper psychologist. So I think it's very important for patient protection to ensure that we have standards, proper standards and so on. Another important point is that the Insurance Act doesn't allow for insurance payments when patients visit a psychologist. If they go to a doctor, it's different. And therefore, that can sometimes deter patients from, seeking treatments from psychologists. So that's another issue that we can look at. But most importantly, it really is to protect the standards of the profession to ensure that, the patients, are treated by those who are most qualified and certified and so on. And of course, a regulating body would have the power by law to be able to look at any infringements. Another issue that was raised by the president of the TTAP, Trinidad and Tobago Association of Psychologists, is the fact that there are many psychologists who apparently, because it's not a regulated profession, who are practicing out there, member for Tobago East, and may not necessarily have the qualifications, and especially when they're dealing with children, that's very, very important. The basic minimum should be a master's in clinical psychology and preferably a doctorate. And I just declare my intention here, Madam Speaker, because I have an interest in this because my daughter is actually completing a doctorate in psychology at the moment. So I take a very keen interest in this as well. So I just want to ask the government and the Attorney General, perhaps the Minister of Health, to look at the whole issue of the regulation of this profession. I know that there is tremendous support from the Trinidad and Tobago Association of Psychologists. I know that they have a document prepared, so it's not going to be very difficult to cross that bridge. And I think if there's anything that can come out of this legislation would be, I will support this amendment, but I think it's also important that, we take the next step and we go forward in terms of the regulation of the practice of psychologists in Trinidad and Tobago, Madam Speaker. I promised the Minister of Finance I'll be brief. I know it's late. And I just want to close by saying that this whole issue of the shortage of psychologists and the issue of mental health has become even more pronounced in the public domain with the COVID-19 crisis. That's another debate, that's perhaps for another time, but I think is even more important as part of the whole challenge that we face with COVID-19. Now we have the issue of the need for psychological counseling and treatment and so on. So with those few words, Madam Speaker, and I'm not one to incur the wrath of the Minister of Finance, I just want to say thank you for the opportunity. Thank you very much, Madam Speaker.
Thank you very much, Madam Speaker. And the member of Parliament for Faizabad went way over the 5 minutes that he promised me. Typical UNC. So, Madam Speaker, let us deal with some of the points raised. It is really disappointing, Madam Speaker, to participate in a debate and when one hears the contributions of honourable members opposite, it becomes obvious that they have not read the legislation before us, bothered to understand it, or interpret it, or to make any meaningful comment whatsoever. One gets the impression that just decided to get up and talk. So let me deal first with the whole question of the Tobago House of Assembly's power to borrow, which we are seeking to amend by way of this bill. In Section 51 of the Tobago House of Assembly Act, the Secretary of the Assembly is empowered with the approval of the Assembly to borrow by way of overdraft such sums as the Assembly considers fit for the discharge of its functions, or with the approval of the Minister, and in this particular case, it means Minister of Finance, borrow sums by way of term loans for the purposes of capital investment. I heard the member for Shogunas West say that he thought that the THA already had the power to borrow, so why the need for this legislation? I was really disappointed by that question, especially from a legal luminary, because one would think that if one is coming to comment on an amendment bill, one would do the necessary research. The THA is limited in terms of what it can do by the words in that Section 51, and in particular, the words term loans. And if honourable member from Shogunas West does not know what a term loan is, I will educate him. A term loan is a loan from a bank for a specific amount that has a specified repayment schedule. In this particular case, we are amending the Act, the Tobago House of Assembly Act, to improve that Section 51, and in particular, in the improvement of Section 51 of the Tobago House of Assembly Act, we are allowing the Secretary, by way of insertion of a new Section 51A, with the approval of the Minister, to raise money by the issue of securities for the purposes of meeting any of the obligations and discharging any of the functions of the Assembly. In no part of the world, Madam Speaker, no part of the Commonwealth, no part of the Caribbean, and no part of Trinidad and Tobago is a term loan a security. And again, for the edification of the honourable member for Shogunas West, a security, if one goes to the Securities Act, is any document, instrument, or writing evidencing ownership of or any interest in the capital, debt, property, profits, earnings, or royalties of any person, and without limiting the generality of the foregoing, extends to any bond, debenture, note, or other evidence of indebtedness. A term loan is not a bond. And I was very clear in my introduction of this bill that the reason why we're doing this is to allow the Tobago House of Assembly to access syndicated financing arrangements which would be made available by way of a bond instrument. I was clear, and therefore I am just taken aback at the question as to why we are doing this. Very disappointing. If you go now to a point made by the honourable member for Tobago West, and in her stirring contribution, one of the points the honourable member for Tobago West made is that this amendment, which will improve the House of Assembly's ability to borrow money by various diverse means, including getting
an arranger to arrange a syndicated financing facility, the member for Tobago West made the point that this is necessary. This amendment that we are making is necessary to give the Tobago House of Assembly the flexibility to access loan financing from the financial market for the purpose of the development of the island of Tobago and for the benefit of the residents of Tobago. And just as an aside, I think it's very pertinent, because there is absolutely no doubt that we should give the Tobago House of Assembly this flexibility, especially because honorable members opposite, for the last 6 years, in the 6 standing finance committees that this Dr. Keith Rowley administration has overseen, in every single standing finance committee, when we deal with the allocations to the Tobago House of Assembly, members opposite grumble, complain, indicate their displeasure, and say that the Tobago House of Assembly is not deserving of the allocations they are given by way of appropriation. So we are now avoiding that old talk by giving the Tobago House of Assembly the power to borrow with the approval of the Minister of Finance, which will give the requisite oversight for development purposes, to avoid that old talk that we have to deal with every standing finance committee. There's absolutely no doubt there's a theme that comes through that the THA is not deserving of funding by the government of Trinidad and Tobago. Let me deal now with the whole question of the laws that we are amending, because none of the members opposite bothered to read the Trinidad and Tobago Electricity Commission Act, the Water and Sewerage Authority Act, the THA Act, or the Securities Act. So let me edify members opposite. The Water and Sewerage Authority shall consist of no fewer than 5, no more than 9 persons to be designated commissioners, appointed by the minister. 4 commissioners shall be appointed from among persons who have special qualifications in and have had experience of matters relating to engineering, accountancy, law, economics, or business management. What this means is that if the full complement of 9 persons is appointed, it means that 4 of them have to have these qualifications, and the other 5 are not limited by these qualifications. And as the Honorable Prime Minister has pointed out, we have chosen to appoint a geologist to the board of the Water and Sewerage Authority, specifically to deal with the whole question of water resources and the winning of water, the drilling of wells for water, to get groundwater from aquifers, and to look at surface water and that sort of thing. And this is the kind of skill set that we wish to bring to the board of the Water and Sewerage Authority, in addition to these matters here which are prescribed: engineering, accountancy, law, economics, or business management. And we felt it was necessary, since we have a policy decision to restructure the Water and Sewerage Authority, that we should bring as broad a skill base as possible to bear on the board of the Water and Sewerage Authority, because they can then appoint multiple subcommittees and persons who deal with the accounting side of things, the operational side of things, the engineering side of water, the water resources side, can then be put to chair these various subcommittees. And that is the reason why we're expanding the board of the Water and Sewerage Authority. With respect to the Trinidad and Tobago Electricity Commission, if you look at Section 21, which is being amended by Clause 8 of this bill, it's a very old law, and it used the word president. The commission may, with the approval of the president, borrow, secure, or raise money, but it's a well-known determination that when you look in a law and you see the word president, you have to look how it's used and whether there are words that occur after it, such as in consultation with the leader of the opposition and the prime minister and so on. In this particular case, this means cabinet, and it was thought that that was a bit cumbersome, since in terms of all other financing, the Minister of Finance would do the approval after
Cabinet has deliberated upon it, so we are changing President to Minister of Finance to make it consistent with virtually every other law that gives the power to borrow with the approval of the Minister of Finance. We're also giving the Trinidad and Tobago Electricity Commission the ability to invest or deal with securities and raise bond issues and so on, in keeping with modern financing methods in the terms of syndicated financing. With respect to the Water and Sewerage Authority, similarly, we are giving them similar authority to issue money or to raise money by way of securities. And as I indicated, the definition of security in the Securities Act includes a bond. And Madam Speaker, that's about it. In terms of the amendment to the Children's Authority Act, I heard one honorable member over there saying, why are you doing that? Not understanding, of course, I think that was Kuvasaut. Not understanding what we are doing is increasing the maximum age of the youth representative on the Children's Authority. That's all we're doing. Because right now, the youth representative on the board of the Children's Authority is limited to a person who is 30 years of age or less. And we're simply increasing that to 35 to allow the government some flexibility in terms of selecting an appropriate person to represent youth on the board of the Children's Authority. If you had bothered to read the Children's Authority Act, you would have understood what this was all about, so you wouldn't have to ask that irrelevant question. And with respect to psychologists, I would caution the member for Faizabad, be very careful how you make recommendations in this parliament, because you came across, honorable member, as if you were pleading your own case. I am not aware that in the Legal Profession Act, one has to have a master's degree or a doctorate. I am not aware that in the Medical Profession Act, in order to be licensed, one has to have a master's degree or a doctorate. I am not aware in the Dental Profession Act that in order to have a license, you must have a master's degree or a doctorate. So why on earth would you make a recommendation that we must license psychologists and they should have a master's degree in clinical psychology and even a doctorate, and then you reveal to all of us that you have a relative who is studying to become a doctor of psychology? I really think that was very unfortunate, and I would ask members opposite, be very careful what you say. These things are not simple, and there are many consequences for these kinds of loose utterances. I beg to move, Madam Speaker.
Honourable members, the question is that the miscellaneous amendments, powers of statutory authorities and matters related to certain boards bill 2020 to amend the National Lotteries Control Act, Chapter 2104, the Tobago House of Assembly Act, Chapter 2503, the National Institute of Higher Education, Research, Science and Technology Act, Chapter 3958, the Children's Authority Act, Chapter 4610, the Water and Sewerage Authority Act, Chapter 5440, and the Trinidad and Tobago Electricity Commission Act, Chapter 5470. We now read a second time. All in favor say aye. Any against? The ayes have it.
Bill entitled An Act to Amend the National Lotteries Control Act, Chapter 2104, the Tobago House of Assembly Act, Chapter 2503, the National Institute of Higher Education, Research, Science and Technology Act, Chapter 3958, the Children's Authority Act, Chapter 4610, the Water and Sewerage Authority Act, Chapter 5440, and the Trinidad and Tobago Electricity Commission Act, Chapter 5470, to provide for amendments to the composition of various boards and the borrowing powers of certain boards and matters connected therewith.
The Minister of Finance.
Thank you, Madam Speaker. I beg to move that the miscellaneous amendments, powers of statutory authorities and matters related to certain boards, Bill 2020, be committed to a committee of the whole.
Honourable members, the question is that the miscellaneous amendments, power of statutory authorities and matters related to certain boards, Bill 2020, be committed to the committee of the whole. All in favour say aye. Any against? The ayes have it. This House will now go into the committee of the whole to consider the bill clause by clause.
Clause 1.
The question is that clause 1 stand part of the bill. The question is that clause 1 now stand part of the bill. Those in favour say aye. Those against say no. I think the ayes have it. Clause 1 now stands part of the bill.
Clause 2.
The question is that clause 2 stand part of the bill. Minister of Finance.
Madam Speaker, an amendment has been circulated to clause 2, and again, this is stylistic, and it is what has been recommended by the Chief Parliamentary Counsel as the appropriate form of words for a commencement provision. We've gone through this before today, and I would simply ask that the clause 2 be amended as circulated.
The question is that clause 2 be amended as circulated. Those in favour say aye. Those against say no. I think the ayes have it. The question is that clause 2 as amended now stand part of the bill. Those in favour say aye. Those against say no. I think the ayes have it. Clause 2 as amended now stands part of the bill.
Clauses 3 to 8.
The question is that clauses 3 to 8 stand part of the bill. The question is that clauses 3 to 8 now stand part of the bill. Those in favour say aye. Those against say no. I think the ayes have it. Clauses 3 to 8 now stand part of the bill. Honourable members, the question is that the bill as amended be now reported to the House. Those in favour say aye. Those against say no. I think the ayes have it. This committee is now adjourned. The House will resume.
Thank you, Madam Speaker. I wish to report that the miscellaneous amendments, powers of statutory authorities, and matters related to certain boards, Bill 2020, was considered in Committee of the Whole and approved with one amendment. I now beg to move that the House agree with this report from the committee.
Honourable members, the question is that this House agree with the committee's report on the miscellaneous amendments, powers of statutory authorities and matters related to certain boards, Bill 2020. All in favour say aye. Any against? The ayes have it. Minister of Finance.
Madam Speaker, I beg to move that the miscellaneous amendments, powers of statutory authorities, and matters related to certain boards, Bill 2020, be now read a third time and passed. Or be forthwith read a third time and passed.
Honourable members, the question is that the bill Miscellaneous amendments, powers of statutory authorities and matters related to certain boards bill 2020 be forthwith read a third time and passed. All in favor say aye. Any against? The ayes have it.
A bill entitled the National Lotteries, a bill entitled an act to amend the National Lotteries Control Act 2104, the Tobago House of Assembly Act, Chapter 2503, the National Institute of Higher Education, Research, Science and Technology Act, Chapter 3958, the Children's Authority Act, Chapter 4610, the Water and Sewerage Authority Act, Chapter 5440, and the Trinidad and Tobago Electricity Commission Act, Chapter 5470, to provide for amendments to the composition of various boards and the borrowing powers of certain boards and matters connected therewith.
Attorney General.
Thank you, Madam Speaker. Madam Speaker, I beg to move that a bill entitled An Act to Amend the Supreme Court of Judicature Act, Chapter 401, the Summary Courts Act, Chapter 420, the Coroners Act, Chapter 604, and the Sexual Offences Act, Chapter 1128, to provide for the procedural matters of the courts and for related matters thereto, be now read a second time. Madam Speaker, the bill before us is of great importance. We seek in 6 clauses to amend 4 particular laws. In the first case, Madam Speaker, we're amending the Summary Courts Act. In the second, we are seeking to amend the in the first we seek to amend in Clause 3 the Supreme Court of Judicature Act. The second law that we seek to amend is the Summary Courts Act in Clause 4. We then seek to amend the Coroners Act in Clause 5. And we lastly seek to amend the Sexual Offences Act in Clause 6. Permit me to say, Madam Speaker, that we do have a few small amendments to make, which we would propose to circulate at committee stage, and they will really not occupy too much of trouble for honourable members as I explain the purport. Madam Speaker, the Supreme Court of Judicature Act in Clause 3 seeks firstly an amendment for the introduction of a drug treatment court process. We then seek, Madam Speaker, to allow for the referral to a drug treatment court process. We also seek, Madam Speaker, to allow the Honourable Chief Justice to issue directions with respect to the hearing and taking of evidence in criminal and civil trials. Madam Speaker, we also propose in the Supreme Court of Judicature Act to treat with the amendments to allow for the move to the perfection of electronic management of records and structures at the judiciary by allowing for the making of the rules-making capacity and the ability to apply administrative fees in respect of certain matters. Those amendments are with respect to the drug treatment process replicated in Clause 4. We will propose to have an amendment to Clause 4 where we add the drug treatment process itself into Clause 4. We have already the replication of the power of the Honourable Chief Justice to treat with virtual hearings and taking of evidence in Clause 4. And then the Coroners Act, in summary, treats with very important amendments to allow for improvements in the administration of justice as it relates to the Police Complaints Authority. Clause 6 is intended to remove the obstacles to the full operationalization of the Sex Offenders Registry. So, Madam Speaker, permit me to start with the substance of the amendments to the Supreme Court of Judicature Act. They will obviously apply to what I will say in the in the Summary Courts Act. So let's get to the mischief that we're looking to solve. Madam Speaker, you'll note at Clause 3 and also at Clause 4 in the Summary Courts Act, we are proposing the introduction in the definition section of a drug treatment court process. This process is where a judge, a master, or a district court judge, Madam Speaker, you're well aware that we have now merged the jurisdiction of several aspects of the Family and Children Division, such that judges may sit in magisterial districts, and therefore it is not uncommon, even though it is in the Supreme Court of Judicature, to now see reference to a district court judge, as magistrates are now called. Masters, of course, are made reference there too, because in the family and children's proceedings, the case management of matters, whilst they exclusively resided in the magistrate's court before, can now be heard by a judge or a master sitting in the High Court division. But this introduction of drug treatment court process, Madam Speaker, specifically contemplates rules to be made by the Rules Committee established under Section 76 and those rules made under Section 77 of the Supreme Court of Judicature Act. And listen to what it does. To cause someone to be under an intensive treatment and counseling program and other services that require the person to be monitored by a judge, master, or district court judge, and to abandon successfully the use of the drug or alcohol, and to be held accountable by the judge, master, or district court judge for meeting his obligations to the court, society, himself, and his family. And we specifically then take a very broad definition of the word substance. Substance is meant to be any dangerous drug as defined in the Dangerous Drugs Act and includes alcohol, Madam Speaker. That amendment, Madam Speaker, flows immediately into Clause 3C, where we propose the introduction of a new Section 65R. And this is where the three categories of judicial officers, judge, master, or district court judge, may refer a person to a drug treatment court process where it is satisfied that the person has a history of alcohol abuse or substance abuse. And this is the category of people we seek to now catch, where the person who is referred is a person before the court in any criminal or traffic matter other than a violent offense. Secondly, the person is a party to a family matter. Madam Speaker, I would remind you that a family matter is defined under the Family and Children Division, and therefore family matter as opposed to child matter is a separate matter standing alone. Or a parent, guardian, or person with responsibility for a child who has come to the attention of the Children's Authority as a child at risk. Madam Speaker, we then go on with the agreement of the person, a member of the household of a child who is convicted of an offense, a child who would be liable, etc., to the payment of a fine, damages, or costs, if the child is a child at risk and the substance used by the member of the household is negatively affecting the child. Madam Speaker, this is squarely rooted in the work which we as a government implemented in the Family and Children Amendments that we caused in Act number 6 of 2016. I want to remind that in birthing that law, sent it to on the 5th of July 2016, in Section 47 of that groundbreaking piece of law, we introduced the Children Drug Treatment Court process. Now, Madam Speaker, this government and the judiciary have together made history in the CARICOM by introducing the Drug Treatment Court process. We implemented as a government the salvation by way of anonymity for children who are referred to the courts. We established with the United Nations the anonymization of records for children. We, as a country, established a robust drug treatment court process. And, Madam Speaker, we put that right alongside the pair resolution process, as you will recall. Madam Speaker, so groundbreaking was this work that the rest of the Caribbean is now applying the same methodology. Barbados, Turks and Caicos, Bermuda, Bahamas are now all in active consultation with Trinidad and Tobago to apply the innovations of process that we have applied. That, of course, came on the back of a diagnostic study of the Trinidad and Tobago Drug Treatment Court, and the Honorable Chief Justice, Mr. Justice Ivor Archie, is definitely the forerunner in this field in having taken the judiciary into such a novel process, Madam Speaker. Madam Speaker, what this amendment allows us to do, both in respect of the Supreme Court of Judicature and the Summary Courts Act, is that it allows us, Madam Speaker, to focus upon children at risk. Madam Speaker, we allow court treatment processes in the plural, not in the singular, so that we can have the family, the entire family, people with responsibility for the child, a person who comes to the attention of the children's authority, that we can have all of these people into family counseling and drug treatment counseling. And, Madam Speaker, we allow it in the broadest concept of application, including if you are on community service, if you are before the court, if you are not even before the court and you consent, Madam Speaker, when we focus upon this new terminology of a CHIN, a child in need of care, Madam Speaker. It runs right alongside with the harmonization of our laws when we introduce the decriminalization of marijuana. It runs right alongside the Children's Act when we see that the exposure to alcohol or dangerous drugs has to be treated by way of avoiding the court and jail and incarceration and taking into an alternative form of salvation where children in need of care are provided with alternative mechanisms. Drug treatment process, child drug treatment process, pair resolution, Madam Speaker. We lift the immense successes in the Children and the Family and Children Division into the Supreme Court of Judicature Act and into the Summary Courts Act. Madam Speaker, similarly in the bill, we seek in the Supreme Court of Judicature Act and in the Summary Courts Act to treat with the process of the Chief Justice issuing directions. Directions to ensure criminal and civil trials are conducted by audio and video link. Evidence is taken by audio and video link from a remote point. Why is that necessary in both the Summary Court and in the Supreme Court, Madam Speaker? Quite simply for two reasons. Even though we have a system of video conferencing and also of virtual appearances anchored in the Family and Children Division and also in the Criminal Division, done in 2016 and in 2018 respectively, there has come to the attention of the jurisdiction, to the court in particular, the very recent decision arising in the Privy Council, which considered the matter of similar issues coming in the Turks and Caicos, where there was a challenge to the concept of remote sitting and taking video evidence and audio evidence, and even in that jurisdiction of a judge in Jamaica sitting in the court in Turks and Caicos. Madam Speaker, the Privy Council put squarely before the world its decision, which set out that there is nothing untoward or in terms of taking away of any rights or privileges or even equality of arms to have remote trials, to have video conferencing, to have audio conferencing, and that, Madam Speaker, being a decision in November 2020 of the Privy Council, it was important for us to take not only judicial notice but parliamentary notice of the case of the Attorney General of Turks and Caicos Islands respondent versus MISIC and others as appellants, and that came before the Privy Council in appeal number 0072 of 2020 in the Michaelmas term, judgment delivered on 13th November 2020 before Lady Black, Lord Lloyd Jones, Lord Briggs, Lord Hamblin, and Lord Stevens. And therefore, Madam Speaker, it is imperative for us, taking note of that, taking note of considerations at the local bar, expressions as to whether jury trials can continue on a virtual platform, considering all of the circumstances now better clarified by the Privy Council, it's important for us in the Supreme Court of Judicature Act to put these provisions in, and also in the Summary Courts Act as they appear before you, Madam Speaker. Madam Speaker, may I ask what time is full time?
11:14:48.
Much obliged. So, Madam Speaker, I'd like to say that whilst you see in Clause 3 the reference to the definition of drug treatment court, and then you will also see in paragraph C the referral to the drug treatment process itself. It is those two items that we will add into, at committee stage, into the Summary Courts Act in the move to reformat this bill. Regrettably, those things fell off, Madam Speaker, between Friday and the day on which it was laid, but they cause no injury because the very concept of it has to be in harmony between the Supreme Court and in the Summary Court as well, Madam Speaker. So, Madam Speaker, we would propose to put in similar provisions as appears in Clause 3 into Clause 4. Madam Speaker, in Clause 3, you will see in the amendments that we propose in paragraph D that we're allowing for the making of the provision for charging of administrative fees by the Supreme Court. And you'll note, Madam Speaker, that rules are being invoked pursuant to Section 76 and Section 77 of the Supreme Court of Judicature Act, that the Chief Justice can determine costs associated with the filing of documents, service of documents, use of alternative methods. I'd like to point out and specify here the use of mediation, Madam Speaker, the use of technology, conveniences, transactions, interpretation, and other services. Why is this necessary, Madam Speaker? As we have moved to the electronic platform, as we have moved to the electronic payments of monies into and out of court done by way of legislation in 2018 as well, Madam Speaker, it is necessary to constantly keep an eye on the law so that whilst the COVID pandemic has allowed a precipitation and catalyzation of precipitate in this pandemic of using now very frequently video conferences and remote hearings, and now almost exclusively electronic filings, we have to move away from the concept of cash in a drawer at the register. And therefore, it fits in with the government's digitization program and the move to an e-wallet society to allow for the payment of services on electronic platform for a multitude of services, importantly including mediation services, again with the focus on alternative dispute resolution, Madam Speaker. Madam Speaker, I turn to Clause 5 of the Coroner's Act. I'd say that this amendment is very closely related to a bill which we laid today, and without anticipating that bill, the Coroner's Act is necessary for amendment, and the administration of justice itself is importantly improved by removing one of the hurdles that the Police Complaints Authority frequently faced in coroner's inquests. Now, Madam Speaker, you know that under the Coroner's Act, a magistrate sits as a coroner where there's an unnatural death. Unnatural deaths very often include police shootings. When that goes before the coroner, far too frequently and unfortunately, the Police Complaints Authority find out in arrears or don't know that the matter was proceeding. And the amendments that we cause here now are firstly to allow the locus or right of audience for the Police Complaints Authority as an interested party before the coroner, as opposed to having the Police Complaints Authority make itself a party by way of application. And secondly, and importantly, that notice of the proceedings before the coroner will be served upon the Police Complaints Authority in circumstances where it is the subject of an investigation monitored, audited, or carried out by the Police Complaints Authority, and that is specifically obviously rooted into unnatural deaths before a coroner concerning police shootings. Madam Speaker, the last amendment is to Clause 6 of the bill, proposing the amendment to the Sexual Offences Act. Madam Speaker, I'd ask you to take note that the Sexual Offences Act and the very concept of a sex offenders registry stood on the books of Trinidad and Tobago for nearly 20 years without a single person going on to the register. Why? The law as cast in 1999 was quite simply ridiculous. It required somebody to report to a police station at the same time that the judge was putting them into the jail. And that just simply was a nonsense. There was no process flow as to how somebody came on to the register. And Madam Speaker, it resulted in this country having a law passed in 1999 without a single person 20 years later on the register. What we have found out in our survey to cause the proclamation and operationalization of this law is that there has been a significant roadblock, and that can be cured by an amendment to Section 49 of the Sexual Offences Act, where instead of a mandatory mental assessment report from a psychiatrist, where the court, before making a determination to put you on the sex offenders registry, shall have that report, we now leave it quite properly within the realm of judicial discretion. We simply change the word shall to may. That, in fact, underwrites and reinforces the constitutionality of the law. To say that the court shall have something and be constrained is to offend the separation of powers principle. May leaves it within the court's discretion, bearing in mind all of the subcategories of gravity, circumstance, protection, and rights of justice and interest of justice always prevailing. Madam Speaker, that therefore took us to the amendments to 49(1), 3, subparagraph A. And that, Madam Speaker, can finally allow for the population of the sex offenders registry. Why is that important? Madam Speaker, without reviving the last debate, I did hear my colleagues say that sexual offenses against children are on the rise. Madam Speaker, I dare say the detection of sexual offenses against children are now better recorded. It has always been a feature of this country, regrettably, that our children have been exposed to vulnerabilities. But thankfully, Madam Speaker, because of the hard work of the very many people involved in the protection of children in our country, we are now getting people come before us to report offenses against children, Madam Speaker. Because if we can't protect the most vulnerable in our society, we're in trouble. And Madam Speaker, one of the tools carefully exercised and balanced in protecting our children must reside in the population of a sex offenders registry. That registry is operationalized by the fact that there has been the implementation of the Child Protection Unit, the Gender Affairs Unit, the Solicitor General's Department of Child Advocates under the Attorney General. My colleague, the member for Tobago East, pioneering and supervising the work in respect of children at the ministry that she manages. And therefore, Madam Speaker, this operationalization of the Sexual Offences Act, where we treat with the Sex Offenders Registry, is critical for us all. Madam Speaker, I look forward to the contribution of my learned colleagues in the body of this debate. I think that there can be very little objection to a law such as this, and in those circumstances, I beg to move.
Honourable members, I shall now propose the question for debate. The question is that the Miscellaneous Provisions Administration of Justice Bill 2020 be now read a second time. I recognize the member for Shigonas West.
Thank you, Mr. Deputy Speaker. And I appreciate the opportunity to contribute to this debate. Mr. Deputy Speaker, as I start, I want to say that we accept that drug treatment, or I should say drug treatment courts, enable the criminal justice system to move more effectively and to tackle the problem of addiction and the issues that we see in society which are presented by substance abusers. As I start, I want to say that we need to look at this bill, and what it seeks to do is you are having amendments to the Judicature Act, the Supreme Court of Judicature Act. So we have to look at the debate through the lens of the definition section in the Judicature Act where you are seeking to make certain amendments. Now, there's I wouldn't say it is a saying, but some people consider it a rule, that if you have to explain the meaning of a word, you don't use the word in the explanation that you seek to give. And I say that respectfully, just simply to say that we have to look at what is being presented in the definition section by virtue of these amendments. Now, let me start off by saying that assuming that facilities, and this is really, I know the learned Attorney General, Honorable Attorney General will probably give us more information on this. But facilities have been and will be earmarked, that will persons at these designated facilities be trained in physical combat and restraint? And this is a serious issue that has arisen in the past, and I dare say this question that I'm asking is not out of place. There have been incidents of court-ordered referrals to St. Anne's, where persons referred have engaged in serious combat with the nurses. And in a Guardian article entitled "Violent Patient Threatens Nurses Boycott at St. Anne's," this is February 27, 2019, it was stated that the Trinidad and Tobago Nurses Association had two recommendations. And one of it was, and I quote, "It wants only one High Court referred patient at the forensic division at a time, and for there to be a permanent police presence at the facility." The article describes the manner, Mr. Deputy Speaker, it describes the manner in which patients, prisoners are dropped off, and this is what it says. So the police would bring them shackled, handcuffs. Each police officer is heavily armed, and as they reach on the ward, the police take off the patient's handcuffs, and then they are free to roam within the ward. And as I say, to Learned Attorney General, Honorable Member for San Fernando West, that this is not a criticism on what has been piloted, but it is something that we definitely need to look at as we seek to put in these, we are amending the Judicature Act to introduce these powers, but also we want to know that in reality that it can work in a safe manner and in a proper system. The question as well that arises is their period of monitoring. And this now goes back, Mr. Deputy Speaker, if we look at the definition that is being sought, this is at Clause 3, a drug treatment court process. And it reads there, means a process where a person is referred by a judge, etc., to an intensive treatment and counseling program and other services that require the person to be monitored by the judge and to abandon successfully the use of drug or alcohol. Now, when we look at, for example, the Mental Health Act, this is often applicable to substance abusers who suffer impairment of the mind, where a judge can order the director of psychiatric hospital to admit a person in those circumstances. Such a person cannot be kept for more than 14 days. And I raise this to say that after which the court can rescind the order or reissue a further order to the hospital director until such time that the director informs the court that further treatment is not necessary. Why do I raise this? Is because this process that we are talking about, question is it an open-ended process? And I know there will be the supporting legislation, but I have to raise it in as much as we are talking about a definition section. One aim of the proposed process is for the person to abandon successfully the use of the drug or alcohol and to be held accountable by the judge, etc., for meeting his obligations to the court, the society, himself and his family. I want to say that we need to be careful in the definition section when we use that language, abandon. And when we're talking about asking persons to abandon the use of drug or alcohol, there's a world of difference between use and abuse. And by simply asking persons to give up using their 30 grams of marijuana to which they are legally entitled, this is something that will interfere with their habit, it will interfere with their lives, and it also has implications so that it must be distinguished from asking persons to abandon their abuse. So there is use as opposed to abuse, and this is something that I want to point out when we are looking at the definition section. Now, Mr. Deputy Speaker, before I get further into the proposed bill, some of the things that struck me is that you have some practical issues that arise, and I trust that the Honorable Attorney General will probably speak to some of these in winding up. Now, or other members supporting the bill. If it is you have, in a situation like this, where you look at substance, and now you're seeking to say substance means any dangerous drug as defined in the Dangerous Drugs Act and includes alcohol. One of the practical questions that arise is what would be the scenario in your criminal records. So for someone who actually is convicted of one of these DUI, you have a particular reflection on the criminal record. But when you say now substance means any dangerous drug as defined in the Dangerous Drugs Act, and it includes alcohol, the practical effect that we are looking at is that when you have a criminal record, what is reflected there? If it is simply reflected as substance abuse, there is a difference for people if it is they are convicted for DUI or some related charge, as opposed to substance abuse. You may have cocaine or you may have other drugs, and that makes a difference. Where it makes a difference is that in as much as the drug treatment process is meant to help with rehabilitation with persons, the criminal record that reflects what they have been charged with also assists people with reintegrating in society in a manner that is, more accommodating. If the record reflects something just simply as substance abuse, but there's no determination or no definitive position on whether it is, cocaine usage as opposed to alcohol, then you have employers who may want to take a certain position that, look, this person is somehow guilty of that kind of charge, and they may think twice. I'm just saying that is a practical reality that we have to consider. Now, the drug treatment court process, one must always be able to know at any given time whether it is something that the process is in conjunction with a good behavior bond, or is it purely penal? And that is something that I did not pick up, Honorable Attorney General, in terms of when you're seeking to put in these amendments to the Judicature Act, and it's going on to deal with other provisions, amending or giving way to other pieces of legislation. The other thing is that, Mr. Deputy Speaker, when we are talking about referral to the drug treatment court, the question arises, what if a person is charged for trafficking, but is not someone who is a user themselves? It is something that I don't know how they will fit into this definition. What if the offense charge has no element of possession or use, but in the course of giving their defense, so to speak, their defense is that they don't necessarily use, but the excuse for probably stealing or larceny is one that, look, they wanted it so that they could buy, some drug or the other. Does all of these persons fall into the category that you want to now move forward to have them the benefit of the drug treatment court process? And when we look at some of the other definitions, when you're talking about history, the question is that some of these things have to be detailed clearly in the other pieces of legislation. So I just raised that as practical issues that arise, and I know that we would probably hear from the Attorney General on some of these things. Now, Mr. Deputy Speaker, moving on to a more familiar area to myself, if I may say that when we look at Clause 3B, Now, this is something that has been, I have to say that you have different positions being taken by practitioners, certainly legal practitioners in the profession. And what basically the section says that the Chief Justice, Honorable Chief Justice may, when the circumstances warrant, issue directions as deemed necessary to ensure that criminal and civil trials may be conducted by audio and video link. Now, in a post-COVID world, it is necessary to have an indication of what specific circumstances will warrant the necessity for remote trials. I know on the other side they will say, well, this is up to the discretion of the Rules Committee and how it is to be implemented, but I think it is our duty to put it on the record that for future purposes that we ought to look at it in this manner, that, in the post-COVID world, what exactly is going to take, will be materialized, because during COVID, we saw the need for having the video link and for having the virtual hearings. But even during the COVID pandemic, the question did arise in court proceedings, certain court matters, which were published in the public domain, and you had even senior counsel taking the position that you were eroding people's rights by having the trials done only through virtual hearing. Now, sources of evidence, we know, can include the observation of the demeanor of witnesses, and this ties into some of the objections that were raised during the pandemic, the early pandemic. And bearing in mind that during the pandemic, we had certain rules that were passed to allow the video link and the virtual hearing. So I'm saying that even in that situation, you had senior practitioners raising these concerns. And if you break it down, basically, when you have the observation of the demeanor of witnesses, the examination of physical exhibits, objects such as weapons and even spent shells, all of these things, the question arises, do you have the equivalent that you're accustomed to in a normal trial? There is the value to meeting or confronting your accuser in court. I could say that, in Trinidad and Tobago, we tend to say we have our day in court, or you hear some people saying, we have court closed. But what do they really mean by these things? And, in England, Lord Denning himself said that the essence of cross-examination is to have the continuous exchange of questions and answers. Jones and the Cole Board. That is the English, common law position. In the United States, there's a Sixth Amendment constitutional right that there's a right to confront and cross-examine a witness in a criminal action. And this includes the right to be present at the trial. And this is even guaranteed by federal rules of criminal procedure. So I'm saying all of these things, that there's a certain need for deportment, appearances, conduct, eye contact. We even, in law, when you're dealing with evidence of innocence and guilt, you assess and observe body language of the witnesses. You ask questions such as, was he showing any remorse or simply smirking? All of these things the courts take into account. I'm simply saying that if we are going in this direction, we have to bear in mind that there is a common law right. If you do not want to elevate it as high as a constitutional right, it is certainly a common law right to have your day in trial, in person, in court. So this is a broad sweeping power, and I would say that it does not take into account the views of the parties necessarily, who may very well wish to have their day in court. Perhaps it would be more prudent to suggest, I'm suggesting that there should be a reserve power certainly in a post-COVID environment, that to retain as a default position that if you reach the stage of a trial and you want to have virtual hearing of the trial, have persons consent, at least give the option that persons can consent. If they consent, then there is no erosion or trampling of their rights. And it is their option, it is available. If they take it up, it means they move along. And if they don't, it means that the matter will, hold on until such time as it can move on. But it is an option that I think it should be afforded to the parties to choose, because it sometimes leads to, a life-defining event, the trial itself. Now, moving along, Mr. Deputy Speaker, now let's just look at the bill itself. And I know time is limited, but I wanted to point out that when we look at Clause 3C, And I know that amendments have been passed around, but I would want to point out kindly to the Honorable Attorney General that this clause 65R1, A, B, C, and D, sorry, A, B, and C reads, in my view, it reads okay, it reads properly. But from D, there seems to be some problems with the reading. But yes, and I'm getting to the amendment. The amendment is helpful, but the drafting is something that I think it makes it very difficult to follow. When you look at with the agreement of the person, the history of the person that is referred to in the body at 65R1, and then when you look at what happens from D1, 2, and 3, it creates a little bit of awkward reading. I want to point that out, but particularly at D, Roman numeral 3, what you have is, even with the amendment, we have to be careful with this, and I am sure it will be cleared up in the committee stage. You have here, if the child is a child at risk, and then when you look at the amendment, insert before the words, if the child. So I just pointed out, I'm not splitting hairs, but I think we need to just look at that when we get a little bit further. But my humble opinion is that D1, 2, and 3 provide some very difficult reading. Now, what I want to say is that certainly the intention here is that children who grew up in chaotic homes where alcohol or other drugs are abused and who experience abuse and neglect by their parents or others, they are more likely to have problems as adults. And so whilst this is welcomed, I'm just saying that we have to be very careful that the interpretation of the sections, you know, it doesn't lend itself to anomalies. So now is the time to cure if there's any drafting issues. Now, moving on from that, please, Mr. Deputy Speaker, alcohol abuse is an issue looming large, and I dare say sometimes larger than life itself. It is imperative that persons are not labeled as an alcohol abuser or even as an alcoholic without due testing by qualified persons in the field. And I did some research, and in the reputable medical site WebMD indicates that problems with alcohol use are now officially called alcohol use disorder. You'll still hear a lot of people talking about alcoholism or alcohol abuse. It is a condition that ranges from mild to moderate to severe, and it's all still problem drinking, even if you think it's mild. But herein lies the problem. At what point does alcohol use become alcohol abuse? And I'm looking at the wording that we are using here. Matters are complicated by something called high functioning alcoholic, where you can possibly have a functioning alcoholic who might not act the way you would expect him to act. He might be responsible and productive. He could even be a high achiever or in a position of power. In fact, his success might lead people to overlook his drinking. So this is something that we have to bear in mind when we are drafting legislation with clarity and in keeping with, I use that only as reference to say that we keep our drafting. Sometimes we look at doing it in keeping with international definitions. I know at one point in time there was a committee or a body set up to make sure that all of our offenses and even the elements in some cases of our offenses matched international, I should say, acronyms at the very least. So this is something that we can start looking at from now. I wouldn't say that necessarily the section of the legislation is reactionary, but what I would say is that we need to look at some of the statistics and the research in this area when we talk about alcohol use and alcohol abuse. In a 2018 article published in the BMC Public Health Journal entitled National Alcohol Survey of Households in Trinidad and Tobago, Willingness to Support Changes in Policy, Laws and Regulations. This is found, it can be found if you Google it on the website. There was obvious support for fixing alcoholism in a holistic fashion. And I would urge the government to take note that in tackling an agenda to curb abuse before a person so inclined reaches the court and is subject to this process, we need to look at the holistic approach, how else we can target that person. A part of the article addresses what households in Trinidad and Tobago believe to be issues of importance when you talk about alcohol consumption. And these were the results. 1,695 households responded from a total of 1,837 homes. This approached the response rate of 92%. In a national campaign, the following proportions of households would support, and I say what they are supporting, please, Mr. Deputy Speaker: setting the legal age for drinking at 21 years, that is 82.4% of the survey, saying that; restricting or banning alcohol advertising on TV and other media, 73.1% and 54.4% respectively said that; banning all alcohol advertising at sports and cultural events, 64.8%; banning radio stations playing songs with reference to alcohol use, 71.3%; holding sellers of alcohol responsible for the amount of alcohol sold, 79.5%; advocating that proof of age to be shown by persons buying alcohol. You had 87.4% of the households saying that this is a measure. I'm saying this in the context that all of this is, in as much as you're talking about a drug treatment process, you have to identify ways of treating with persons so that they don't even have to make it to court to have to access this. Placing more prominent warning labels on products, placing more prominent warning labels showing harmful effects, increasing taxes, etc., supporting restrictions in density of outlets. All of these were part of the survey. So I would like to say that in closing, Mr. Deputy Speaker, that we must be careful that the drafting does not reflect any lack of clarity. We also have to look at a forward-thinking approach. So whilst I said that it is welcome and we understand that you can have this type of legislation, you want a drug treatment court process to be able to even help with the judicial system and to help with dealing with these sort of offenses and matters. We need to be forward-thinking. We do not wish to have any inability on our part, even as we legislate. We must have exactly what it is we want the court process to do, and this is why I took the position. This is why I took the position, of ensuring that we look at it through the lens of the definition. This is the definition section we're talking about. From this, it will lend itself to interpretation in all pieces of legislation. We need to properly clarify the parameters of, as I said before, the use versus abuse, and this distinction is necessary to determine if alcohol versus drugs should be the subject of some of these provisions. So, Mr. Deputy Speaker, in conclusion, I urge the Attorney General to just review that 65 Clause 3C, which is the Section 65R. Sorry, I'm just concluding, Mr. Deputy Speaker.
Members, please.
Yes. So that I think the Honorable Attorney General has given me a signal. But I hope that even in looking at the 65R1D Roman numeral 3, I would like that we can look specifically at 65R1D Roman numeral 1, Roman numeral 2, and Roman numeral 3. I think it will provide a lot of clarity in the circumstances. Mr. Deputy Speaker, I know that my colleagues will follow on in terms of our position on this, but I thought in responding to this piece of legislation that we point out some of these areas. And as I said, I hope that is taken on board, that in future, even when some of these things, matters are left for the Rules Committee, that they will take our contributions on board. Thank you, Mr. Deputy Speaker.
Mr. Deputy Speaker.
1 second.
Thank you, Mr. Deputy Speaker. Mr. Deputy Speaker, I wish to thank the Honourable Member for Chaguanas West on an excellent presentation, which has certainly taken us to a very fulsome place. I wish to say that I agree with the large majority of submissions made by my learned colleague. They certainly have taken us to a better place, a lot of which we can deal with at the committee stage. I think the Honourable Member is correct in his observation that there is some tweaking necessary to the bill and the amendments that we're proposing in circulation. And quite simply, we can take those at committee stage, and I beg to move.
Honourable members, the question is that the Miscellaneous Provisions Administration of Justice Bill 2020 be now read a second time. All in favour say aye. Aye. Any against? The ayes have it.
A bill entitled An Act to Amend the Supreme Court Adjudicator Act, Chapter 401, the Summary Courts Act, Chapter 420, the Coroners Act, Chapter 604, the Sexual Offences Act, Chapter 1128, to provide for procedural matters of the courts and for matters related thereto.
Attorney General.
Mr. Speaker, in accordance with Standing Order 68.1, I beg to move that the Miscellaneous Provisions Administration of Justice Bill 2020 be committed to the Committee of the Whole.
Honourable members, the question is that the Miscellaneous Provision Administration of Justice Bill 2020 be committed to the Committee of the Whole. All in favour say aye. Aye. Any against? The ayes have it. This House will now go into the Committee of the Whole to consider the bill clause by clause. Honourable Aji, are you ready?
Yes. Apologies, I am. Thank you for the momentary indulgence.
The question is that Clause 1 stand part of the bill. The question is that Clause 1 now stand part of the bill. Those in favour say aye. Aye. Those against say no. I think the ayes have it. Clause 1 now stands part of the bill.
Clause 2 next week.
Clause 2?
Mr. Chair. Yes, sir. The amendment is the amendment as proposed in the circulation. It really is simply stylistic. Some could call it piddling, but we're just keeping it in conformity with other laws. It is to just simply reword the way we stated it should come into effect by proclamation.
The question is that clause 2, be amended as follows. As circulated. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clause 2, as circulated, now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it.
Clause 3.
Clause 3. The question is that clause 3 be amended as circulated. Those in favor say aye.
Mr. Chair, forgive me. The clause 3, consonant with some observations made by my friend for Shogunas West. My friend was absolutely correct in his observations that there was some surgery required to the language. And therefore, Mr. Chair, would you permit me to amend what is circulated in clause 3C as follows? It would just simply be A and B stay as they are. C is where I propose that we do some adjustment. And we would say, insert before the words stay, if the child stays, the words okay. Yeah. Okay, so forgive me, Mr. Chair, because you go for Sorry, Mr. Chair. So if you follow me, and honourable colleagues, I apologize for this. So in what is 3C, in paragraph C in the second column, we would go insert before the words, if the child, the words, you see, Mr. Chair, you see Roman 3 in brackets. Right after the Roman 3, just insert the words, a child, comma. So we're just adding into that sentence in the table at the very end of 3C on the column, before the inverted commas, after Roman 3, the words a child, comma. So it reads, insert before the words, open inverted commas, if the child, close inverted commas, the words, open inverted commas, Roman 3 in brackets, a child, comma, close quotations.
Honourable Attorney General, I know we are looking at the proposed amendment circulated and 3C. It seems to me that it would read, when you say insert a child before the words if the child,
I can assist this way. If honourable members would turn over to the second page of circulated amendments and look to what is described as 56A. 56A would be exactly what we're doing here, but you'll be able to see it in context. So if we go 56A1, a judge may refer a person to a drug treatment court process where it is satisfied that the person has a history of alcohol abuse and is, D, with the agreement of the person, a member of the household of, Roman 3, a child, if the child is a child at risk and the substance use of the member of the household is negatively affecting the child. So if you insert just the words a child at Roman 3 there, you will get exactly what we're seeing in these amendments. So if Shogunas West will just take a look at that second page, at the Roman 3, just slip in the words a child before if a child. So with the agreement of the person a member of the household of a child, comma, if the child is a child at risk and the substance use of the member of the household is negatively affecting the child. It's a different category of person. We have a child who is convicted in Roman 1, a child who would be liable in Roman 2. In Roman 3, here's where the person agrees. There's a member of the household of a child, and the child is at risk, and the substance use of the member of the household is negatively affecting the child.
Honorable AG, you would recall I said 56. You would recall that I said in terms of the bill,
yeah,
and I'm referring to the bill now, 65RD, Roman numeral 1, Roman numeral 2, and Roman numeral 3. I find great difficulty in reading that whole provision.
Right.
I am okay with what you have said in terms of the amendment that you have proposed, that it can read as in the second page,
yes,
Roman numeral 3, but I really do have, I'm putting that on the record, difficulty in reading that whole clause D.
Understood. Because, and I don't mean this pejoratively at all, but because amendments aren't circulated with draft marked up copies of how they look, I can give you the assurance that what 65R will read like is exactly as I've just described with respect to 56E.
Yes.
So 56A1 is the same as 65R1. A is A, B is B, C is C, D is D. D Roman 1 is the same, D Roman 2 is the same, and we're amending D Roman 2 where the shoes or the choiseures, which is the bottom part of the thing on the bottom of the page, we need to add in a Roman 3, a child if the child is a child. So it reads exactly as 56A1.
Yes, Mr. Chair.
Yes, sir.
Yes. I recognize the member for Baratoria San Juan.
So I have a comment on clause 3B. I don't know if you want to entertain it now, or do you want us to settle the amendment for 3C first, and then we could always move on.
Settled on 3C in that particular one, so we can go to 3B now.
Yes, sir, as you please.
Yeah,
Yes.
proceed.
Thank you. Now, I'm seeing at 14A sub A now that civil trials are also included in terms of the directions that the Chief Justice will be empowered to make with regards to trials through audiovisual means. Under the civil procedure rules, there's also a rule 29.3, that deals with taking evidence via video. Why are you including civil trials in this amendment when we already have rules to cover AV trials through civil means?
Absolutely, Mr. Chair. My colleague is referring to the very debate in the profession. Whether it ought to be in subsidiary legislation, i.e. rules issued pursuant to Section 77 of the Supreme Court of Judicature Act, or whether one ought to have it in a parent law, in this case the Supreme Court of Judicature Act and then the Summary Courts Act. Following upon the Privy Council's decision in the Attorney General of Turks and Caicos in November of this year, we thought it prudent to put the legislative springboard in the parent acts, i.e. Supreme Court of Judicature and Summary Courts Act, out of an abundance of caution, bearing in mind that there's the potential for litigation on the issue. In Trinidad, we have a well-established practice, as we all know, of the civil proceedings rules speaking to virtual hearings. We've had the virtual courts for quite a long time right now in Port of Spain, San Fernando, and Tobago. It's tried and tested here, but we are such a litigious society. We didn't want somebody taking a shot and then have to go all the way to the Privy Council to settle something.
You see, AJ, I'm having two issues being raised here. The first being parliamentary oversight, because under the rules, the CPR, those rules will now be subject to negative resolution. Now, under your present amendment, the Chief Justice will issue a practice direction which will effectively guide the procedure. I know you referred to the Mystic case also, the Turks and Caicos case, but that case decided one substantive point, which was whether or not the judge who was sitting in Jamaica, whether the regulations would have captured him in terms of him sitting in the Turks and Caicos virtually while he's physically present in Jamaica. The case did not deal specifically with the fairness of the trial because the trial was at a very premature stage. So the Privy Council was very cautious in terms of making any pronouncements with regards to the fairness of an audiovisual trial, criminal that is. In this case now, what I'm saying is that we should have some level of Parliament oversight because you will have two sets of rules running now. You will have the practice direction dealing with the trials in terms of taking evidence through electronic means, and then you will have the actual rules that will be subject to the Rules Committee under the CPR. So we are running two parallel streams. Why don't we just put everything under the Rules Committee for civil trials?
Mr. Chair, I read the judgment at least 7 times. The judgment actually said a whole lot about virtual hearings. It didn't say a little. It also said quite a bit obiter. There can be no clearer purpose in law than Section 53 of the Constitution saying that Parliament made laws for the peace, order, and good governance of its country and took the step to legislatively amend the parent acts. So when you put it in the primary law, Parliament has made the decision to say that virtual hearings in this jurisdiction should stand. Now, that could be easily proved in a court of law when one had to defend whether there's an equality of treatment and whether you could lead evidence virtually, etc. But we want to avoid the risk of somebody taking those points as happened in Turks and Caicos. We want to specifically put it into the parent law, and in those circumstances, there is in fact oversight. In fact, it is ex-Senator Wayne Sturge himself, a member of the UNC, who went to court and challenged the practice directions of the Honorable Chief Justice with respect to the criminal proceedings rules and practice directions. So there is oversight. What better oversight than the court having to decide that these things were legitimate and fulsome? So the judiciary certainly is of the view that we want to have this in the parent law. As Attorney General, I certainly hold the view that we ought to take conscious reflection of the Privy Council's decision, and I would prefer for the removal of argument that we go to the parent law amendment as opposed to relying upon a tackle on subsidiary legislation when neither the Supreme Court of Judicature Act speaks to it openly or does the Summary Courts Act.
You see, AG...
1 second. Go ahead, Bartaya Sanwan.
Yeah.
Port of Spain, sir. Port of Spain North.
Sindan, just 1 second. Go ahead.
Yeah, AG, I understand the point with putting it in the parent law. The issue I'm having is the reason why that case, the mistake case, went all the way to the Privy Council was because of the badly drafted directions that were made, the regulations that were made under the law. And there was a whole discussion regarding the clarity of the law. Even in the decision, the court found that they were looking at if it was better drafted, you could have avoided the entire litigation. So what I'm saying is that why don't we have the civil trials remain under the jurisdiction of the Rules Committee and have we leave the criminal part of it under the practice direction for the meanwhile?
Mr. Chair, my friend would be well familiar with what I consider to be the runaway horse of judicial review. In Trinidad and Tobago, and I'd say this, and I don't mean this pejoratively, I mean this factually, there are no more fulsome practitioners of judicial review on any and everything than people who very often find themselves in the fold of my friends opposite. And therefore, we have been warned by the Privy Council and the judiciary. The DPP has made concerns about the criminal side, but it applies equally to the civil side, because on the civil side, we have massive amount of litigation. Why would we want to put ourselves in the invidious circumstance of somebody saying, well, Parliament saw it fit to amend the criminal law in the parent law, but not the civil law. Therefore, Parliament intended that the civil law could be open to tackle. We need to harmonize the approach. The issue of evidence is common in both criminal and civil. It's why, for instance, computer admissibility under Section 14B of the Evidence Act is in pari materia in topic to Section 40 of the Evidence Act, because there's admissibility of evidence in both criminal and civil matters. So the policy decision of the government is parent law, harmonization, avoid risk.
Okay. Member for Port of Spain North, St. Anne's West.
Thank you very much, Mr. Chair. Mr. Chair, this discourse, whilst somewhat interesting, I guess, to some at this hour, is completely unnecessary, because anybody worth their weight in law would understand that the parent legislation is two pieces of parent legislation in the Supreme Court of Judicature Act, and we're saying civil and criminal trials be conducted, and this is actually giving life to what is already in existence. So it's backfilling, to use one of the AG's terms, to suggest that we leave it up to the Rules Committee and to accept that both the rules as well as practice directions have already been issued. Just to put on the record, what we're saying is the Chief Justice may, when the circumstances warrant, issue directions. That answers it there. So what you're doing now is you're going to parent legislation to give the power to say Parliament oversight. I can't understand what further oversight there may be. We as parliamentarians have no oversight over the Rules Committee, over the directions issued by the Chief Justice. What we're doing here is giving him the express power to do what has already been done, is to avoid any defeat of what has already been done via litigation.
Right. Honourable Member for Bata Sanwan, again, last point, and we just get a response from the AG. Proceed.
Also, I'm also looking at Section 14E of the Evidence Act. That provides for the Rules Committee to make rules for criminal trials also.
14B, criminal side.
Correct. So
and then you have Section 40, which is on the civil side.
So why don't we use the Rule Committee to make the rules for these trials, so that you subject the rules to the negative resolution of the Parliament?
Sorry to interrupt my colleague.
And also, before the AG could respond
to
the both, right? So the first one is whether or not we make criminal rules via the Rule Committee under the Evidence Act, have it laid in Parliament through negative resolution. That's the first point. And the second point is, I'm looking at the timing of this legislation. I'm just asking the AG to confirm whether or not there's an active case before the courts currently that is about to decide this exact same point that we're going to pass legislation for. Why don't we let the court make a decision before we pass
Lord, sorry. Mr. Chair, with the greatest of respect, I've been pellucidly clear. The Privy Council has just decided in the Turks and Caicos case, Attorney General of Turks and Caicos, Mr. Deputy Speaker. It is the Attorney General of Turks and Caicos versus Misik and others on the 13th of November 2020. We're not even a month away from that date. They have made very important observations in that judgment. All of the judges, Lady Black, Lord Lloyd Jones, Lord Briggs, Lord Hamblin, and Lord Stevens. Why must we wait for a first instance court in some matter which is not what is before me, because then I would be ad hominem and doing law to catch a case? And we all know from the classic case of Lienage that that is not permissible. So this has nothing to do with a case. It is a general principle of law. And we have the opportunity to just cure that now. And I'll say it this way. The policy of the government, in line with that of the judiciary, and consonant with observations in the legal profession, including from the Honorable Director of Public Prosecutions, is as follows. Number one, we want it in the parent law. Number two, evidence is evidence whether it is in the civil or criminal trial, because it runs to the fairness of a trial. Whether it is civil or criminal, it's no difference. They have different standards, sure, and there are different consequences, sure, but it's still a trial. And therefore, in those circumstances, the policy of the government is quite simply to amend the Supreme Court of Judicature Act, and later you will see, Mr. Chair, the Summary Courts Act, so that we settle the law once and for all.
Right. Honourable members, the question is that Clause 3 be amended as circulated and further amended by inserting the words "a child, comma." Those in favour say aye. Aye. Those against say no. I think the ayes have it. Clause 3. The question is that Clause 3 as amended now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it.
Clause 4.
Clause 4. AG.
Mr. Chair, for the same reasons advanced in respect of the amendments to Clause 3 and the bill, I ask honourable members to please consider the proposed amendments as circulated in respect of Clause 4, save only on the second page, at the bottom of the page, at Roman 3, to insert the words "a child," comma, before the words "if the child."
The question is that Clause 4 be amended as circulated and further amended by inserting the words "a child," comma. Those in favour say aye. Aye. Those against say no. I think the ayes have it. The question is that Clause 4 as amended and circulated be further... Oh, sorry. The question is that Clause 4 as amended now stand part of the bill. Those in favour say aye. Aye. Those against say no. I think the ayes have it.
Clauses 5 and 6.
The question is that Clauses 5 and 6 stand part of the bill. The question is that Clause 5 and 6 now stand part of the bill. Those in favour say aye. Aye. Those against say no. I think the ayes have it. Clauses 5 and 6 now stands part of the bill. Honourable members, the question is that the bill as amended be now reported to the House. Those in favour say aye. Aye. Those against say no. I think the ayes have it. The House will now resume. Attorney General.
Good morning, Mr. Deputy Speaker, and to my learned colleagues. How lovely to hear the bells chime at this hour. Mr. Deputy Speaker, I wish to report that the Miscellaneous Provisions Administration of Justice Bill 2020 was considered in Committee of the Whole and approved with amendments. I now beg to move that the House agree with this report from the committee.
Good morning, likewise, members. Honourable members, the question is that this House agree with the committee's report on the Miscellaneous Provisions Administration of Justice Bill 2020. All in favour say aye. Aye. Any against? The ayes have it. Attorney General.
Mr. Deputy Speaker, I beg to move that the Miscellaneous Provisions Administration of Justice Bill 2020 be forthwith read a third time and passed.
Honourable members, the question is that the Miscellaneous Provisions Administration of Justice Bill 2020 be forthwith read a third time and passed. All in favour say aye. Aye. Any against? The ayes have it.
A bill entitled An Act to Amend the Supreme Court of Judicature Act, Chapter 401, the Summary Courts Act, Chapter 420, the Coroners Act, Chapter 604, and the Sexual Offences Act, Chapter 1128, to provide for the procedural matters of the courts and for matters related thereto.
Attorney General.
Mr. Deputy Speaker, I beg to move that a bill to amend the mutual, I beg to move that a bill entitled A Bill to Amend the Mutual Legal Assistance in Criminal Matters Act, Chapter 1124, the Proceeds of Crime Act, Chapter 1127, the Anti-Terrorism Act, Chapter 1207, the Interception of Communications Act, Chapter 1508, the Financial Intelligence Unit
of Trinidad and Tobago Act, Chapter 7201, the Income Tax Act, Chapter 7501, the Central Bank Act, Chapter 7902, the Financial Institutions Act, Chapter 7909, the Companies Act, Chapter 8101, the Securities Act, Chapter 8302, and the Non-Profit Organizations Act, number 7 of 2019, be now read a second time. Mr. Deputy Speaker, I'm very pleased to pilot this bill to amend these 11 pieces of law. I do so, Mr. Deputy Speaker, in the context of Trinidad and Tobago's continued work in ensuring compliance with our international obligations. By now, members will be well familiar with the fact that Trinidad and Tobago underwent review from the Financial Action Task Force, and that following upon our fourth round mutual evaluation, where we performed terribly in January 2015, Trinidad and Tobago was put into enhanced follow-up in the Caribbean Financial Action Task Force, and we were also put into grey listing, sometimes confused for blacklisting, by being referred to the International Corporation Review Group, the ICRG, of the Financial Action Task Force itself. Because of the size of Trinidad and Tobago's economy, we were singularly named in the International Corporation Review Group by FATF, meaning that we were obliged to be put upon a mechanism of continuous reporting to the Financial Action Task Force. We had goals to achieve, and we had to, in the reporting on your progress in the fourth round mutual evaluation, the Financial Action Task Force is looking at your efficacy, not only the laws that you have. The third round effectively looked at your laws to meet technical compliance. Do you have an Anti-Terrorism Act? Do you have a Proceeds of Crime Act, etc.? But it's in your fourth round they looked at the efficiency of your laws. I'm very pleased to say, Mr. Deputy Speaker, thanks to the hard work of all stakeholders, and permit me at this moment to recognize in particular the Secretariat of the Attorney General, led by our head of Anti-Terrorism Unit, Ms. Viana Sharma, the Chief Drafter for the work of the Financial Action Task Force, the indefatigable Ida Eversley, who has worked tirelessly for Trinidad and Tobago, and of course all of the hard-working people across the spectrum at the SEC, the Central Bank, the Financial Intelligence Unit, the Financial Investigation Branch, Customs, etc. We managed to do phenomenally well. We succeeded in our third follow-up report and in our final review. We subjected ourselves in January of this year, 2020, to an on-site examination by the Joint Group of the Americas, and we passed with flying colors. In that regard, we were taken out of the assessment routine. We were taken off the negative listing, but we have continuing obligations. There will be a fifth round. Very importantly, other bodies, the European Council in particular, the derivative of the European Union, they have their own independent methodologies where they take the FATF listing and they misapply it. And I say that very purposefully here because I have written to the European Commission and indicated Trinidad and Tobago's thorough dissatisfaction with having been placed upon negative listing by them, even though we have come off of the FATF negative listing. And in that regard, the European Council in particular has accelerated the consideration of our treatment of two aspects of the FATF methodology. Number one is recommendation 25 for beneficial ownership and its transparency. And number two, very importantly in this bill today, are the elemental features of what we call recommendation 35. Recommendation 35, which was effectively crystallized in our third follow-up review report in June 2019, had the FATF making the following commentary. And that is to be found in that report, which is in the public domain. The FATF's comment was specifically on comparison with previous FATF reports where no administrative financial sanctions are in place, no ratings above PC, meaning partially compliant, have been given. We would encourage comparison with the mutual evaluation reports of Switzerland and Norway in this regard. The matter was also raised in discussion during the MER, Mutual Evaluation Report of Denmark. We would particularly note that the ECG discussed the issue in the MERs of Switzerland and concluded that whilst administrative financial sanctions should not be regarded as mandatory, in specific circumstances, a fine is the only adequate and proportionate sanction available. Therefore, the absence of an ability to levy financial administrative penalties means that, on the basis of current precedent and consistency with other reports, this rating should remain as PC. Let's translate that. The Financial Action Task Force said to Trinidad and Tobago, go and install administrative sanctions alongside your criminal sanctions. And specifically, Mr. Deputy Speaker, do that as we have crystallized it in our working groups in the Proceeds of Crime Act, the Anti-Terrorism Act, the Financial Intelligence Unit of Trinidad and Tobago Act, the Income Tax Act, the Central Bank Act, the Financial Institutions Act, the Securities Act, and, sorry, I should not have said the Income Tax Act. Please exclude that, but all others. And therefore, Mr. Deputy Speaker, when one has regard to the fact that under the Proceeds of Crime Act, Anti-Terrorism Act, Financial Intelligence Unit Act, Central Bank Act, the Financial Institutions Act, and the Securities Act, coupled with the Financial Obligations Regulations and the Financial Obligations Regulations with respect to terrorist financing, we propose specifically in this bill to introduce an alternative approach to criminal sanctions by the introduction of administrative sanctions. What are administrative sanctions? Administrative sanctions are where the regulator has the opportunity to tell a regulated entity or a listed entity, as we have in the Proceeds of Crime Act, listen, you have an option. You can take an administrative fine, which is significantly less than the criminal offense route. If you pay that fine, okay, if you agree to. If you don't, we'll take you to court either on a summary offense or an indictable offense. And what we propose, Mr. Deputy Speaker, therefore, is that we bring to life this whole concept of administrative penalties. Administrative penalties are put in place where you are dealing with matters that don't involve a mens rea or a mental intention. It's usually an act, a failure to file something, a failure to do something where there was no intention or mental element behind the crime. So, Mr. Deputy Speaker, we propose specifically in looking at this bill to do the following. The short title is Clause 1, the commencement is Clause 2. Clause 3 is the amendment now outside of the Recommendation 35 administrative sanctions. We wish to put a secrecy provision inside of the Mutual Assistance in Criminal Matters Act. What is that? The Mutual Assistance in Criminal Matters Act is the legislation which allows us to engage in reciprocity for criminal matters in Commonwealth and non-Commonwealth jurisdictions, and specifically to allow for extradition proceedings. We're proposing the introduction of a confidentiality of information, and that persons who are employed at the central authority, and I should say the Attorney General is the central authority under that, but there is a unit, persons who are employed and who previously were employed are subjected to an offense if they disclose information improperly other than in the course of their employment. This would allow, as we have right now, in significant matters, the reciprocity of information, and for our foreign intelligence partners and other jurisdictions to be certain that there will be no leaking of information which would prejudice or tip off an investigation. We then propose in Clause 4 to amend the Proceeds of Crime Act. Effectively, as I mentioned earlier, we're bringing to life the regime of administrative sanctions. We are proposing, consequent upon the observations of the FATF, that we allow for the springboard for regulations to provide for either breach of regulations amounting to an administrative fine. In default of that payment of fine, you commit an offense, or that you go another route, which is that you just go summary or indictable for breach of regulation. We also recognize that there is merit in harmonizing these laws, because in the FIA, and we look at the SEC in particular, CBTT, Central Bank, and Trinidad Securities Exchange Commission, there is a progressive sanctioning regime. And therefore, we want to harmonize all of our laws with these administrative sanctions to work in best interest. Mr. Deputy Speaker, very importantly, in the Proceeds of Crime Act, we are proposing an amendment to the Seized Asset Fund. We are allowing in the Seized Asset Fund, Mr. Deputy Speaker, the introduction of, in Section 58E, another purpose. We are proposing a widening such that the minister may, by order in addition to matters set out above, determine that the funds may be used for any other purpose. Why? Trinidad and Tobago is at the cusp of the recovery of hundreds of millions of dollars. Let me repeat that. We are at the cusp of the recovery of hundreds of millions of dollars, and with the amplification of recovery under the unexplained wealth orders and the amendments that this government has caused to improve the following the money in corruption matters, we want to allow the broadening of the category of matters for which the seized assets funds may be used. This is a direct request of the Honorable Prime Minister, Dr. Rowley, in saying that we will treat with these matters in a very careful way to improve our society's utilization of the proceeds of crime once recovered. Mr. Deputy Speaker, we in further amendments follow consequential amendments to the financial obligations regulations. This is pursuant to the administrative sanctions being introduced, and that is to revise Regulation 42. Mr. Deputy Speaker, we turn to Clause 5 to amend the Anti-Terrorism Act. Specifically, there is a provision for the Attorney General to list terrorist entities pursuant to Section 22B of the Anti-Terrorism Act, but we need to seal these records. Again, if we are going to have information given to us by law enforcement authorities in other jurisdictions, we cannot run the risk of having information tip off criminal investigations, and therefore we are sealing the record to these matters. That is not to say that the matters won't be heard inter partes amongst related parties, but they will simply stay out of the public domain. This is borrowed from the provisions that we use in the Financial Intelligence Unit legislation, and therefore it takes us into a better place. Mr. Deputy Speaker, in the Anti-Terrorism Act, we of course bring to life the administrative sanctions route, as I have described, to meet recommendation 35 of FATF. Mr. Deputy Speaker, we cause the exception to Section 63 of the Interpretation Act so that we're not confined to the very low penalty of $500 for breach of regulations as that act usually provides. Mr. Deputy Speaker, obviously the financial obligations, financing of terrorism regulations also have to be amended, and that is again a consequential amendment as a result of the amendment to the Parent Act, and we'll be amending Regulation 8. We then, in Clause 6, Mr. Deputy Speaker, move to amend the Interception of Communication Act. Mr. Deputy Speaker, notwithstanding the opposition's statement that they intend to tackle this law in the courts and to seek to set it aside, we intend to proclaim the law. In doing our consultations prior to proclamation, the Honourable DPP pointed out that there was an amendment that was required to the Interception of Communication most recent amendments. The Honourable DPP asked us to clarify that designated devices would be defined, and that was done by a simple fix to Section 6A2 by simply adjusting the shoes of the legislation, breaking it apart such that the minister will clarify the definition of a designated device. In other words then, prisoners will be allowed to speak on devices approved by the minister. so that you can preserve legal professional privilege and not breach the law, therefore allowing us to bug the rest of the prison and to record prisoners if they are engaged in illegal activities. Why the opposition wishes to save prisoners from being bugged and recorded, God alone knows. I cannot understand that. Mr. Deputy Speaker, we also heard from the DPP that we should include stored data into Section 18 of the Act. We've taken up that. It was an inadvertent error not to include it when we did the amendments last. Clause 7 treats with the amendments to the Financial Intelligence Unit Act. A number of amendments are proposed here, from nomenclature, by calling the FIU, the Financial Intelligence Unit, the FIU-TT, adding Trinidad and Tobago, because they're a member of the Egmont Group, and everybody has an FIU. It is to allow for us to distinguish the FIU-TT from the other FIUs in the Egmont Group when we are disseminating information. We have allowed as well for the concept of deregistration by the FIU, ex proprio motu of its own volition, or by way of application for deregistration. We have also allowed for the inclusion of the Police Complaints Authority. The FIU has to be within the fold of providers of information to the PCA for police misconduct. I can only refer you to recent events in the public domain where you have seen massive money laundering allegations concerning members of the protective services. And therefore, it is only proper that the FIU provide information to the PCA in lawful circumstances where there are production orders, etc. Mr. Deputy Speaker, we also allow for the introduction of administrative penalties, meeting the recommendation 35 observations that I've pointed out before. Mr. Deputy Speaker, we amend the Income Tax Act, we amend the Central Bank Act, we amend the Financial Institutions Act, we amend the Securities Act to add one common theme. That common theme is to specifically say that a matter which has been the subject of compulsory disclosure by the court and for which the DPP says there ought to be disclosure and for which the purpose is the production of a witness statement, that the secrecy provisions in these acts that I have just mentioned will be further opened up not only to police officers, as I have piloted previously in this Parliament, but now also to the Police Complaints Authority. Why? This is to allow them to pursue police misconduct. Mr. Deputy Speaker, apart from the commonality in those sections, I can also refer you respectfully to the Central Bank Act, where we propose the introduction of the administrative fines in amplification, in meeting the recommendation 35 considerations, and importantly, for a small amendment to the tenure of the governor of the central bank, allowing for a period of not less than 3 years appointment and then not more than 5. Why? So that there is not the misfortune of a coterminous appointment at the same time a government is happened to be put into the saddle. Mr. Deputy Speaker, we amend the Financial Institutions Act, as I've described already, in common with the PCA amendments. We then proceed in Clause 11 to amend the Companies Act. Mr. Deputy Speaker, we are clarifying amendments that we put into effect already, where you surrender your bearer share warrant or your share warrant, where you are improving the beneficial ownership or transparency provisions under the Companies Act. We are also ensuring that we capture name, address, email addresses, etc., because we are about to launch the fully online suite for the Companies Act, where we will effectively abandon paper filings and give you a two-step authentication process. You amend the Companies Act, you get a text message and you get an email saying your form was just filed for the change of directors, your change of address, somebody has attempted to deregister you, where there's a real-time tracking mechanism born on the back of a complete reformation of the Registrar General's Office undertaken in the last 5 years, I would say, under our watch. Mr. Deputy Speaker, we're making sure that we capture not only shares limited by, not only companies limited by shares, but we're capturing companies limited by guarantee. Because as you know, Mr. Deputy Speaker, companies are of different types. They may be not-for-profit, they may be externally registered companies, they may be shares limited in liability, they may be companies limited in liability by shares or companies limited in liability by guarantee of its members. Mr. Deputy Speaker, we are also cleaning up some errors which happened way back when the Companies Act was brought into effect, Chapter 8101, and therefore we're tidying that up. Mr. Deputy Speaker, we go to Clause 12, which amends the Securities Act. There are a number of things requested by the Securities Exchange Commission. Of course, we are putting in the administrative penalties. And then we're taking care of some market activities where draft submissions were made, and then there was this whole debate as to whether time started to count on the clock or not. There was the change in nomenclature for the legal officer. There was inadvertent spelling inside of the Act. And we have also, very importantly, improved the amendments to the access to information by specifically tidying up the SEC legislation so that you always preserve in clearer form that any information disclosed from the SEC to named bodies will be the subject of a criminal sanction for improper disclosure. And that, Mr. Deputy Speaker, assists us. Further, we have added in, of course, the creature of the Police Complaints Authority, as I've identified a little bit earlier. Mr. Deputy Speaker, we treat with some massaging again in practical terms for locally distributed securities and how registrants make notification. The last clause, Clause 13, is where we amend the Non-Profit Organization Act, number 7 of 2019. We had referred to the FIU under that act as the regulator. In fact, the FIU is really a supervising authority, and therefore we just simply harmonize the term to meet with the better description of what the functions of the FIU are. Mr. Deputy Speaker, with the passage of these amendments, Trinidad and Tobago will be able to advance its removal from the blacklisting by the European Commission, the European Council, specifically in its further updates. We will be required to proclaim the Registry of Trusts, which we included in the Registration of Deeds Miscellaneous Provisions Amendment. If we do these administrative sanctions, we will take care of Recommendation 35 observations, and then the European Union, the European Council, will have no choice but to remove us into the clean state and condition that we find ourselves in the FATF. I look forward to the contributions of my learned colleagues, and I beg to move.
Honourable members, I shall now propose the question for debate. The question is that the Miscellaneous Provisions FATF Compliance Bill 2020 be now read a second time. I recognize the member for Barataria, Sanwan.
Thank you very much, Mr. Deputy Speaker, and thank you for recognizing me this time to join this debate on the Miscellaneous Provisions FATF Compliance Bill 2020. And Mr. Deputy Speaker, this piece of legislation that we're contemplating about at 12:27 a.m. Saturday deals with some very important pieces of law that regulates basically the financial industry to ensure that persons don't engage in money laundering and terrorist financing, and to ensure that Trinidad and Tobago obeys our international obligations when it comes to FATF, CFATF, and also those obligations we would have with the European Union. And Mr. Deputy Speaker, one of the things that I observed is that this is a very loaded piece of legislation because we're amending 13 pieces of law, 13 clauses in the bill. And this omnibus type legislation really doesn't augur well, especially in this COVID time. And for the record, I would just like to say that as members of parliament, we only have limited time to speak on certain matters. And bills such as these, which has so much implication and being so loaded, we don't really do justice to what is before us, especially this being the 5th bill that we're passing for this particular sit-in. So while there may be some clauses in the bill that we will agree with, that we will be comfortable with, there are other clauses in the bill that is very objectionable. And one of those clauses, and I'll go through some of the issues that I have with regards to the bill. And in particular, I have seen various clauses that deal particular with the FATF compliance. So we look at the introduction of the administrative sanctions, the amendment to the Non-Profit Organization Act. We looked at the amendments to the Proceeds of Crime, Anti-Terrorism, the Seized Funds Asset. So those are the things that deal with FATF. But it brings me to the clause that deals with the interception of communication. And that is found at clause 6. And the amendment reads that we're going to now, and I don't know if the Attorney General made a drafting error here, but when we pass the amendment to the Interception of Communication Act, I believe the first part, in such places within a prison as may be specified by the minister by order, is already in the amended legislation that we would have passed. That is the 2020 amendment, where you were able to intercept communication from within the prison. But this is where the issue lies, Mr. Deputy Speaker, at 6B, where we amend section 18A, 1, 2, 6, and 7. And 18A was one of those clauses that was introduced by the 2020 amendment to the Interception of Communication Act. And just as a matter of history, you will remember that that particular piece of legislation was introduced in the Senate with a special majority. It was debated in the 11th Parliament. The special majority was removed in the 11th Parliament in the House and then brought back to the Senate, because we had raised various constitutional issues regarding the amendment to the Interception of Communication Act. And 18A, Mr. Deputy Speaker, is a very troubling section, because we are amending the section to now allow a constable to obtain a warrant or production order under any written law for the purpose of obtaining any communication data, stored data, or stored communication. So you're introducing the ability for a constable to go to the court and get stored data. Now, what is troubling about this, Mr. Deputy Speaker, is that, one, it is unconstitutional. And I say that because the effect of this amendment will have a retroactive application of the law, meaning that stored data, the constable will be able to get stored data prior to the passage of this act. So therefore, the retroactive application of the act in itself is an unconstitutional method, because when you are going to pass laws, you pass laws going forward, moving forward, not going backwards. So that's the first point. The second point is that there were inherent safeguards in the parent act to the Interception of Communication law. And that is, one, that the persons who were allowed to obtain a warrant to intercept communication would have been the Commissioner of Police, the authorized officer, would have been the Commissioner of Police, the Chief of Defense Staff, or the head of the SSA. So those are the bodies that would have been able, or the officers, to get data. Now you're allowing a constable to receive data through a warrant. Now that in itself, Mr. Deputy Speaker, is troubling. And then apart from that, that constable can disclose the data to whom? The Commissioner. He can disclose the information in connection with the performance of his duties. And lastly, he can disclose the data if the minister directs such disclosure to a foreign government or agency of such government, where there exists between the state and such foreign government an agreement for the mutual exchange of that kind of information. and the minister considers it in the public interest that such disclosure be made. So what is happening here is that a minister, a politician, can now have in his possession intercepted communication from a constable, stored data, data that we don't know how far back it goes. That in itself, Mr. Deputy Speaker, is unconstitutional, and we cannot support that particular amendment. We cannot. Cannot. Mr. Deputy Speaker, this particular amendment has nothing to do with FATF. Which one of the recommendations in FATF recommends or tells Trinidad and Tobago that we have to amend the Interception of Communication Act to obtain stored data? Why it is that we are continuously, this government is continuously whittling away on the rights of our citizens, Mr. Deputy Speaker, and trampling on enshrined constitutional rights, protections, and privileges that we have. This in itself, Mr. Deputy Speaker, is a dangerous, dangerous amendment. And we saw that they sneaked in this amendment into this fully loaded bill, thinking that what, the opposition would not be able to identify it. Mr. Deputy Speaker, this in itself is disingenuous to call this bill a FATF compliance bill when this particular amendment has nothing to do with FATF. Nothing. Absolutely nothing. And we cannot support that. We cannot support that at all. Now, there are other clauses in the bill which I would admit we have to deal with regards to FATF. And just like the Attorney General, I looked at the follow-up report, the third follow-up report on the technical compliance and re-rating of Trinidad and Tobago when it comes to FATF. And they did, in fact, indicate to Trinidad and Tobago that, and I could read from that report at paragraph 100, that Trinidad and Tobago was rated partially compliant with recommendation 35. The technical deficiencies, among others, were that the sanctions to address non-compliance with the AML CFT obligations in some cases were not proportionate to the infraction or sufficiently dissuasive to discourage reoccurrence. So that's deterrence. Except for the TTSEC, there were no monetary administrative penalties for AML CFT breaches. So I can understand that. I can understand the amendments that we're making in order to introduce the administrative sanctions when it comes to various pieces of law, such as the Proceeds of Crime, the Anti-Terrorism Act, the FIU, the Central Bank, the Securities Act. I can understand all of that. But what I cannot understand is why you are amending the Interception of Communication Act in a FATF bill. And the Attorney General will stand up and say, well, that is because you have to investigate the crimes or whatever. You bring these pieces of law that require a special majority on a separate piece of legislation. You are touching fundamental human rights. You are touching it. And you are trampling upon those rights. Now, I looked also at the amendment that deals with the Police Complaints Authority in terms of the witness statements that must be provided. So currently, as the law stands, is that you can have an employee, for example, if we're looking at the BIR, having to provide a police officer with a witness statement. And now they're asking for persons from the Police Complaints Authority to be able to obtain a similar witness statement in certain cases. So, Mr. Deputy Speaker, in this case, what we're seeing here is that the Police Complaints Authority is an authority with very little coercive powers. The Police Complaints Authority, according to their act, when you look at Section 30 and Section 44, Section 30 deals with the preliminary investigation. They are allowed to investigate matters and then refer those matters to the DPP, the Commissioner, or the Police Service Commission in certain instances so that follow-up action can be taken. And on the conclusion of that investigation, the authority shall make an assessment and form an opinion as to whether or not the subject matter of a complaint has or may have occurred, is or may be occurring, is or may be about to occur, or is likely to occur. So you're going this one step in order to give them the power to now access sensitive information on individuals, mainly the police officers, because they have jurisdiction to investigate police officers. But why don't you give them the power that they have been asking for all of the time? Because they can conduct an entire investigation, but at the end of the day, they can't do nothing, save and accept to refer the matter to the DPP or the Commissioner of Police, who will then take action with regards to determining whether or not a prosecution for that matter is warranted. And I looked, Mr. Deputy Speaker, at what the current statistics are when it comes to police corruption and misbehavior. And this is an article dated the 3rd of October 2020. And this article was from the Trinidad Newsday. And this article related and reported on the PCA annual report. And in that report, they talked about from the period October 1st, 2019 to September 25, 2020, there were 394 formal complaints to the authority. And between October 1, 2019 and March 31, 2020, the PCA received 209 complaints. And out of those complaints, 15 were for fraud and corruption. And this particular amendment that we're dealing with will deal with those matters relating to fraud and corruption. So, Mr. Deputy Speaker, I just want to ask the Attorney General, when he's winding up, this specific amendment, when it comes to the PCA having that power now to obtain witness statements from those statutory bodies or financial institutions, is that also a recommendation of the FATF in terms of whether or not we have to guard the guards, because this is essentially what we are doing, we're guarding the guards. The next issue I have comes with the amendment to the Anti-Terrorism Act. And we have done extensive work on this particular piece of legislation, especially the amendments that we made that were subject to a joint select committee. And myself and the Attorney General and other members of the 11th Parliament would have served on that committee, where we did some good work. And the amendment that I'm seeing to the Anti-Terrorism Act, and I'm seeking clarification from the Attorney General on this matter, deals with the procedural issue that we're going to undertake. So at Clause 5, Mr. Deputy Speaker, we are amending in Section 22B of the Anti-Terrorism Act to include a new subsection 13, which states that an application under subsection 1A shall be filed under seal. Now, that application under Section 1A that they're speaking about is a freezing application where the Attorney General has the power to apply to a judge to make an order against a designated entity, an entity who knowingly committed or participated in the commission of a terrorist act, or other instances where that person may have benefited or was in association with a terrorist organization or listed entity. So if we're making an ex parte application, I wonder what is the rationale behind sealing the proceedings. And then, Attorney General, Mr. Deputy Speaker, through you to the Attorney General, when you look at Section 3A of the 3A of the Anti-Terrorism Act, it states a person likely to be affected by an order made under subsection 3 shall, as far as practicable, be served with a copy of the order and may within 60 days after the publication of the order under subsection 5 apply to a judge for a review of the order. So what that really means is that after a freezing order is made, when the Attorney General makes the application to a judge of the High Court, that order shall be served to that person who is affected, and then he has 60 days in order to complete a review of that order. Now, if we're sealing the proceedings and we're making this order now, I know some of the orders where you can't find the person, it's published in the newspaper. Will the proceedings now have to be unsealed if those orders have to be made public through advertisement in the newspapers? So that is one of the issues I'm looking at, whether or not this particular provision is running with respect to, is conflicted with other existing provisions in the law as it stands. And it is important because Attorney General, you will also remember at 3C, these orders are very extensive because it can apply to a person with the same or similar name to a designated entity. And I think I may be captured under that particular provision, having a similar name to some very notorious individual from the Middle East. So that is one of the issues I would like to look at when it comes to the Anti-Terrorism Act, whether or not the sealing of the proceedings will fall or be inconsistent with other existing provisions at Section 22B of the amendment to the Anti-Terrorism Act. The seized funds asset, that also, Attorney General, if we can get some more information. I know that there's an annual report that has to be done. I know there's a committee that also has to be set up that deals with the seized funds asset. Can you give us some information on whether or not, what is the total, the value of the funds currently in the seized asset funds, whether or not we have the committee set up, because what we're doing now is we're giving power to the minister to use the funds for other means other than what is prescribed in the existing law. So that is something I would like to get some more information on with respect to the seized funds asset. So, Mr. Deputy Speaker, when it comes to amendments regarding FATF and our compliance with other international bodies and relations that we may have, for example, the Global Forum, the opposition has worked with the government. We have passed the legislation. The Attorney General can boast today that Trinidad and Tobago is in a better place with regards to our rating with FATF. It was a concerted effort by both benches of the Parliament, opposition and government, and the independent bench in the Senate. We have passed the laws. There's still some more work to be done, as evident by this amendment that comes to the House. And I continue to reserve my right under this particular bill that we do not agree at all. We cannot support the amendment at Clause 6, which is the amendment to the Interception of Communication Act. Because in our considered view, Mr. Deputy Speaker, that amendment is in fact unconstitutional, and that amendment tramples and infringes on the rights of individuals, be their right to privacy and their right to a fair trial. And I thank you very much.
I recognize the Attorney General.
Thank you, Mr. Deputy Speaker. Mr. Deputy Speaker, it gives me no pleasure to begin the schooling that I must right now. Mr. Deputy Speaker, I heard the member for Barataria Sanwan in an earlier debate tell me he wished that now he understands why I spent time at law school. I understand from the honourable member's submission why apparently he did not spend enough time at law school. And I'd like to tell you why, and I mean this most sincerely. You see, saying something with a sober voice don't make it sensible, you know.
Say that again.
Saying something with a sensible voice does not make it sensible. It could be sober, but it's not sensible. Mr. Deputy Speaker, you know, we have an iPad paid for by the taxpayers. We have the laws of Trinidad and Tobago paid for by the taxpayers, the hard volumes, red book, and inserts. We have the member for Barataria Sanwan standing up to tell people that he understands things about their character. Mr. Deputy Speaker, I want to refer you to a piece of law. It's Chapter 1201 of the Laws of the Republic of Trinidad and Tobago, Mr. Deputy Speaker. Chapter 1201 is not a recent law. It's a law starting in 1917. And in 1917, a police constable had the authority under Section 5 of that law to approach a court and get a warrant for anything. Since 1917. Mr. Deputy Speaker, there's another law. I don't know how old Barataria Sanwan is. Surely he's older than 22 years old. But Mr. Deputy Speaker, there's another law called the Proceeds of Crime Act. And under the Proceeds of Crime Act, one has the ability, again, a police constable, to approach the court to get a production order. But Mr. Deputy Speaker, a sober voice coming from Barataria Sanwan says to us, it is unconstitutional, these amendments to the Interception of Communication Act. We can't support it. These amendments to the Interception of Communication Act. I mean, come on. We have the Interception of Communication Act, and it has been amended. The honourable member says that it's going to be retroactive, these amendments. What intellectual nonsense, Mr. Deputy Speaker. And let me tell you why. I go to the Interception of Communications Act, Chapter 1508, as amended. Section 4, capital A, this act applies to. Subsection 3. For the avoidance of doubt, all communication data obtained by a constable prior to the coming into force of this act and lawfully obtained pursuant to sections 32 or 33 of the Proceeds of Crime Act or section 5 of the Indictable Offences Preliminary Inquiry Act shall continue to be admissible in evidence. That honourable member had the audacity to tell the Honourable Parliament tonight that this law is unconstitutional and we're given retroactive powers for the first time, Mr. Deputy Speaker, since 1970.
One second. Barataria Sanwan. Barataria Sanwan. Not this morning. Not this morning. Please, proceed.
Mr. Deputy Speaker, when you hear crying and gnashing of teeth and wailing like a schoolgirl getting whipped, it's a hard thing to listen to, you know. Because tonight I've had enough of Barataria Sanwan. He betrays the honor and dignity of this Parliament by failing to read the law. The 1917 law, the Preliminary Inquiries Legislation, Section 5, the 2000 Proceeds of Crime Act, Section 32 and 33. Shame on you, Barataria Sanwan, coming forward to say that this is law. Is there something that you wish to raise by standing order? Is there? I'll give way.
He has nothing to say as usual.
I've offered to give way to the wailing and gnashing of Barataria Sanwan, who cannot explain to this country how the law says that a constable since 1917 could get a warrant to get anything, including stored data, how Section 32 and 33 of the Proceeds of Crime Act allows for production warrants, and then the honourable member has the audacity and the lack of shame to stand up here and say that this law will be unconstitutional. Madam Speaker, spend a little more time in law school. Pick up the books. Take a read. Go to class. Go to class. Take some notes. Let's get to 18A of the Interception of Communication Act. Hear the intellectual rubbish that fell from Barataria Sanwan. 18A is new and novel law. 18A is the power to obtain communication data, stored communication, by a search warrant. We're adding in stored data. 18A was designed and put into the law to bring constitutionality and to preserve and add the safeguards from the Interception of Communication Act for the first time, to put those safeguards on a Section 5 warrant for the preliminary inquiries route, or Section 32 or 33 production order under POCA. This honorable member, the member for Barataria Sanwan, stands up here to say that this is something you know, sir. This is law designed to protect tipping off for the first time, to add the strictures of Sections 13 and 14 of the Interception of Communication Act. And what are those? Sections 13 and 14. Sections 13 and 14 are duties of persons providing assistance to telecommunication. 14, confidentiality of intercepted communication. You see, Madam Speaker, prior to the amendments brought by this government in the last Parliament, a Section 5 warrant for stored data and a Section 32 and 33 warrant under POCA production order had no provisions to safeguard confidentiality. And Barataria Sanwan, intellectually shameless as he is tonight, has the intellectual audacity to tell the country that there is not going to be support because this law is somehow dangerously...
Standing order 48-6. Member shameless.
Attorney General.
Thank you. Intellectually shameless, the honourable member, incapable of reading the law as a whole by way of interpretation, not willing to bother to understand that 18A added protections to improve the constitutionality of the stored data production via the preliminary inquiry route in Section 5 or Sections 32 and 33 of the Proceeds of Crime Act production orders. The honourable member comes to threaten the government tonight in a sober tone that the honourable member says the opposition is not supporting, he said, almost in a shrill tone, the amendments being proposed by this legislation to add stored data, Madam Speaker, to the protection provision in 18A. Geez and ages, I feel in shame. I feel in shame, Madam Speaker, that this is the quality of contribution at 12:56:29 a.m. in the morning. Go and buy your doubles and get some nutrition. Clarence Rambarat will help you to find a good doubles man. Madam Speaker, you pay your rent yet? For the house, Madam Speaker.
Attorney General, please address your comments this way.
Thank you, Madam
St.
Speaker.
Augustine, I've just come in. This is the second time I've stood up. Please continue your crosstalk. Attorney General.
Yes, Madam Speaker. You see, you get a little tired when you're fed up here. Lack of research in action and not paying the rent. Madam Speaker, not paying the rent. Madam Speaker, contrary to the observations of the member for Barataria Sanwan, the graduation from the Financial Action Task Force did not involve the UNC's assistance in large part, save for the anti-terrorism disaster in difficult management. Every single other bill that was passed had to be passed on a simple majority basis, including the Interception of Communication amendments, which they have now threatened they're going to court to overturn so that prisoners could live happily without recording in their cells. Well, I could tell you this, Madam Deputy Speaker, we intend to meet them in court and beat them the same way they get beaten every election. left, right, and center. So bad is the beating that I heard the member for Point-a-Pay the other night on a political platform using a PNM war cry, we go beat you in the north, south, east.
Member?
Standing order 48-4, please.
Overrule.
I have to confess, when I got the meme of the honourable member for David for Point-a-Pay, the one and only MP I know who could campaign in his constituency without being present when the music truck passed in, Madam Speaker, I have to tell you, voiceover in action. I enjoyed the little clip, Madam Speaker. I'm still waiting to hear if you know 3 streets in Point-a-Pay. But anyway, Madam Speaker, when I heard them say, we go beat them in the north, we go beat them in the south, we beat them in the east, we go beat them in the west, all I was waiting to hear is great is the PNM. That's all I was waiting to hear, Madam Speaker. So, Madam Speaker, I would like to most respectfully tell the honourable members opposite. The country has measured you, marked you, and they're marking us too. We are no strangers to being marked hard. Madam Speaker, it causes us little concern who have crush on who had a call your name whole day and whole night. But when you stand up in a big man name and you want to pelt big man cuff, don't cry like a little girl when you get 2 slapped. That's the advice that we will give certain members in this House, Madam Speaker. So, Madam Speaker.
Attorney General. Attorney General. Please.
I don't want to hurt anybody's feelings tonight. I will rephrase. There have some soft personalities around, and I don't want to be too pejorative. It's nice to flex every now and then and to put a little hard lash. So, Madam Speaker, of course, Madam Speaker.
And the other thing I stand on, I've noticed a tendency to speak of girls in a particular way. Maybe you haven't realized it, and men in a particular way, and I think we need to watch that in 2020.
Madam Speaker, let me put it this way. As one of the members in this House knows, when nobody stands up for women, I do. There are members in this House that know that. I have a twin sister born to a powerful mother, a powerful wife as my companion, and 2 powerful daughters. I respect women wholeheartedly. Madam Speaker, the vernacular in Trinidad is sometimes intriguing and useful, but I hear you, Madam Speaker. So, Madam Speaker, I'd like to simply say to the honourable members opposite, don't come and pretend. Do your homework. Read the law in front of you. I've seen Chaguanas West nearly in tears at the contribution coming from Barataria Sangman. Cringing at the fact that you can't read Section 4 versus Section 18A of the Act. Madam Speaker, we pray for our friends opposite to continue doing exactly what they're doing. Once they continue doing what they're doing, we good on this side. Madam Speaker, this is good law before us. There's no sinister purpose. For those who are willing to do comparisons of the real law and bother to know that the law in 1917 permitted something and 2000 permitted something, welcome to the world of research. In respect of the anti-terrorism amendments and for the sealing of records, Madam Speaker, the honourable member asked a question, again betraying any kind of understanding. Why are you sealing it if it's ex parte? Geez and ages, it has to go inter partes afterwards. Ex parte is followed by inter partes. They're going to serve it. What kind of question is that? Seriously, in law, why seal it if it is ex parte? You have to serve the proceedings. And once you seal the record, the judge will then decide what the circumstance of service, if it is to be publicized, will be. I gave the comparator of the Financial Intelligence Unit. But in today's world, where terrorism is a global phenomenon as it always was, intelligence reciprocity is bound by the understanding that confidence and confidentiality can be maintained. So for all of those reasons, Madam Speaker, I simply say I beg to move.
Honourable members, the question is that the Miscellaneous Provisions FATF Compliance Bill 2020 be now read a second time. All in favour say aye. Aye. Any against? The ayes have it.
A bill entitled An Act to Amend the Mutual Legal Assistance in Criminal Matters Act, Chapter 1124, the Proceeds of Crime Act, Chapter 1127, the Anti-Terrorism Act, Chapter 1207, the Interception of Communications Act, Chapter 1508, the Financial Intelligence Unit of Trinidad and Tobago Act, Chapter 7201, the Income Tax Act, Chapter 7501, the Central Bank Act, Chapter 7902, the Financial Institutions Act, Chapter 7909, the Companies Act, Chapter 8101, the Securities Act, Chapter 8302, and the Non-Profit Organizations Act, Number 7 of 2019.
Attorney General.
Madam Speaker, in accordance with Standing Order 68-1, I beg to move that the Miscellaneous Provisions FATF Compliance Bill 2020 be committed to the Committee of the Whole.
Honourable members, the question is that the Miscellaneous Provisions FATF Compliance Bill 2020 be committed to the Committee of the Whole. All in favour say aye. Aye. Any against? The ayes have it. This House will now go into the Committee of the Whole to consider the bill clause by clause. The question is that Clause 1 stand part of the bill. The question is that Clause 1 now stands part of the bill. Those in favour say aye. Aye. Those against say no. I think the ayes have it. Clause 1 now stands part of the bill. Clause 2.
Madam Chair.
The question is, Clause 2 stand part of the bill. Attorney General.
Madam Chair, in the circulated amendments, we inadvertently refer to Clause 3 as opposed to Clause 2, and it really ought to be that Clause 2 be amended as per the circulated draft. Apologies.
Whip? Okay. The question is that Clause 2 be amended as circulated. Those in favour say aye. Aye. Those against say no. I think the ayes have it. The question is that Clause 2 as amended now stand part of the bill. Those in favour say aye. Aye. Those against say no. I think the ayes have it. Clause 3. The question is that Clause 3 stand part of the bill. The question is that Clause 3 now stand part of the bill. Those in favour say aye. Aye. Those against say no. I think the ayes have it. Clause 3 now stands part of the bill. Clause 4. The question is that Clause 4 stand part of the bill. Attorney General.
Madam Chair, the proposed amendments to Clause 4 as circulated come as a result of the consultative input of the National Anti-Money Laundering Committee and the recommendation coming from all of the stakeholders, Central Bank, TTSEC, FIU, Customs, Board of Inland Revenue, FIB, other divisions of TTPS, etc., is that we ought to raise for consistency the proposed maximum limits from 500,000 to 1 million and from 1 million to 3 million
as they appear respectively. These are specifically to keep us in common and in conformity with the other administrative fines across the financial suite, in particular the CBTT and the SEC regime.
The question is that clause 4 be amended as circulated. Those in favor say aye. Aye. Those against say no. I think the ayes have it. The question is clause 4 as amended now stands part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clause 4 as amended now stands part of the bill.
Clause 5.
The question is that clause 5 stand part of the bill. Attorney General.
Madam Chair, the rationale for the proposed amendments are exactly as in respect of the previous clause. For the consistency of administrative fines, I want to bear in mind that these are just maximum fines. The regulations, when they come before Parliament, will demonstrate what the individual ratios will look like.
Well, the question is that clause 5 be amended as circulated. Those in favor say aye. Aye. Those against say no. I think the ayes have it.
There is an amendment to clause 6, just flagging. Okay, good.
Sorry. The question is that clause 5 as amended now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clause 5 as amended now stands part of the bill.
Clause 6.
The question is that clause 6 stand part of the bill. Attorney General.
Yeah, Madam Chair.
Madam Chair, as you know, we've been amending laws so frequently that the revised laws have not caught up to us. So this bill proposed in 6 subparagraph A, it proposed something which we had already done by way of legislative input earlier this year. It was specifically on the 13th of April. Sorry, Act number 13 of 2020. By Act number 13 of 2020, that amendment we proposed in paragraph A has already been effected. In those circumstances, we propose to delete paragraph A of the bill, 6A, and take off B. So we're just going to have that as the proposal for 6. In other words, then there's no longer an A and B, there's only that which appears at B, so removing the B.
Okay. So
the amendment would be delete paragraph A and remove numbering, open brackets, B. So the amendment to clause 6 will be delete paragraph A, open brackets, and remove numbering, open brackets, B, close brackets. So just the wording of B stands as clause 6.
okay, so the question is that clause 6 be amended as follows: to delete paragraph A, that is common A, and remove open brackets B, common B, close brackets.
Remove numbering. Open brackets, B, remove numbering, open brackets, close B, B, close brackets, so that the words stay but just the numbering removes.
Okay, so those in favor say aye.
Aye.
Those against say no. I think the ayes have it. The question is that clause 6 as amended now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clause 6 as amended now stands part of the bill.
Clause 7.
The question is that clause 7 stand part of the bill. Attorney General.
Madam Chair, the amendments to clause 7 are again to harmonize the regime for administrative sanctions, and the amendments are for the same reasons referred to previously.
The question is that clause 7 be amended as circulated. Those in favor say aye. Aye. Those against say no. I think the ayes have it. The question is that clause 7 as amended now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clause 7 as amended now stands part of the bill.
Clause 8.
The question is that clause 8 stand part of the bill. The question is that clause 8 now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clause 8 now stands part of the bill.
Clause 9.
The question is that clause 9 stands part of the bill. Attorney General.
Madam Chair, we are proposing the amendments as circulated in clause 9 in the list of amendments in paragraph B in the proposed D in brackets. We're inserting after the word supervisory role the words or general administration. This is just simply to harmonize the functionality of the CPT because they have a bifurcated function.
I believe we are all still in the same meeting. Attorney General.
Yes, Madam Chair. Insofar as DD is part of the powers of the central bank, functions, we are amplifying the imposition of administrative fines as are provided for under any other written law, under which the central bank has a supervisory role or general administration, because the CBTT acts in multiple capacities, Madam Chair.
Okay.
The reference to 56.2 really should have been 56.2 capital A, and therefore we're just correcting the cross-reference.
All right. So the question is that clause 9 be amended as circulated. Those in favor say aye. Aye. Those against say no. I think the ayes have it. The question is that clause 9 as amended now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clause 9 as amended now stands part of the bill.
Clauses 10 to 12.
The question is that clauses 10 to 12 stand part of the bill. The question is that clauses 10 to 12 now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clauses 10 to 12 now stand part of the bill.
Clause 13.
The question is that clause 13 stand part of the bill. Attorney General.
Madam Chair, there was a simple cross-referencing to change the number 2 to 3 in paragraph A, and therefore we propose the amendment as circulated.
The question is that clause 13 be amended as circulated. Those in favor say aye. Aye. Those against say no. I think the ayes have it. The question is that clause 13 as amended now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clause 13 as amended now stands part of the bill. Honourable members, the question is that the bill as amended be now reported to the House. Those in favor say aye. Aye. Those against say no. I think the ayes have it. This committee meeting is now adjourned. The House will resume. Attorney General.
Madam Speaker, I wish to report that the Miscellaneous Provisions FATF Compliance Bill 2020 was considered in Committee of the Whole and approved with amendments. I now beg to move that the House agree with this report from the committee.
Honourable members, the question is that this House agree with the committee's report on the Miscellaneous Provisions FATF Compliance Bill 2020. All in favour say aye. Aye. Any against? The ayes have it. Attorney General.
Madam Speaker, I beg to move that the Miscellaneous Provisions FATF Compliance Bill 2020 be forthwith read a third time and passed.
Honourable members, the question is that the Miscellaneous Provisions FATF Compliance Bill 2020 be forthwith read a third time and passed. All in favour say aye. Aye. Any against? Okay, so members, the announcement will be made. Members will have a 3-minute opportunity to get here. And as we said, if the count starts and members have not arrived, they'll be allowed to vote once it is before the division is given.
Mrs. Robinson-Regis.
Aye.
Mr. Al-Rawi.
Aye.
Mr. Imbert.
I agree with everything the Attorney General said, yes.
Mr. Young.
Yes.
Mrs. Morris-Julian.
Aye.
Mr. Hines.
Aye.
Mr. Dialsingh. Mr. Ford.
Yes.
Mrs. Webster.
Aye.
Ms. Kojo.
Aye.
Dr. Gatsby Dolly.
Aye.
Mr. Gonzalez. Mr. McClatchy.
Aye.
Mr. Cummings. Mr. Manning.
Yes.
Mr. Lyons. Mr. Richards. Mr. Denoverger.
Aye.
Mr. Scotland. Mr. Monroe. Mr. Lee.
No.
Mr. Indarsingh.
No.
Ms. Amin.
No.
Mr. Ratiram.
No.
Mr. Ram.
No.
Mr. Paray.
No.
Mr. Paray. Mr. Rambali.
No.
Dr. Bodo.
No.
Mr. Hussain.
No.
Mr. Padara.
No.
Ms. Haynes.
No.
Mr. Tanku.
No.
Ms. Mohit. Dr. Ragbir.
No.
Dr. Sicharan. Madam Speaker, the result of the division is as follows. 20 members